Good morning, everyone. Welcome to the summit. Good morning, Daphne.
Good morning. How are you today, Russ?
It's all good. Shannon, welcome.
Hello, nice to see everyone again.
Beautiful day out there. Welcome to everybody streaming live on YouTube. It's great to have you join us as well. And how's everybody doing today?
I'm doing well. I'm excited for another jam-packed day of very interesting and informative presentations. We have another great lineup today to look forward to. And we have Adam Cordover, who will be kicking off with a keynote in just a couple minutes. So I'm looking forward to hearing from him, and he'll be talking about collaborative practice.
Yeah, I didn't add it up, but like 5 or 6 of today's programs are professionalism, one EDI. Is that right?
Yes, lots of opportunity to get your CPD hours as well for all of the lawyers joining us. I'm actually going to launch our first poll too, just to get an idea of who's in the audience today. Want to welcome everyone back who joined us yesterday and welcome anyone who is joining for the first time today. And we would love to know who you are.
Look at that. One, two, three, four, five. Wow. 5 professionalism hours. Full day of learning, right?
Yes, it's going to be a great day. Okay, so I'm just putting up our first poll here, like I said, just to get to know everyone in our audience here. So tell us a little bit about yourself. I'm a family lawyer. I'm a lawyer practicing in another field. I'm a mental health professional. I'll let everyone read it from there. But if your answer isn't up there, just let us know through the Q&A if you'd like, and you can send those in. You'll notice the chat has been disabled from the audience end, but you can send in any questions, comments you have through the Q&A.
And put in the Q&A what city you're from and where you're from. Lots of people are from Ontario, but we get lots of people from the United States and throughout the world. So share where you're coming in from, and we'd like to know who's joining us today. And I love these polls. If you participate in the polls throughout, it really helps the presenters tailor their presentation to the results and ask questions early. If you want your question answered, throw it in the Q&A box. Lots of times we'll get a pile of questions at the end, maybe 20 or 30 will come in and we just don't have the time to go through them all. So get your questions in early. We usually like to answer the questions when we're waiting on poll results. And Denise House, you want to talk about that for a few minutes, Shannon?
Yeah, so like I said, anyone who is new that's joining us today, just wanted to get everyone up to speed on a little brief of what we covered yesterday. In particular, just letting everyone know what our event will be supporting today. So our sponsors, CPO and Bridgepoint Financial, both have provided very generous sponsorship toward this event, which have been donated to the Denise House, which is a local shelter in the Durham region that provides a shelter and supportive programs for women with or without children experiencing gender-based violence. So we had Sandra McCormack, the executive director from the Denise House, join us yesterday to share a bit more about their programs. And we've also open it up to our audience if anyone else would like to, if you'd like to contribute to the new initiative that they're, so the donations will actually support a new shelter that they're building. So it's going to a really great cause to support our community. And we're very grateful again to our sponsors, but also to the generosity of so many of our audience members yesterday. So thank you so much. And if anyone would like to donate, we'll still have it open for the rest of the week and probably next as well.
Yeah, we had some questions about how to donate. We'll put a link in the chat box right now. It's really easy. You click the link, it goes to the GoFundMe page. You enter your name and your credit card details. You decide how much you want to donate. We've had, from $25 to $250 for individual donations. So whatever amount you think is appropriate, every little bit helps. If you want the name to show up on the GoFundMe page, or you can go anonymous, whatever you prefer, and they'll issue a tax receipt. So it's a win-win. All proceeds from today from the sponsors are going towards the Denise House, our goal is to raise $10,000. I think we're at about 6,500, so I'm optimistic we're going to hit that today. And it's a really great way to give back to the community in a really important cause. We're going to be talking about risk factors in family violence first thing this morning. So keep in tune for that. If you want to learn more about how you can help, this is one way you can do it. So thank you, everybody who's already contributed. If you're thinking about contributing, please do so. I think as a legal profession, we have an obligation to give back to our community. And this is a great way to service women who are in need and are victims of domestic or intimate partner violence and help them get them and their children and their pets into a safe place. So thank you again for considering that. And we'll give updates throughout the day as the fun. This is our little hourglass. I want to see it's going to be going up, and Daphne's going to be updating it regularly, right, Daphne?
That's right. I'll be updating it live. So I'm excited to see the donations coming in for such a great cause.
We still have people joining us, but so far we have 65% family lawyer, 21% lawyer practicing in another area. Lots of lawyers. Get your credits. You can get all your credits over this 2-day program, all 12 that you need for the Law Society. Mental health professional, law clerk. I love when the law clerks come in. Professional in another field, you can put that in a Q&A as well. So thank you for participating in that poll. And we've got a couple more housekeeping items, and I think we're going to make a start. What else you got for us, Shannon?
One thing that I just wanted to mention is that our colleague Nicole will be helping us behind the scenes. So if anyone does have any tech issues or any general questions or comments for us, I'm just putting her email in the chat here. So just maybe keep that on hand in case you need it at all, in case you have any issues. I will also note, I know that not everyone can stay for the full day or might want to come for some of the morning programs and log back on for the afternoon program. So I just want to let everyone know it will be one link for the whole day. So you can stay on it for the whole day if you'd like, or if you do need to pop in and out, the link, you can still use the same link that you logged on this morning and you'll be able to log back in.
So we've got lots of comments coming in. We have family mediators, Christina, mediator arbitrator, and Vaughn. Who else? We've got someone coming in from Harcourt, Ontario, southern tip of Algonquin Park. Welcome, everyone. It's great to find out where you're joining us from. So put that in the chat, and we'll share that with everybody.
All right, so I think that covers all the housekeeping. So I'd like to take a moment to introduce our keynote speaker, Adam Cordover. He will be coming on in just a moment for a presentation on all the ways to collaborate, examining different models of collaborative practice. Adam B. Cordover is a collaborative lawyer and Florida Supreme Court certified family law mediator. He is a member of the board of the International Academy of Collaborative Professionals, the IACP, as some of you may know it, and recipient of the inaugural Florida Academy of Collaborative Professionals, FACP. Visionary Award for founding and co-instructing the FACP Leadership Institute. He is co-author with Forrest Woody Mostyn of Building a Successful Collaborative Family Law Practice, published by the American Bar Association in 2018. Adam is a former president of Next Generation Divorce in Tampa Bay and Greater Sarasota, growing it to become the largest collaborative practice group in North America. In 2015, Adam stopped taking litigation cases and now practices exclusively in out-of-court dispute resolution. Adam is currently accepting family law matters from throughout the state of Florida and has offices in Tampa, St. Petersburg, and Sarasota. And I will drop Adam's website into the chat if you'd like to learn more. And on that note, I would love to pass things over to you, Adam, to get started with your presentation.
Welcome, Adam. Thank you for joining us today.
Thank you. Thank you so much, Russ. Thank you so much, Shannon, and everybody here at the summit. As Shannon just mentioned, I stopped taking litigation cases back in 2015. And just to put that in a little context, or as I like to say it, I retired from litigation at the ripe old age of 35 years old back in 2015. And I did this so that I could focus on peacemaking work, out of court dispute resolution, and really with a focus, a specialty on collaborative practice and collaborative family law. But one issue that I found is that I was limiting myself on the ways that I could offer collaborative practice to clients. And I was limiting the amount of clients that could access the form of collaborative practice that I was providing. And fortunately, there are some role models out there. Ron Oski, former president of the IACP, and one of the original collaborative practitioners, and also friend and mentor Woody Mostyn, who's the father of unbundled legal services. They all had a philosophy that rather than trying to push clients into one particular model of collaborative family law, we professionals have a duty to mold a model of collaborative family law to fit the needs of the clients that are in front of us. And I'll explain a little bit more what I mean by that and offer some different examples throughout this keynote presentation. So I think it's oftentimes helpful to really take a step back and determine what counts as a collaborative practice file. What are the requirements for it to be considered collaborative matter? Because I've learned, especially in working with newly trained professionals, that they have all different ideas. And really, when they think of collaborative practice, they're thinking of a particular model, but not the basics of what is essential, what are the requirements. There really are only 3 essential requirements for a case to be considered a collaborative practice file. Number 1, each person needs to have their own lawyer. Number 2, there needs to be a written participation agreement that lays out the rules of the case and of the way that they're going to proceed. And number 3, there needs to be a disqualification clause that says that in the event that the parties are unable to reach an agreement or otherwise that somebody files a contested pleading, that the lawyers and the other professionals are disqualified from continuing on in the case. So long as you have all 3 of those elements, it is a collaborative practice file. You can put a bunch of different things on top of that, but so long as those 3 main things are there, it's collaborative practice. If any of those 3 things are missing, then it is not a collaborative practice file by definition. So, I hear all the time, is somebody who is a lawyer, well, can I represent myself in a collaborative case? No, you need to have a separate independent lawyer for yourself, as does the other spouse, and have these other elements for it to be considered a collaborative practice matter. So I mentioned models before, and let's talk first with the original model. By the way, I consider myself a little bit of a daredevil, although there are times where I want to kind of She-Hulk out. But I think these are all great role models, if you will. But in the original model of collaborative practice, it was the lawyer-only model of collaborative practice. So this is where each person has their own lawyer. There's a written participation agreement and a disqualification clause, and no other professionals. Back in 1990, when Stu Webb, an attorney in Minneapolis, created the collaborative process, this was the model that he had in mind. And since then, every model that has come since has built on the lawyer-only model. And this is still a model that I use in my practice in certain cases. So for example, if it's a case where it's relatively simple and there are no children, it's a relatively short-term marriage and very few assets and debts, then I might consider doing a lawyer-only model of collaborative practice. Typically, I'll put in my participation agreement that if it's truly should be resolved in a lawyer-only model, we should be able to resolve things within 1 meeting or within 60 days. And if we can't resolve things within 1 meeting or within 60 days, then we may bring in another professional. But again, there are clients where this model makes sense, and that there are clients that can resolve their matters within 60 days or within one meeting. So that's a lawyer-only model of collaborative practice. The next model of collaborative practice is known as the two-coach model of collaborative practice. This was a model that was established out of California in the United States by Peggy Thompson and Pauline Tesler. Many of you may be familiar with those names. And in this model, the original interdisciplinary model of collaborative practice, each person has their own lawyer. Each person also has an aligned coach or licensed mental health professional. There is oftentimes a neutral financial professional, and many times there's a neutral child specialist. And the child specialist is there to bring on the voice of the children into the case. And so this is not the model that I was originally taught. And so it's not a model that is commonly used in my home state of Florida. But I have used this model of collaborative practice in circumstances that warranted it. And so I'll give an example. There was one case that I had where the husband retained me and he wanted to do things collaboratively. He mentioned that his wife was bipolar and had some issues, but even with that going on, he wanted to move forward in a collaborative manner. I sent over a letter which explained the collaborative process and gave the names of some collaborative attorneys. And about a week later, they were still living in the same house. She went through a bipolar manic episode, and she attempted to burn down the door of the bedroom that he was staying in. Now, it doesn't sound like that ought to be a collaborative case, right? And actually, that case I was litigating at the time. I filed a domestic violence injunction, and in the meantime, she actually ended up hiring one of the collaborative attorneys whom I recommended. And me and the other attorney talked, and we first said that we don't know if this can be a collaborative case. But if it is, it probably makes sense for there to be two separate coaches on the case, because given her condition, she probably would not recognize a neutral mental health professional as neutral. But again, we did not know whether this case could go collaborative. So we ended up sending her to a psychological evaluator, and this person was a psychologist. And the evaluator said that no, this can't be collaborative right now. But if there are some things that are put in place, then it could be. And he said, so long as she starts seeing a psychiatrist and starts getting medication and gets stable housing that is outside of the house, and confirm that yes, and so long as they're each agreed to have their own aligned coach, that yes, this could be a collaborative case. And so we started this case in pretty much a domestic violence court. Ultimately, the injunction was put in place, but with a provision that the clients could move forward in a collaborative process so long as these steps happened, and so long as those provisions were put in place. Those steps did happen, those provisions were put in place, and we did move forward in a two-coach model of collaborative practice. So we found a model where we needed more support than the typical model that we use, and we utilized that model. So let's go on to the next model of collaborative cases. This is actually the form that I was originally taught. I understand in many parts of Canada that this is the main model that is used as well. It's known as the one coach model, or neutral coach, or neutral facilitator, sometimes also known as the neutral mental health professional model. And in this model, each person has their own lawyer. There is a neutral coach, and oftentimes also a neutral financial professional, and in some cases and in some communities, a neutral child specialist. And this is kind of the basic model that we use. This is, I basically use this as a catch-all, a default model that if there aren't special circumstances that make sense for a different model, this is the model that I use. Okay. And by the way, this gentleman in here, that's Jeremy Gaze. He is my co-trainer and I consider one of the best mental health professionals / facilitators / coaches in the business. Okay, so let's talk about somewhat of a newer model of collaborative practice, which not a whole lot of people have heard of, but it's starting to gain some traction in some communities. It's known as collaborative mediation. And this is basically a combination of mediation practice and collaborative practice. And in this, each person, just like any other case, each person has their own lawyer. There's a written participation agreement that includes a disqualification clause, but there's also a fourth element to this as well, and that is there is one or more mediators who help in the process. And the mediator might be instead of all of the other neutrals that might be in the case, or all of the other professionals, or the mediator might be in addition to other professionals who may be in the case. And I find that there are certain cases where this makes sense. So for example, if a case originates from a mediator, oftentimes a mediator, or most mediators, let clients know that they ought to retain an attorney to review any agreements or possibly to participate in the mediation process. And mediators usually have an incentive to bring in collaborative lawyers because they know if that collaborative lawyers are trained to help parties reach an agreement outside of court, which is a different skill set than helping clients find a resolution within the court system. And if everybody signs a participation agreement that includes a disqualification clause, this makes the attorneys and the mediators and the clients all moving forward on the same page in trying to reach a resolution, and giving the clients the understanding that within the mediation process, that if they don't reach an agreement, that the attorneys will not be used against each other. So again, these are great for cases where the collaborative matter originates from a mediator, or where the clients would prefer to use a mediator who's not a mental health professional, because I think there are some communities that just have some bias against mental health professionals. I don't agree with that, but I also accept that that is the case. And so in those cases, a neutral mediator may be a good fit for that particular family. And one additional model of collaborative practice, and this was coined by Nancy Cameron, who is a friend and a mentor, and she discusses the Lego model of collaborative practice. And so again, this starts out the same way as every other case, that each person has their own lawyer. There's a written participation agreement that includes a disqualification clause, and the spouses retain really any other professional that may be helpful for the entire process or discrete tasks within the process. And let me provide some examples. It may be that the parents just want to bring in a child specialist for the limited purpose. If there's a troubled teen, for example, and they just want to have at least one meeting with the teen just to make sure they're okay, they may retain a child specialist for the limited purpose of that one meeting. Or maybe that they need to bring on a real estate professional to get a real estate appraisal, or some other works. Or I've had cases where we've needed to bring in an estate planning lawyer. That may be where the clients are older. They want to figure out what are the trusts and other documents that they may need to help fashion the particular agreement for them. Other cases may require a vocational evaluator, somebody to help determine what skill sets, what experience does somebody have, and what amount of money that they can make for purposes of determining an alimony amount. I've discussed psychological evaluator, and there are business valuations, substance abuse evaluators, all sorts of different building blocks that you need. And so my purpose, my hope with this keynote address is number one, to help you understand that there's not just one model of collaborative practice, but there are many models of collaborative practice. And it really is incumbent upon us to build the model of collaborative practice that makes sense for the family in front of us, rather than trying to push the clients into the model that we like or we are most comfortable with. And I hope, with all these different models, and learning that there's a lot of different ways to do out-of-court dispute resolution, one thing that I learned along the way, and it was really impactful to me, is that there are some people who like to litigate and want to litigate and really appreciate that. And I totally respect that. And that's just not me. And I personally don't like being in the litigation mode. So one thing I hope to let you all realize and recognize is that if you don't want to litigate, you don't have to. There are options. You just have to think about what are the different options that you're going to offer. And just so you know, as I mentioned, I stopped litigating in 2015, and my business has grown from there. And in the last 2 years, I basically doubled my revenue. So you don't have to litigate, and you can still be profitable. So I just want to mention as well, in some final points, you can find out more about the way that I view things, as well as my mentor and co-author, Woody Mostyn, Forrest Mostyn, in building a successful collaborative family law practice. I believe digital copies are still available at the American Bar Association website, and you can find the link in the PowerPoint, which I believe was provided to you. And here's my contact information. I've got offices in Tampa, St. Petersburg, and Sarasota, but I represent clients virtually throughout the state of Florida. So if you know somebody who could use our services in Florida, please, we'll take care of them. We invite you to send them our way. And so with that, Shannon, I just want to check to see if there are any questions or anything I can answer or help with.
All right, thank you so much, Adam. Again, we appreciate you being here so much and sharing your vast knowledge of collaborative practice. It's very much appreciated. I'm just gonna quickly have a look at the Q&A. I don't have any. Russ, did you have any questions or comments?
It's great seeing you again, Adam. It's been a while since the IACP, but I deeply appreciate all the work you've done for collaborative practice, the IACP, and also sharing your thoughts with our audience today. It's been fantastic.
Russ, thank you so much. I'm so impressed with the summit that you and your team have put together, and for such a great cause. So, so excellent, and it was an honor.
Thank you so much.
Thank you,
And
Adam.
just on that note, we do have some collaborative practice training coming up. Is that right, Shannon?
Yes, so Russ, as well as a few of our summit speakers, Brian Galbraith, Jonathan Paynter, and Carrie Heinzel, will be hosting collaborative practice training this fall. So I believe the first date is October 21st, and I will drop the link in the chat if anyone is interested in participating in that. All the information will be there. And we are offering a $10 discount code for our attendees. So I'll put that in the chat as well.
10%.
Yes. What did I say?
$10.
Oh, 10%.
A little bit more than $10, but
I told you, Russ, I haven't had a chance to have my coffee yet. So
I know.
I better do that at break.
We did have some people sign up yesterday. The discount code is open to the end of the week, and we have some more spots. So if you want to become collaboratively trained, that's a great opportunity to do so. It's remote, and it's done over a number of weeks. So it's traditionally you'd come into a hotel somewhere 3 to 5 days, and you'd have to take the whole week off in person and get a hotel. But now you can do it remotely. We've broken it up over a number of weeks, so this only takes an afternoon or two of your time each week, and then you can get fully trained. So thank you for sharing that, Shannon. And on that coffee note, should we give everybody a quick health break, and then we're back at 9:30, or is there any more housekeeping we want to do?
No, that's great. We'll be back on, or Daphne will be back on to introduce our next set of speakers at 9:30. So if anyone else needs coffee like I do, here's your chance.
We'll see everybody back here at 9:30. Thank you, Shannon.
Good morning, everyone.
Good morning, Daphne. It's nice to see you.
You
Good
too.
morning.
Excited for another day of the summit. Good morning, Jonathan. Morning, Amrit.
Good morning.
I love the energy this morning, and I love the keynote. I was able to hear a bit of the end of it as I was logging in.
Excellent. Yeah, I'm looking forward to this presentation as well. It ties in nicely with the cause for the summit this year. So risk factors in family violence. So I'll go ahead and introduce our speakers. So let's start off with Michelle Mulchan. Michelle is the senior managing lawyer at Russell Alexander Collaborative Family Lawyers. She's been practicing family law for over 14 years, specializing in divorce, custody access, property division, child and spousal support, and family responsibility office enforcement matters. Her focus is on creating comprehensive, creative resolutions to family law matters, and Michelle excels at helping clients deal with complex financial issues that arise as a result of a separation. So welcome, Michelle. Great to see you again for day 2. And returning again, we have Jonathan. Good morning, Jonathan. Jonathan is a registered social worker, accredited family mediator, and psychotherapist who works in the family law system, completing parenting plan assessments, voice of the child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, and couples counseling for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of Collaborative Practice Durham Region. We are also joined by Amrit. Good morning. Amrit Malhotra holds a Master of Social Work degree from the University of Toronto and practices as a registered social worker specializing in fertility and third-party reproduction, healthcare, trauma, grief, and loss. She's also an accredited family mediator with the Ontario Association for Family Mediation and is a collaborative practice family professional. Amrit is a board member with the collaborative practice Hamilton Fulton. She's a co-chair of the Counseling Special Interest Group at the Canadian Fertility Andrology Society. And in addition, she provides individual and couple counseling in her private practice and is the president of Invicta Counseling. Wow. This really is the dream team. I'm so looking forward to your presentation. And without further ado, I will just pass the floor over to you to get started. So thanks so much.
Thank you so much, Daphne. This is great. I won't have to do any work with these 2 professionals here today. As you said, they really are the dream team. So why don't we start off with a poll, just so we can get to know our audience and maybe tailor a little bit of information. So our first poll is just tell us a little bit about yourself. Are you a family lawyer? Are you a lawyer practicing in another area of law? Are you a mental health professional? Are you a law clerk, a student? Or maybe you're actually going through this process yourself or have someone who is a loved one going through this process. So as we're just waiting for that poll to go up and go ahead and answer it while you have some time, why don't I just jump into the first topic, which is understanding the importance of risk factors in family law. And Jonathan, why don't I throw it over to you to start that with just a brief overview of domestic and family violence in Ontario?
Sure, yeah. So I think it's really important first to say that everybody should be donating to Denise House. I just sent in a donation, one for every day that I've been presenting at the summit. I did a donation for yesterday as well. So I would encourage all the audience members to donate as well and help that great cause. So it's really important as family law professionals, no matter what profession you're in, to know at least the basics about family violence, because it's something that will always come up in your work. It's really unavoidable, and a lot of family law cases have this as an element of them, and obviously most of the more difficult and more challenging cases definitely have family violence issues in them. So a few statistics. Family violence is very common, unfortunately, in Canada. In 2019, for example, about 22,300 kids were victims of family violence. And most of those victims were female, 60%, 40% were boys. Most were victimized by a parent. but other family members also contributed. People like siblings, step-parents, aunts, uncles, cousins, that kind of thing. Most were parents, though. Family violence is much, much more common in rural areas than urban areas. It's actually almost double the rate. There are 652 cases per 100,000 in the country in rural areas, and 325 per 100,000 in urban areas. So we see a big divide there. Now, keep in mind, most people live in cities, so it's still very, very common in cities. In 2019 as well, about 108,000 people who are adults experienced intimate partner violence. About 80% of them were women, and women were almost 4 times more likely to be victimized than men. And women were much, much more likely to experience severe violence, much more likely to be murdered or, assaulted to the point of bodily injuries than men were. Indigenous women were much more likely to be experiencing family violence compared to non-Indigenous women. The split there was about 61% of Indigenous women will experience it sometime in their life, whereas non-Indigenous, it's about 44%. So you can see that that's the difference. And LGBTQ2S+ families are much, much more likely to experience family violence. About 67% of women who are identify as LGBTQ experienced intimate partner violence, compared to 44% of straight women. So we can see that unfortunately, family violence is still continuing. It's still a big issue in Canada. We are one of the safest countries in the world, but we still have this major problem that needs to be addressed on all levels. We need the government to deal with it. We need the frontline people like us to do it. We need, the public to work on it, and everybody kind of rowing in the same direction to try and prevent this from impacting the lives. And we know that it's very, very harmful for people to experience this. It causes a wide range of mental and physical health problems, and it's extremely damaging to children and can really negatively impact their long-term development. So unfortunately, these statistics are not very cheery, but it's important for family law professionals to know this information so that when you're walking into a case where this is an issue, you have the tools that you need to be able to manage that. And speaking of that, Michelle, I was wondering if you could speak a little bit about what you feel is the lawyer's role in knowing about and identifying and screening for family violence.
Thanks so much, Jonathan. Yeah, it's incredibly sobering to think about it and to realize the privilege we have and the responsibility, right? It's like Spider-Man. With great power comes great responsibility. And that's what we're here to impart on everyone today. So just before we do that, why don't we see the results of our poll, just so we can moderate our conversation just a little bit. Excellent. So 68% of us are family lawyers. 21% of us are lawyers practicing in a different area of law. We've got 9% of law clerks, and we've got professionals in another field at 7%. And we have a couple mental health professionals. So welcome, everyone. Thanks so much. So I absolutely think that the lawyer's job is incredibly important. It's very sobering, but we see these cases every single day at our firm. There really isn't a day that goes by that we don't see these cases. And often we are the front line. We're the first person that person is going to get help and assistance. And so it's really important for us to have these resources and have them front and center. I'm a big advocate. I'm very technologically advanced, but I also like the old school ways. So I actually have binders on my desk still, and they're color coded. And I have some of these things printed and in front of me because, I don't know about you, Jonathan and Amrit, but I've had cases where in my very first consultation, I had a case where a woman was imprisoned in her house when she was able to do that call with me. So it wasn't one of those situations where I could say, hey, wait a second, give me 10 minutes so I can go find my data and my sheets and all of my resources. You have to have it at the ready. I had another one where it was, in this case, the husband who was being physically abused by the wife. And of course, the children were hearing the verbal abuse. And, you have to be able to get out of your gender roles, get out of your stereotypes, and really assist the client you have in front of you. I've unfortunately also had the client who is the aggressor as well, and giving them those resources is really important. So I think that, we need to screen, and we need to screen constantly. So that very first call, you should be screening. We should also be screening as you go. And there are a number of reasons for this. First of all, I don't know about you both, but when I first meet someone for the first time, I'm not exactly going to share with them my deepest, darkest fears and all of these horrible things that are going on with me. You need time to build that connection, to feel safe, to feel comfortable. They need to know that you are a safe resource, that you are non-judgmental. A lot of times you hear people say things like, well, why did you stay for so long if it was so bad? That's not helpful. That's judgmental, and that means that person doesn't feel safe to open up to you. You have to understand that these people are coming to you for help, and it's your responsibility to help them. So, we do the screening early, we do it often, and anytime we fear that there might be something going on, we try to have a very open and honest conversation with our clients to say, hey, this is, can you tell me a little bit about this? Have you ever experienced this? And sometimes people don't realize the impact of what their partner is doing to them is family violence, right? And sometimes it's your job to educate.
Yeah, that's a good point.
Which is really scary. Go ahead, Jonathan.
No, I was just going to say, you're absolutely right that a lot of people who are experiencing this don't self-identify as victims of violence or abuse. And so when you're doing your screening, it's really important to ask about behaviors, like what have you seen, as opposed to saying, does your ex-partner or did your ex-partner abuse you? That's not the right question, because they might not identify it as abuse, and B, abuse can mean a really wide range of behaviors, and we don't know specifically what that means. So I would ask more, and I'll talk a little bit more later on about some screening tools I use. But you ask more about the behaviors. Has your partner ever hit you or threatened you, or held you in a room against your will, or those kinds of specific behaviors to get to the bottom of whether or not there is abuse and violence in the family or not.
Thanks so much, Jonathan. Okay, so that actually leads us really nicely into our next topic, which is the definition and scope of domestic violence and family law. So the definition, so we're just going to talk about the Divorce Act because it's the kind of all-encompassing one, and it's really great and multifaceted. So for those of you who don't know, in 2021, the Divorce Act got a little bit of a facelift, and we got a lot of new terminology, a lot of updates to it. But one of the really important ones was this addition of family violence and the definition of family violence. So I'm not going to go through the whole definition. It'll be in the show notes at the end of the day. But very kind of high level, it means any conduct, whether or not it constitutes a criminal offense. That's really important, right? It does not need to be a criminal offense for it to be family violence by one family member against the other. So that's also important too, right? It doesn't need to be husband versus wife. It could be wife versus husband. There could be children involved as well. That constitutes a pattern of coercive or controlling behavior and causes the other family member to fear for their own safety or that of another person. And it could include things like physical abuse, sexual abuse, threats to kill or cause bodily harm, harassment, stalking, the failure to provide the necessaries of life, psychological abuse, financial abuse, even threats to harm or kill an animal or to damage property, or the act of harming or killing an animal. And the way that the Divorce Act is framed, it really defines family violence in the context of the best interest of the child. And this is really important because we have seen the impact on children when they grow up in a situation where there is family violence. And as I said before, you don't have to rise to the level of a criminal offense. So you don't need to meet that burden of, the proof beyond a reasonable doubt to be considered family violence. So for instance, I have a case right now where the husband there was a trial, and unfortunately he was not convicted criminally, but that still doesn't mean that, that there wasn't family violence in that case. And that's really important to know. So Amrit, I think,
sometimes goes to the difference in the standards of evidence for criminal cases versus family cases, right? Where the standard of evidence for family law is much lower than criminal law.
Oh, absolutely. I've had a case where one party kept threatening to kill the puppy. And even though it didn't happen, that was the constant threat, the family dog, the dog that the children and the other parent loved desperately. That was the threat, that if you don't behave, one day that dog is not going to be here anymore. And even though it never happened, so it's not it didn't rise to the level of a criminal charge, it was considered in the family court, which was really important. So sorry, Amrit, would you like to talk a little bit about the forms of violence?
Sure. I mean, you've mentioned some of them with the forms of that could be physical or emotional, psychological, sexual, financial, or it could be in the form of litigation, where someone is repetitively brought to court on matters that are just going to create a lot of bills and a lot of hardship, and it can be really taxing on others. So this is hard work. I just want to say that even as the professionals in dealing with all of these things, it is really challenging, and it's important to consult if it's an area that you've never practiced in before and it's the first time that you're seeing it. It's always a good idea to consult with another professional who may have a little more experience in this so that we can best serve the clients. It can affect the whole family, and as a result, we have to ensure that the safety of the clients that we're working with and the children, that's super important. So yeah, I wanted to share that.
And just to add on to what you were saying, Amrit, there are different reasons why family violence happens in these cases, and kind of researchers have sort of come up with three broad categories of reasons why. One would be what's called coercive control, and that's where the violence is committed by mostly one person, and that person has a pattern of coercive control over the other person. So that might be threats and intimidations, it might be financial control, it might be limiting their access to family members, it might be abusing the family pet in front of them, it might be manipulating the children against them. So it's a broad pattern of abuse and control, and those are the most concerning cases. There's also something called situational violence, where let's say a couple go to a party and they have a few too many drinks, and they come home and they get into a fight while intoxicated, and one person pushes the other person and they fall backwards and break the coffee table. But that's not a pattern of violence against one of the couple. It's sort of mutual violence that happens in very rare situations. And it's still very concerning. It can still be very dangerous and harmful for both the people involved in the violence and the children in the home, but it's not the same kind of pattern. It's not the same kind of severity. And so it has to be handled in a different way. And then another type of violence is violent resistance. Sometimes what you'll see is one of the people that's the quote unquote victim of the violence was actually the aggressor, and the real victim kind of fought back and defended themselves, and in the process might have maimed or injured the other person. So that those cases are usually in the more severe family violence cases where the victim of the coercive control behavior is really fearful that they're about to die or get really seriously injured, and so they act to defend themselves in a way that involves using violence. So those are sort of three broad ways of kind of categorizing some of the reasons behind the violence. And then, another thing to look at is what are the main risk factors for violence. And there are kind of broad categories of them. So individual factors, there might be relationship factors, there might be community and societal factors. So some of the individual factors might be if someone has a history of violence. So maybe they were violent in school and they got suspended for violent behavior towards their peers, or maybe they've had a violent incident at work, or they've been violent with other people at a bar, say. So there is a history of violence in different settings, and that really raises the risk that they're going to be violent at home as well. One of the biggest risk factors is substance use. So it doesn't really matter what substance they're using, any mood altering substance. So alcohol, cocaine, cannabis, heroin, speed, whatever drug of choice that they're using greatly increases the risk of violence. And one of the reasons for that is because our brain is very susceptible to these substances. And when we're using them, that actually turns off our thinking brain, our prefrontal cortex, which is the part of our brain that is used to control the emotional part of our brain. And when we don't have that control, or when that control's lessened, the kind of inner tiger can come out, and you can really get into trouble with that. So you just don't have the ability to manage your mood and your emotions as well when you've been using substances. Mental health issues can be a factor as well. So personality disorders are a very, very significant risk factor. If someone has a personality disorder, they're much more likely to be a violent person towards their family. And sometimes other mental health conditions can contribute too, like depression, anxiety, bipolar disorder, those kinds of things. But keep in mind that just because someone has, depression or anxiety doesn't mean that they're violent. A lot of people are able to manage their symptoms, or maybe their symptoms for depression are withdrawing and not being angry and aggressive. So it's not enough just to have a person, a depression or anxiety to be violent, but it is one of the factors we look at. Demographics might.
Sorry, Jonathan, if I could
Yeah,
just jump
please,
in
Emma.
there for just a minute. Just from the perspective of mental health, I really like that you emphasize that it doesn't mean that just because someone is experiencing depression or anxiety that they're necessarily going to experience a violent episode or anything like that. But mental health does impact our emotional, psychological, and social well-being. And it does affect how we think and how we feel and how we act. And it also determines how we manage our stress and how we relate to others and make healthy choices. So it is an important part of the intake to get that information, to ensure that there are some supports in place to assist if there are mental health issues.
100%. And sometimes I think that's an excellent point, Amrit. And sometimes the mental health can be a symptom of other problems. So, for example, a lot of abusive, coercive control people use threats of suicide to get what they want out of their partner. And so is that a genuine mental health? Are they genuinely suicidal, or are they just using it as a tool to manipulate their partner? So yeah, I think that those are very good points, Emma. Thanks for adding that. Other factors include demographics. So your age, younger people are more likely to be violent than older people. Gender. So if you are LGBTQ, you're more at risk. straight people, and women we know are much more higher risk than men. Transgendered people are particularly at risk of violence, of being victims of violence. And socioeconomic status can influence risk factors as well. And the reason for that is because one of the overall risk factors for families is stress. And if you're living in poverty, you're going to be more stressed, and more stress can sometimes contribute to people being violent in their homes as well. And then there's relationship factors. So this is kind of unique to that couple. So you want to look at the power imbalances. How are decisions made? Who makes decisions? Who's kind of in control in the family? Those would be important things to look at. If there's a history of conflict in the family, that will be an important risk factor. If one or both of the parties are jealous and possessive of the other person, or have very strong views about gender roles. So if people who have very strict gender roles beliefs tend to be, on average, more violent than people who believe more in equality between men and women, for example. And actually, the presence of children can be an important risk factor, especially the more children there are, the greater the risk. And if there's stepchildren, that also increases the risk. And then generally, sort of more societal factors might be, the overall health of our society. So if we're going through, for example, a recession or a depression, and that's really going to increase the stress of families and increase the risk that there is violence. The sociocultural attitudes towards violence are also really important. Like if a group of people believe that it's a person's right to be violent with their family, then that will increase the risk that it will happen. And then there's also more cultural issues where people from Indigenous communities or Black communities are discriminated against, and maybe they don't have the same access to services, or maybe they're not being believed by their therapist or their police officers who are responding, or teachers or whatever. So those are all risk factors. And the last one I will say is accessibility to weapons. So we know that having easy access to either a knife or even worse, a gun can greatly increase the risk of really severe violence and even death and murder. So that's definitely one of the screening questions we always ask is, are there weapons in the home? Are they properly stored? This is exactly why we have our gun laws in Canada, where you have to store the gun locked and separate from the ammunition, because that prevents a lot of crimes of passion where someone grabs for a loaded gun during an argument and fires it off. So it's really, really important to make sure that you're asking about weapons in the home, especially in the areas that I work in, which are more rural. And it's much more common for people in my area to have guns than people in the city. Anything you want to add there, Amrit?
Yeah, no, I think it's excellent that you spoke about the accessibility. I think when you're working with newcomers or refugees that are coming, they may not have access to the funds or be aware of the resources that are available. So it is really important to note that the statistics are not higher in those communities necessarily for violence, but not having access to not having access to resources is really an important factor. There may be language barriers as well. So yeah. And the stricter changing gender roles when they arrive in a new country, and maybe even the trauma that they come with because of their immigrant experience or their refugee experience, that's important as well. So having a trauma-informed approach when we're working with these clients may be very important.
Really important, and all the more reason to support places like Denise House, because they do provide services in a lot of different languages, and are able to connect their clients with resources that are relevant to their cultural or language group. So please, everybody, make sure you support Denise House, because it's a great cause, or a similar service in your region. What about you, Michelle? Anything that you want to add? Like, what are the risk factors you see a lot in your practice?
Yeah, I think you guys have done such an amazing job covering them. I think what it's important to realize for family lawyers is to do that deep dive and understand the dynamics, the cultural, social backgrounds of your particular couple, so that you can be ready. And, we're going to talk about safety planning coming up. Knowing these factors and these risk factors, and knowing where your client may or may not be at a higher risk in some of these areas is important. So for instance, knowing if there are guns in the house will affect my safety planning to my clients and how I do that. So that's really great. Jonathan, I don't know if you could tell, but I was furiously typing as you were both chatting there, because it's great to have the refresher. And again, it's great to add, as I advocate to everyone, have that binder, have that resource, kind of have it in your own words too, right? It's one thing to have these show notes, they're wonderful, but having it in your own words and your own notes is really impactful, and you're more likely to remember them if you're making your own notes as this goes along. All right, why don't we go into our next poll? So whose responsibility do you guys think it is to screen for family violence? The lawyer, the family professional, the financial professional, other, so therapists, shelter workers, etc., or all of the above? Oh, and I see, Jonathan, thank you so much. You are putting in tons of links into the chat there. I really appreciate it.
I think Daphne will make sure that those are added to the show notes later, so that as I know a lot of the questions in our Q&A section are about getting resources from this presentation. So sounds like there's a real need out there for more information. So that's great.
Thanks so much. Yes, that's thank you so much for the chat. I see it's wonderful, and there's lots of questions. We have over 100 pages of resources, so don't you worry, you're going to get inundated with this stuff soon. Okay, so let's see
print them all out and color code them like Michelle does.
There you go.
Have them in a binder.
All right, so 9% think it's the lawyer's job, 1% think it's a family professional's job, 2% of you think it's the other or therapist's job, and 87% think it's all of the above. All right, Jonathan, what do you think?
Yeah, I definitely think it's all of the above. Now, mental health professionals and family professionals do tend to have more specialized training in that kind of thing, or if you've done a course on family mediation or family arbitration, or parenting coordination, those courses always come with a heavy dose of family violence training as well. And actually, this is an interesting question, Michelle. How much do you learn about it in law school? Is it an optional course? Does everybody have to learn about it? What's the scenario there?
Well, I don't want to tell you my age, but I'm a bit of a dinosaur. I went to law school.
Well, you can't be as old as me, so.
I think we're probably the same age, Jonathan. I went to law school 15 years ago. So at that time,
we are not the same age.
Oh. You're so young at heart. I see you all the time. But 15 years ago, there wasn't this kind of this knowledge base and this movement to really incorporate domestic violence. Obviously, it was always a topic, and it was kind of the underlying of what we were taught in law school, but we never actually had any courses on it. I think it really wasn't until about maybe 7 years ago that it got a bit more mainstream. And now, especially with the changes to the Divorce Act that requires lawyers to think about these things, that we're getting all of these resources from the legal perspective. And I think it's really wonderful. I also think there's been more funding. I think that COVID had a big impact. So when you're talking about those, economic factors, I think that COVID really brought to light the prevalence of domestic violence, and there had to be some really interesting and unique ways that we safety planned with our clients. And I think it's great that we are seeing a lot more courses come out, and there's just a lot more in the media. I think that Kara's law came into effect not so long ago.
I was going to mention that. Yeah.
Yes. No, that's I'm not going to spoil it. It's so important.
No.
I met Jennifer.
No, it's good. It's yeah. So that's a law where judges now have to get training on family violence, right?
Exactly. Yeah. So I'll let you. I won't spoil it because it is such a wonderful. I did an 1.5 hour course with Jennifer, and it was so impactful. There was not a dry eye in that course. Let me tell you.
Yeah. It's a heavy topic. I think, and I'm sure both of you would agree with me that it's every professional's responsibility to screen for this. You can't get into family law without having to touch this at some point. It's impossible. So make sure you get the training if you haven't had it. If you haven't had the training and you're waiting to get it, then bring in another professional who can support you and give you advice. Or sometimes I'll do screenings for other professionals. For our family arbitrators, they're legally required to do a family violence screening. So sometimes they'll call me to ask me to do that screening for them, or someone like Amrit as well. But yeah, it's everybody's responsibility, and it's really important that we don't make assumptions about who's a victim of this. A lot of people assume it's exclusively for families who are in lower socioeconomic status, or certain cultural groups or certain language groups or whatever, but none of that's true. Family violence affects everybody. Unfortunately, it doesn't matter what socioeconomic status you have. It doesn't matter what cultural group you're from or language group, whatever. So it's really, really important that every family that comes through your door, you're kind of screening them, because if you make assumptions about who is and who is not going to be a victim, then you might not be asking the right questions for your client. And let's keep in mind that working in these cases can be deadly. There are cases where partners have murdered each other, and so it's really, really important that we all work together to prevent those kinds of situations from happening. And that's why this kind of training is so important for all family professionals, all legal professionals, all financial professionals. It doesn't necessarily mean that, say you're doing a collaborative family case, it doesn't necessarily mean the lawyer is going to take the lead on managing the issues of family violence, but they're still asking the right questions, because they may be getting information from the client that other professionals aren't. And we all have to work towards, protecting those clients as a team. So I think, screening is important across the board.
Yeah, and communication is key, right? It's important if you're in a setting that everyone is aware of the violence, and so that we can make decisions in that realm and in that lens. Okay. Thanks so much for that, both of you. That was wonderful. Why don't we move on to the impact of domestic violence on children and the risk factors for exposure. So Jonathan and Amrit, you guys did a great job of kind of talking about some stats and some, the factors, but kind of focusing on children. Jonathan, you brought this up, but I want to highlight it, that research shows that people who engage in intimate partner violence are significantly more likely to abuse their children. And I think that is the importance of Kara's law, that we need to understand this. It doesn't mean everyone is going to. It's just something that we have to keep in the back of our mind when we're making these decisions, these really big decisions about who should be having decision-making for the children. What should the parenting time look like? Should there be supervision? Is there a gradual increase in parenting time if there hasn't been some? Why children may be wary of going to one parent versus the other. All really important factors as lawyers that we need to understand. And oftentimes, intimate partner violence continues even after separation. So physical abuse, psychological abuse, stalking, harassment, all continues at a significant rate after separation and actually can be increased. So I always tell my clients that those first couple weeks after separation are the most crucial, because those are the weeks that things are statistically more likely to increase. And we want to make sure that if I'm the first point of contact, I understand that and I'm aware of that so that I can coach my clients, because they don't know this. This is my job. It's my job to educate them and to let them know. So
risk factors for kids is, I think, where you're heading in that.
Exactly. Yeah. Risk factors for kids during that.
Yeah. So it's going back to what you said earlier, where people that are abusive to their partners are much more likely to be abusive to their kids. That is true. But it's also true that it's just as harmful for a kid to witness abuse as it is to become a victim of abuse. And there's a lot of complex reasons for that. The main one is that kids, especially younger kids, are utterly dependent on their parents for survival. And in order to get through their childhood, they become very attuned to their parents' mood. If their parent is anxious, they're anxious. If their parent's upset, they're upset. If their parent's angry, they're angry. Because we know that emotions are infectious. And so if you have a child who's witnessing abuse of their parent, the person that is there to keep them alive, then they're going to feel very terrified, just as, and the impact is just as serious as if they were being abused themselves. And this comes, there's a huge and growing body of research called adverse childhood experiences, where we look at what is the impact of these experiences on children later in life. And what originally this study was started by doctors, because what they were noticing was that people are coming into their clinic with these medical concerns. They'd treat the medical concerns, but the medical concerns wouldn't go away. They'd stay around. It didn't matter what the clinic did to treat those medical problems. They use all the proper treatments for them, but they weren't recovering. And what they found was that there was a whole other layer of complexity to these clients, in that they had all been victims of violence as children. And this was negatively impacting their physical health later on in life. So we know now a lot more detail about how and why adverse childhood experiences negatively impacts children's development. And it all has to do with hormones. So there's certain hormones that children release when they're stressed that actually negatively impact their development. There's also something called epigenetics, where parents can pass down traits and tell their children's genes what to turn on and what genes to turn off. And so if a parent's experiencing abuse, they can pass things like anxiety, depression, and other mental health conditions on to their children, just within 1 or 2 generations. There's also something called intergenerational trauma, where if your grandparent or great-grandparent experienced some kind of trauma in their life that negatively impacted them, it can actually cause you to experience a lot of mental health and physical health problems in your life, even if you've never had any traumatic experiences in your life. So we know, for example, that kids who have 4 or more adverse childhood experiences in their life are something like 3,000% more likely to attempt suicide as an adult. They're twice as likely to develop heart disease or strokes. They're twice as likely to develop diabetes. And they're much more likely to experience depression, anxiety, bipolar disorder, schizophrenia, all those very serious mental health conditions. And this effect lasts their whole life, and it actually impacts the length of their life, and they tend to live less years and with more health problems than people who didn't experience those traumatic events in their childhood. So we know it's really, really harmful for children, and it really negatively impacts their development. And for adults, it also contributes to all kinds of major problems. We know that stress is one of the worst things for our bodies. It's just as bad as smoking a couple of packs of cigarettes a day. And if you're living in an abusive relationship, you're feeling that stress every day, all day, all night and never goes away, and that can be really, really harmful on your body. There's this concept called allopathic load, which is kind of the amount of stress and harm that your body can absorb and your mind can absorb in a lifetime. And the more negative experiences you have, the lower your lifespan, because that allopathic load goes up, the more trauma you experience in your life. The bad news is that there's a lot of negative effects, but I do think it's also important to note that there are a lot of protective factors as well. There's this whole new body of research that I find fascinating called positive childhood experiences. And they're the opposite of negative or adverse childhood experiences. And they actually have a very protective role to play in children's lives. And they can not just undo the damage caused by trauma and abuse, but they can actually improve a child's life beyond that. So they have a very powerful role. So some of those protective factors might include things like having an adult that you really trust, like a coach or a sibling or an aunt or uncle or someone who's, it might be someone involved in your church or a teacher, someone important in your life who has a positive relationship with you. That positive relationship can have a very, very protective effect on you. And so we know that there are ways of counteracting the negativity from abuse and family violence as well.
That's so
Amrit, did you
interesting.
have anything you wanted to add to that?
I think you just said it beautifully, Jonathan. It's so critical, like the childhood experiences, because it affects future life, and having those positive role models in your life can be really beneficial. And like even if the kids are engaged in sports and other things, like or having a teacher that's really involved, and even what happens post separation and the supports that are put in place can really be valuable for the children. Being resilient and being able to build on some of those strengths, I think, is super important.
Yeah, that was really
Yeah,
interesting. I hadn't heard about, I mean, obviously we all, conceptually understand that positive childhood experiences will positively affect children, but the data and the research behind it is so interesting. I may have to have you guys back just to talk about that one day. That could be a whole hour in and of itself, because the flip side to our job is also coaching our clients in how to create better situations for themselves and help their children and help their family, so that there isn't this intergenerational trauma, and that what's going on now isn't going to be impacting them for years and generations to come. So thank you both. Just before we move on to the next topic, I really quickly want to talk about the duty to report. So it is so important. Sorry, do either of you want to chat about this? No? Okay, sorry. I saw you both. You got so excited for it. I didn't want to take it away from you. But the duty to report. We as lawyers and lots of other professionals have a duty and a positive obligation to report if we think that there are situations that would be harmful to another party, to a child. And it could be your client who is facing it, or it could be your client who is the aggressor. And I unfortunately have had to do this. I've had to report once where it was my client who was the aggressor, and they made a comment, and I knew there were guns in the home. And I immediately went into safety planning, not for my client, but safety planning for the other party, right? And it's so important that you understand that you do have a positive obligation to report. You can't just sit back. You need to be active. And it's not just family lawyers. We all have this positive obligation. Teachers have it. I'm sure in both of your professions, there is an obligation. Is that correct?
Absolutely. Yeah, it's very important to know about the duty to report. In fact, with any client that I see, there is an agreement that we sign right from the beginning where they're told about the limits to confidentiality, and that if they tell me that there's a chance of harm to themselves or others, or there's a child that could be at risk, I need to report. I have to report. There's no choice. And even if a client is like super, super frightened about, well, what does this mean? I mean, now he or she is going to be more aggressive as a result of this. I mean, the children's aid societies are aware of how to approach these matters and they deal with it in a delicate fashion, but we absolutely have to report when there's any domestic violence. Because the children are witnessing whether they were impacted physically or not, they're witnessing it and it's impacting them based on what Jonathan has shared. These are adverse childhood experiences. So.
Thank you so much. That's wonderful. Okay, why don't we go into our next poll now? So what are signs you can look for to determine if there is domestic violence taking place? So A, partners talking for them. B, if they have a difficult time making decisions without their partner. C, physical signs. D, financial issues. And E, all of the above. All right, so just while we're talking about that, why don't we start in a little bit with behavioral and physical signs to look for in clients. And I think, Jonathan, you were going to start talking about that. Is that correct?
Yeah, so I'm going to talk a little bit more broadly about screening in general. So when we screen, we want to, it's really hard to say if you see this, it means that, because it could mean one thing, it could mean another. People are very complex. We engage in very complex behaviors. And so you might see the same behavior for different reasons. So I'll give you an example. Someone might be cagey and not make eye contact and be fidgeting when you're asking questions about this. What does that mean? Well, it could mean that they're just anxious. Maybe they're intimidated by lawyers or social workers or whatever. It could mean that they're hiding something, that maybe they're the abuser and they're feeling anxious about asking these questions. It could be they're a victim and they don't feel like they can confide in you. So it's important to note that not one sign means exactly this. It's a constellation. You're looking at a pattern and you're looking at both, physical, behavioral, but most importantly, you're going to ask the right questions. And do the right kind of screening. And there's two broad types of tools that are used to do screening. One are called guided questionnaires, and those would be things like the MASIC, the Dove, or the RIA, which is a homegrown one provided by the Barbara Schleifer Clinic. And then there's others called actuarial assessments. And anybody who's a numbers person will know what that means. And actuarial means you're looking at statistics. What's the statistical likelihood of a behavior or any kind of thing happening again? So insurance people love actuarial assessments because it tells you what kind of interest rate or what kind of insurance rate you're charging your clients. But it's also used a lot in policing and corrections and risk assessment. So there is a homegrown risk assessment tool that's used by police and shelter workers, hospitals, that kind of thing. It's called the ODERA, the Ontario Domestic Assault Risk Assessment. And when you do that assessment on a client, you actually get a percentage chance that this is going to happen again. So you're looking at the percentage risk of the person being a victim of violence again. And so they look at statistical factors. And there's two types of statistical factors. There's dynamic. Those are ones that change over time, like whether a person's been drinking that day or not is something that might change day to day. And then there's static factors. And those are usually things that have happened in the past that aren't going to change. So for example, if someone is convicted of assaulting someone, that conviction is a static factor, that they're not going to make that conviction go away. Even with a pardon, that conviction still happened. So ODERA looks at a mix of those factors and will give you a statistical likelihood. This is 24% likely to happen again, or 67%, or 80%. It's never going to be 100% because people are complex beings and they're never 100% predictable, and it won't tell you when this is going to happen. It's just saying this is very likely to happen again. And that's the ODERA is a great tool because it takes very little training to learn. I have done the training and I'm a certified ODERA user. The training, I think took a day, maybe 4 or 5 hours. But the intention is that it's an easy to use tool that you can use very quickly with your client. So, for example, if you've already done like a full intake and screening, and your client calls you up and say, "Hey, something really bad happened this weekend at the house between me and my ex. A, B, and C happened, and I'm really worried it's going to happen again." You use the ODERA questionnaire, and you're going to be able to tell the client, "Yeah, this is likely to happen again," or let's do some safety planning. I don't think it's going to happen again, but we want to be cautious just in case. There's all kinds of other actuarial assessments that will give you a percentage likelihood. There's the SORAG, which is similar to the ODERA, but it's a bit of a longer questionnaire. I can't remember what it stands for. Something about the risk assessment guide, but I can't remember what the SO stands for. There's the VRAG, which looks at the VRAG looks at violence, and the SORAG looks at sexual violence. So there's different questionnaires that can get at different specific topics that you want to screen for. For me, I like the MASIC and the Dove and the RIA, which there'll be links for all those screening tools in the show notes. They're all free. You can download them. You can just Google them. Just Google MASIC, MASIC, or Dove. I think it stands for domestic something violence something. Yeah, I can't remember. Anyways, I always use one of the guided questionnaires like a MASIC and Dove during my screenings with all clients who are related to family law. And I won't necessarily have the form printed out and fill it out, but I'll be asking the questions on the form in a more kind of conversational way and recording my answers in my case notes. And that will help highlight if there are any major issues. And so, for example, the MASIC asks about how decisions are made in the family, how money is dealt with. Are there any weapons in the home? Does your ex-partner ever use violence? Have they ever hit you or kicked you or punched you or all those kinds of things? So it can help guide your intake screening to make sure you're covering all the important bases. Mental health is another one they ask about, which is really important as well. The RIA provided by the Barbara Schleifer Clinic is also good because it looks at cultural factors as well. Amrit, what do you use any screening tools? What are your favorites?
Not the MASIC. I think the MASIC is really comprehensive, very useful tool. So, but I'm interested to look at some of the other ones you've mentioned as well, Jonathan. It's great.
Yeah.
I also
What
use
about you,
MASIC.
Michelle? Do you use the screening tool?
Yeah, I use the MASIC as well. That's the one that I just find it complements so well with our intake process anyway. And I am like you, I'm not going through the questions saying, in this particular order, but I'm aware of the questions. I'm kind of going through them and marking down if I'm worried. And if if there's enough kind of points there that I'm really worried about, that's when we start really looking at the MASIC and saying, okay, maybe I do need to sit down and ask these questions, and maybe we need to have some deeper dives, and maybe we also need some time so that the client can get comfortable with me so that they can answer this, because what they answer on their first meeting or second meeting with you might be very different when you've known them for 5 or 6 months, when they're more comfortable and open with you. So thank you.
Really good point, Michelle, that you just made there. And I want to emphasize it. Screening doesn't just happen in your intake session. Screening should happen throughout the process, right until the point where they're inking the separation agreement, because things can change, dynamics are complex. And it's, I think what you said there about clients maybe not contributing as much information in the first session that you have with them, and maybe this information comes out slowly over time as they build trust with you, or maybe as things at home get worse and worse, they at some point they feel compelled to share with you what's going on. So screening doesn't just happen at the beginning, it happens throughout. And another important piece there that you said is that trust is so important to build with your clients. So, when they come into your office, the first question you're asking is not, hey, did he ever abuse you? It's you want to build up to that and ask more benign questions at first and kind of build that trust over time and develop the person's comfort with having a more and more stressful conversation with you and talking about bigger issues. So yeah, trust with your clients is really key in this scenario. And I think Amrit said earlier, which I think is really important to repeat, a trauma-informed approach is really important too.
Absolutely. All right. Sorry, I know we didn't do our poll results, so let's get them up. Yeah, I think 86% of us, all of the above. Those are all important signs that we should be looking for. And the MASIC, the Dove, the RIA, all of those kind of incorporate that in different ways. All right, so let's move on to our next one, because this is the one that I think we get the most questions about, which is strategies for effective client communication and safety planning. We've been using this word safety planning, all throughout. What does it actually mean? Amrit, do you want to start?
Sure. I mean, when I'm putting together a safety plan with the client, first of all, there's the reporting to Children's Aid. There's some discussion around whether a restraining order is needed, to ensure that their legal counsel is aware of what's going on so that they can get some direction, that they're connected with supports, whether it be a therapist, an individual therapist, just to help guide them through the process. It may be information about shelters that are available for that safe place, because they may not be able to go to a family member's home for risk of harm that could come to the family members that may be housing or sheltering them, and further harassment. So it is really important to provide those resources. Assaulted Women's Helpline, and I think there are a few others that are going to be provided with the notes that are going to be sent out to everyone, ensuring that they have their important certificates, like documents, passport, marriage certificate, birth certificates for the children themselves, like tax returns, like all kinds of different things, so that they have everything that they require. Maybe even just one set of clothing kind of in a takeaway bag so that they have it, but knowing that also that they can always return back to their home escorted with the police to collect any items, that they don't need to take all of those things. The safety is of utmost importance. We want to keep them safe during that time. Is there anything I've missed, Jonathan? Anything else that you would suggest as far as a safety plan?
Yeah, I think that one of the important things to keep in mind is that if you need to safety plan, like if you are a parent who's dealing with family violence, I would really recommend you connect with a professional to do your safety plan, because they may be thinking about things that you might not have considered. Like you gave a list there of some of the things, Amrit, that are important, but there might be other things that that you as a person may not think about. But generally, what I recommend is if people are living in a dangerous situation, first of all, we want to make sure they're aware of how much danger they are in, and that we don't want to sugarcoat it. People who are going through separation are much more at risk of being a victim of violence than people who aren't going through a separation. And I recommend people have what I call a grab and go bag. So that might include spare medication if you're on any medication, any personal items that you need, deodorant, tampons, change of underwear, a couple of extra shirts. And then making sure that is somewhere safe. So it could be at a neighbor's, it could be at your parents' house, it could be, stored in the shed in a location that your partner doesn't know about. And that is, a bag that you can grab and live off for a couple of days. So there probably should be some cash in there as well, or a bank card or credit card or something like that. I always tell clients, take it seriously, even if you don't think it's serious, because the people who ignore threats of violence are often the ones who end up, getting severely harmed or murdered. by their partners. So take it seriously. If you grab your bag and you go to your parents' house overnight and nothing happens, no one's harmed by that. But if you've just protected yourself and your kids from a violent attack, then you've escaped a really potentially harmful experience. So take it seriously. Be prepared to go somewhere and have a plan. The other thing that's important to think about having a plan is that when we're really stressed, we don't think very well. Our emotional brain gets really, really stimulated, and it actually turns off our thinking brain. So in the moment, when you're trying to escape a very dangerous situation, then you want to have the plan there to go so that you don't have to think about it in the moment when everything's stressed. But sorry, I think I went on a little bit long there. I think we're over time. So I'll pass it back to Michelle and Daphne now. My
Thanks.
apologies.
Just before Daphne comes on, and I'm sorry, this always happens. We have so much, and we could do this for 3 hours. But one of the big pieces of information you're going to get is called the HELP Toolkit, HELP. It's from the Department of Justice. They actually have a free course, which is, I think, 75 minutes. So it's very takeable. It's very doable. And the resources are phenomenal. It's over 100 pages of resources. It has links. It has, ways to speak to your clients. It has what to do. It has community resources. There's just so much. You're going to get a ton of information from us. So please do look at it. I think the most important thing I could tell any new family lawyer or any family lawyer who's interested in this is take the training, because the trainings that I have done are 2 or 3 days at a time, and the refresher courses are 2 days. So, this is really hard to pack all of this into one day. And I hope we just gave you the flavor of all of the things that you need to think about so that you realize how important this is, and that the detailed training is key. It's so imperative that you have it done. And we'll be giving you tons of links. You're going to get so many resources. You're going to be overwhelmed with them. And I'm glad. I would rather overgive you resources, and you can choose the ones you want to use. All right, Daphne, I see you're here to kick us off.
I am, but what an amazing presentation. I'm so happy to let you guys take as much time as you need. Such an important discussion, especially in family law. So thank you so much, Amrit, Jonathan, and Michelle, for sharing your time, and Jonathan for making donations to the Denise House over both days. We really appreciate it. And just a note to all the lawyers in the audience as well, this presentation was accredited for 1 hour of professionalism content by the LSO. So make sure to document that. And yeah, I think Jonathan has answered questions, and there's lots of resources. So thank you so much. If anyone has any other questions, feel free to put them in the Q&A, but otherwise we're going to take just a short break and come back at 10:45 with Shannon and Russ and other speakers for family law financing. So thank you so much. Have a nice little break, and we'll be back shortly.
Thank you both so much. It was so lovely to see you both today, and for all of your insight. I truly appreciate it.
Thanks for having us,
Pleasure.
Michelle. I really appreciate it.
Thank
Of
you.
course, guys. Have a great day.
Bye.
Thanks. Bye.
Bye.
Family Law Financing. Welcome back, everybody. Day 2, the Family Law Summit. Carrie, welcome.
Good morning. How are you? Hey,
Welcome.
Natalie.
Welcome. Shannon, welcome. Just a quick housekeeping update before we begin. Want to thank a number of people who have been donating, a number of individuals. Roxanne Shank, $200, Bev Lewis, 100, Raymond Kinniak, 100, Megan Pellet, 200, whole bunch of anonymous donors, Jonathan Paynter, who was just on. Thank you, Jonathan, $100. Carrie, see, you just made a donation. Thank you so much.
My pleasure.
$100. And we are quickly approaching our mark of $10,000. Shannon, can you give us a grand total and any further updates?
Yeah, we just want to once again thank Bridgepoint Financial, Tim Andrews and his team. Tim Andrews, who you'll meet in just a moment, for this presentation. They already had a very generous sponsorship donation towards the Denise House, but they've contributed an additional $2,500 to help us get closer to our goal. So thank you so much to Bridgepoint Financial, as well as CPO, our other sponsor, and all of our audience members for your generous contributions, small or large. It makes a big difference for the Denise House and their efforts. So thank you so much.
Shannon, I know we're close to 10. Should we push it to 12.5? What do you think?
Yeah, I mean, let's keep going. Let's see how much we can get. We'll break a record.
Get marketing to make a new graphic. We're going to need a new, what do you call this? A
Break the thermometer.
Oh yeah, they could just break it through the top, right?
Yeah.
Add some fireworks while you're at it.
Great. Yeah.
Love that idea, Natalie.
Sarah and Nicole, if you're listening, come on, get on it. You got lunch break. It's working. Okay, so let's make a start. What do you think, Shannon? You ready to go?
Yes, I am. I'm just going to take things over here, Daphne, if you don't mind. With the screen share, here we go. Okay, so as I mentioned, I'm going to take a moment to introduce our speakers who will be presenting on family law financing. First, we have Tim Andrews, and Tim Andrews brings 25 years of experience working in several sectors, including legal and finance, to his role at Bridgepoint, where he leads the business development team and devotes much of his time to creating awareness for the company's legal solutions. He is also involved with product development and evolving existing solutions to best address the needs of lawyers and reflect ever-changing market conditions, including being instrumental in the development and launch of Bridgepoint's family law financing. Tim truly appreciates the opportunity to meet with lawyers to discuss their individual needs, discover more about their firms, and provide solutions relevant to their practices. Thank you so much for being here, Tim, and for all of your support for this event.
Absolutely. Thank you, Shannon.
Next, we have Carrie Heinzel. Welcome back, Carrie. We had Carrie on for a couple of programs yesterday. It's always great to have you here.
We're leaning into Carrie pretty hard, these last couple of days.
It's my pleasure.
And for anyone who didn't join us yesterday, I'll just take a moment to introduce Carrie again. Carrie Heinzel is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for seasoned practitioners. She sits on the board of directors for York and Durham Collaborative Practice and is the president of the OACP. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the OACP, Family Dispute Resolution Institute of Ontario Annual Conference, and the IACP. Thanks again for being here, Carrie.
My pleasure.
And next we have our very own Natalie Derbyshire. Natalie was called to the bar of Ontario in 2006.
A long time ago.
She provides
was there computers back then, Natalie?
There were, but I think it was like a Commodore 64.
Floppy disk.
Yeah.
Sorry, Shannon, we keep throwing you
No,
off.
that's okay. I had a tickle in my throat, so that gave me a minute to
Okay.
recalibrate over here. I appreciate the interlude. Natalie provides clients with peace of mind through sound legal advice and helps them navigate separations confidently. Focusing on dispute resolution processes like collaboration, mediation, and negotiation, she aims to save clients money and achieve reasonable settlements. Specializing in supporting vulnerable clients, particularly those affected by family violence, Natalie offers legal knowledge, safety measures, and therapeutic resources. A certified collaborative practitioner since 2011, she serves on the board of directors for Collaborative Divorce Toronto and chairs its membership committee. She also serves on the board of directors for the Family Dispute Resolution Institute of Ontario and co-chairs the Family Violence section. Thank you for being here, Natalie. And
Thank you for having me.
my pleasure. And I'm just going to give a brief overview of what our speakers will be discussing today as part of their presentation. And what you can expect to learn over the course of the next hour. So we have expected costs of separation, financial challenges of divorce and separation, the retainer agreement, common approaches, and Tim will be sharing about Bridgepoint Financial Services, and then we'll have some final thoughts from all of our speakers. So I'll let you take things away, Russ.
Yeah, let's run our first poll, Shannon, if you don't mind. And we do have some audience questions that have come in. So thank you, everybody. Send your questions in. Please participate in the polls. First poll is, how do your clients finance their divorce and separation? And a question that we're going to kind of lean into you heavily, Tim, not because you're the sponsor, but because you're kind of a unique spot where there's third-party financing for family law litigation. A lot of lawyers don't even consider this as an option. I know up until a few years ago, neither did I. But is financing available if a client hasn't even retained a lawyer yet?
Yes, I mean, we do look at pre-retainer amounts just to, because at the end of the day, it ends up being an access to counsel issue. So we are able to look at certain files and clients pre-retainer just to, ensure that they are able to start working with a lawyer and getting the information that they require for any further funding that they need during the process.
Okay, good to know. Thank you. So let's see what our audience is thinking. How are people paying for their divorces? Can we get our poll results, Shannon, when you get a minute? All right, cash and savings, 60%. Credit card, line of credit. Yeah, it's quite common if they have credit on their credit card anymore. 60%. Family and friends, 56%. It's surprising how many family members step in, right? I know when I meet clients and you think this person doesn't have a pot to piss in, how are they going to afford a lawyer? But the family steps in, they don't want their child or their brother to get railroaded and pays the bill. So that's quite common. Lawyer defers retainer payment, 24%. I'm surprised that it's so high. Third-party financing, 12%. And other, please put it in the Q&A. So thank you, everybody, for sharing those. It's very interesting. Let's talk about expected costs of separation. So I'm going to fire through a bunch of things. And Carrie, Nat, you tell me what your numbers are, and I'll tell you if I think that's consistent with mine. And Tim, if you want to pike in on this as well.
Mm-hmm.
All right, so a collaborative practice file, what's the cost? Like these kind of trick questions, right? Because I know it all depends, right?
Yeah.
give it the ballpark. I've got a number in mind. Carrie, what do you think it's going to cost?
If you're doing a full team, I'm going to say 15 per person.
Per person, Nat?
Yeah, I would say typically an average of total cost somewhere between $30,000 to $40,000.
Oh man, you guys are pricey. I was going to say 5 to 20,000, but
well, wait, are you talking about per person or in total? Like just
yeah, well, I guess it's consistent. That might be my client's cost. So yeah, so 40 maybe would be in the ballpark, yeah, at the high end.
Mm-hmm.
All right, so divorce. So basic, there's no such thing as a simple divorce, but let's just say you can get one through. I would estimate, 2,000-3,000. A lot of that's disbursements, right? Is that consistent with what you guys are saying?
Yeah, 100%.
All right, for the next few, I put a big question mark. Contested divorce, property issues, support issues, parenting issues, and complex divorce. That's all over the map, right? You can't really give an estimate on those. What would you say, Nat?
Gosh, I mean, I hate to say it, but the sky's the limit, and it really is dependent upon the level of cooperation between the parties, whether or not people are providing their disclosure and acting in a transparent manner. So yeah, I would probably say somewhere in the range of $50,000 to $70,000
Which
if it's high
is,
conflict,
you think of
and
the
and it can go up from there.
the CP and they're playing nicey nice, these cases can get up to 40,000. So you can imagine if you're not playing nicey nice and you're running off the court for every dispute. Carrie, what do you think?
I think everything is behavior dependent. So if you're going to have good behavior, both parties are operating with reasonable and good behavior, your costs are going to be much lower. If you're going to have bad behavior, it is going to cost you quite possibly everything you have. I know of people that have spent over $250,000 in process alone and didn't get finished. And that's not paying their settlements.
Yeah, Tim, what are you seeing in terms of your clients?
Well, I think, I
Your
agree.
clients being your clients also including lawyers who turn to you for litigation financing.
Right. I mean, yeah, unfortunately, yeah, the sky is the limit. And I think that, I think also something that dictates it is what the anticipated equalization or entitlement is, because, people are only going to go so far, with the funds that they are anticipating receiving.
Yeah.
And the last thing you want is a novel case, right? Where you have $500,000-600,000 that can go either way.
Mhm.
People spend $100,000 to litigate that issue potentially. Yeah, I agree with everybody. It's all over the map. For me, the biggest, when I have clients ask me about costs, the biggest factor is who their spouse is going to retain as counsel. And I hate to say that because that's going to dictate what process we go in. If they retain somebody with collaborative practice training who wants to use a full team and focus on goals and interests, we could probably manage that. If they retain one of these lawyers who are, an arsonist or a warrior, just want to burn everything to the ground. We all know who these people are. We've worked with them. They're in every city. Like Carrie said, sky's the limit. They're going to litigate until that file runs out of money, until they get fired, or until most of them go right up to the first day of the trial and then file a form, get off the record. A handful of them will actually conduct the trial, but they don't have a proper retainer to do so. Maybe I'm being a little bit sarcastic, but this has just been my experience. But would you agree generally, Nat, that the opposing counsel is really also going to be a
Critical.
factor in dictating the costs?
I actually try in my initial letter to the spouse to persuade them to retain collaborative counsel for that reason.
Yeah. And a lot of people don't know, right? Because I've brought in runaway train high conflict cases after 2 years. Explain the collaborative process, and they said nobody told them about that. If they'd known 2 years earlier, they probably would have saved $100,000 in fees and not gone to court for 2 years. Okay, so let's go next topic. Experts, price range. What are you seeing, Nat?
Geez, again, the sky may be the limit depending upon how you conduct your case and whether or not you're wanting to have expert reports. So paying for your lawyer, obviously that's probably going to be one of your largest expenses.
But I'm thinking if you have to retain an expert, let's say a CBV or parenting professional, what kind of cost would you be estimating?
So I would say roughly at a minimum, anywhere from $10,000 to 30. I've seen more than 30 in very complex business valuations and income analysis reports. It's just dependent upon the nature of your business and how the structure.
Yeah. Carrie, what are you seeing at your end?
Yeah, I think Natalie's estimates are right. At the end of the day, this is going to come down to complexity. So if you have a very simple business, you're a sole proprietor, or, a very simple structure, that's going to look very different on your costs. If you have a full corporation with a lot of employees and land and everything else, that business valuation is going to get a lot more complex, and therefore the cost of that is going to be a lot more. It's really going to, the more complex you are, the more this is going to cost to unravel, because we want to get it done right.
Got to give a plug. This afternoon, we've got certified business valuator reports. So if you want to learn more about what we're talking about, stay tuned. We've got some great experts coming in this afternoon. I would agree. I'd say, 5 to 50,000 would be the general range. It depends what kind of report you want. If you're getting an oral report, it's going to be a lot less expensive. But recently I had an expert do a company valuation, and we got up to 40 grand pretty quickly. I didn't understand why it got so expensive. But there's multiple holding companies with, strange shareholder arrangements, and it took quite a bit more work than I was expecting. So, Tim, you're seeing pretty much the same thing at your end, or?
Yeah, and I would agree. I mean, it's dictated by the complexity. I think some of the more substantial ones we see are business evaluations, and then even getting into forensic accounting, when one party is trying to locate, any monies that haven't been truthfully submitted.
Yeah.
Yeah.
All right, case management. So we're talking about case conferences, settlement conferences, trial management conferences, continuing case conferences, all the rest of it. Exit free trials, I would say $2,500 to $5,000 a pop, including preparation of the brief. Nat, does that feel about right?
Yep, I think that's correct.
Yeah. Trials, pre-pandemic, when I used to do a lot of these in person, I would tell my clients $5,000 a day. We would just run a blocked fee. That actually saved the money because I usually work late at night on the case and early next day, and sometimes I'd be out of town at a hotel. But generally $5,000 a day. I think it'd probably be more expensive now, maybe not. And probably $25,000 to prep for trial. Trial records, document briefs, witness prep, and trials can go from $100,000 to $200,000 if you're into it for 10, 14 days. What's your experience for trials? Does that sound about right, Nat?
Yeah, I would say in general, you're going to spend over $100,000 throughout litigation at a bare minimum if you're going to trial. That's been my experience.
Yeah. Appeals, we don't talk about appeals too much. When I'm unsuccessful, happens, I flip it over to Aaron Franks at Epstein Cole. He's sort of my go-to appeal lawyer. There's the plug for Aaron, our case 2024 case presenter from yesterday. Fantastic job, and Adam as well. But generally, I don't think I've had an appeal cost less than $20,000 for even the simple ones. And if you have motions at the Court of Appeal, it goes through the roof. So appeals can be incredibly expensive. And if you're ordering the transcripts, add another several $1,000s on for transcripts. What's your experience at the appeal level, Nat?
At least $20,000, and that's because of the preparation involved. At my most successful appeal, we didn't have to make submissions, so that was nice. The judges didn't require it of us because the written material was so well done. But yeah, at a minimum, I would say 20,000, and again, it can be much higher just depending upon how many days you're having to attend.
That's some pretty good advocacy, Nat. When they don't want any submissions, that means you've done good, right?
It's all about the preparation.
With me, they just said, we need to hear more. You haven't said anything yet, right? Come on. Don't you have anything? Okay, so what are some, all right, let's go to our next poll, see what our audience is thinking. Thank you, everybody. It just gives you a flavor of the costs that we're seeing on a day-to-day basis practicing family law. Your costs may be different. They could be much higher. Maybe if you're in a smaller community, those costs may be lower. I know a lot of family lawyers don't even do trial work. They refer it out. So it gives a sense in terms of what we're looking at. So next poll, what are some of the financial challenges your clients experience during divorce? So it'll be interesting to see what our audiences experience. Most of our audience today, 80% or more, are family lawyers or other lawyers. So this will be a good one, but let's see if we've got another question we can give to Tim. maybe Carrie can answer this one too, but we'll start off with Tim. Why would a client use family law financing over a credit card? Oh, I think probably the interest rate might be the answer, but what's the answer there?
Yeah,
Tim?
generally, yeah, the interest rate is lower, but there are a few other benefits compared to a credit card. One is monthly servicing. As you know, when you carry a balance on a credit card, you have to pay minimum payments, and that can be really tough if a person's in a position where they're trying to make ends meet during the process. And then the other big factor is monthly compounding. So any amount that you leverage on a card, that interest is compounding monthly. Whereas with, at least with Bridgepoint, we only compound biannually. So those are the two big benefits. And then also repayment is only due upon resolution of the separation or divorce.
And if it's a spouse without credit or an income, they may not be eligible for a credit card.
Exactly, yeah.
Yeah.
So
Carrie?
we don't do a credit check, and there's no proof of income required either.
Carrie, what do you think? Line of credit.
Yeah, I have to agree with Tim. If you're paying like 21% interest on your credit card, it's really not a great use of money. The other thing I like about this idea of financing available to you, it's cash flow. That becomes so difficult when you're starting to go through separation, divorce. Like, we wanted you to be able to live still. You need to be able to live still. So if we can find options for you that allow you to give you that breathing room, let's get you that breathing room.
Well, especially if you got to get a second home or a second apartment, right?
Well, yeah.
That's much, right? All right, let's see our poll results and what our audience is thinking. Thank you, Shannon, for assisting. All right, paying for the lawyer, yeah, 75%. Getting a new home apartment, 55. Pursuing support claims, 56. Waiting for equalization, 50. Living expenses, 49. Other 10, you can put that in the Q&A box. Really, everything, right? According to that poll is what we're looking at. Okay, next, financial challenges during the divorce. Well, let's hear what our experts think today. Accessing equity and delayed equalization payments. Tim, you want to speak to that a little bit?
Yeah, I mean, I think the biggest factors that contribute to the financial challenges during the divorce process that we see is, equities tied up in the matrimonial home, so they can't access that. Any investment accounts are locked until settlement. There's, and we touched upon it just now, there's a requirement for living arrangements, and that becomes even more important in high conflict cases, as well as domestic abuse, where people need to escape the matrimonial home. So that's a very big one. And I'm sure we'll get into a lot of it, but there's the private mediation or arbitration costs that are involved, and generally no access to common financial assets. In a lot of circumstances, one party is a lower or non-income earner, which puts them at a significant disadvantage. And then again, what we spoke about in the last segment, which was your disbursement costs, so your expert reports and business valuations.
All right. So now, what about accessing or retaining counsel? How do you work with clients when they're faced with that challenge?
Well, often people ask me immediately whether or not they're allowed to draw money from their joint line of credit. And the answer is that depends on whether or not you're in the collaborative process.
Yeah.
If it's joint, yes, the answer is you do have access to it. And sometimes clients beat one another to the punch, right? Spouses will race to the line of credit to see who can withdraw first. And then that ends up being one of the first urgent issues to resolve.
Or if the spouse is being mean-spirited, they just simply cut the credit cards off, right? Or,
That too. And if there's a pre-existing unequal playing field, as Tim had mentioned, it's usually worsened.
Yeah, it could be really tough. And that's when I see a lot of family and friends stepping in, right? They realize they may or may not get paid back later, but they're certainly not going to let their family member go without a lawyer helping them. Disbursement costs, we see this quite often in the collaborative setting. Carrie, lots of creative options for the disbursement costs. What are you saying?
Yeah, I always want to make sure that, when people are trying to unlock things or get access to money, that we're not triggering tax. It's one of the things that people go, well, I'll just cash out all my RSPs and everything else. And it's like, can we just talk about that first? That can't be our only access to getting funds and everything else. So wherever we can find a tax saving, not trigger a tax consequence, let's look at that first. Let's see if there's other ways of doing things. Again, if you're in collaborative, Natalie's already mentioned, I love the idea. You have a joint line of credit. Let's use that for process. If we have that available to us, it's a great way of keeping track of what the process is costing the family. Because it's not just one person it's costing the whole family. I find when people can track that and look at it, sometimes it snaps them into reality. And rather than going, oh geez, I just have an open ticket here and I can spend wildly. We want to calm that down.
And we've had cases, Carrie, you and I, where my client was clearly paying something or everything, like
Yeah.
a significant equalization payment, significant support obligation. And I just tell them, pony up 25 grand for the cost of the collaborative process. So your spouse can have a lawyer and professionals involved. It serves his interest to get a full team involved, and we'll adjust for it at the end. And
Yeah,
most clients are agreeable to that.
Yeah, it's all reconcilable. Like nothing is going to be left to the side. We're going to look at all of it. So we're going to do things in order. And when we get there, we'll put it all together and say, great, you spent X on the line of credit, your spouse spent Y on the line of credit. You spent the same, great, don't have to worry about it. That's how it'll get paid out. And we go from there.
But unfortunately, there are spouses and lawyers who use the finances to try to extract an unfair settlement or a settlement that isn't within the goalposts, right? And then we see this quite often when we're looking at expert reports, business valuations, income assessments. Like, why would I pay for you to get an income assessment to say my income's higher? Or, I'm not going to finance your litigation. And this is quite commonplace. And these can be, as we started off at the beginning, quite expensive. So Tim, is this something that they can turn to you for if we need a business valuation or an income assessment or an expert report?
Yeah, those are typically what we can assist with, and we also have a number of experts that we work with. So we're always looking to add more value to the relationship that we do have with firms, and we can provide referrals to certain experts if they're not already part of your roster.
Yeah, and there's a number of other things that fall under this category, right? Family professionals, voice of the child reports, property appraisals, medical reports could actually get quite expensive too if if you're doing a vocational assessment. So yeah, that adds up. All right, well, thank you. That's clearly there's a lot of challenges. I think we can all agree on that our clients are facing at every step of the case. And financing it, we need to be creative. We've heard Carrie come up with some ideas in that too. And, Tim's here to provide a third-party solution. We cannot obviously do contingency fees in Ontario for family law for a number of reasons, but we don't want lawyers taking an interest in a case, especially if it involves parenting or the child's best interests. So let's turn for a minute to retainer agreements. I remember when I first started practicing, going back, story time, there would be these lawyers who would tell clients, just give me $500, right? And the secretary would go in the parking lot and meet with the client and get an envelope of cash. And I'm sure they kept it off the books. And every now and then the lawyer would say, oh, I need another $1,000. Like, this is old school family law, right? It's hard to believe, but it's true. It wasn't me, but there's a number of lawyers, especially in small communities. It's just the way they operate. But you need to have a standard retainer agreement, right, Nat? It needs to be pretty thorough.
You do. I've never operated my practice out of my van.
In your van down by the river. there's a Lincoln lawyer, right? You run around in your car, and there's lawyers like that. You see them all the time coming into court with their grocery bag of court documents. I'm not naming anybody specifically, but I could. So, what do you want to include in retainer agreements, Nat?
Quite a lot, to be honest. I think people are astounded when they receive their retainer agreement because it's quite lengthy and it contains protocols of the firm, how we conduct business, what we expect of our clients, how they can achieve a cost-effective resolution by engaging in rules of conduct. And as well, it details all of the payment terms, how they'll be charged, what they'll be charged for, and how the trust account works that we work against in terms of invoicing and when they're entitled to get money back if they decide that they want to end the relationship with their lawyer or if their matter is finalized.
Yeah. And you can include a lot of non-financial things, right? Warnings about their use of social media and how it can come back to haunt them in court. Appropriate communication with not only our office, but other parties, and privacy and security. It covers a number of things, not just you're going to pay us X number of dollars to do this.
It's like a mini tutorial, Russ.
Yeah, it is.
Family Law 101.
The more detailed and thorough you can make your retainer agreement, the better informed your client's going to be. And it's going to clearly define what your relationship is. And if you're doing unbundled legal services, you want to be very specific in terms of the service you're providing, because the client may just think, okay, you're my lawyer now, and you didn't specify it was only for the financial statement that you'd help me with. And you want a mechanism to get off the record in case there's a breakdown in the relationship. Evergreen retainers are becoming more popular. If you're not familiar with an evergreen retainer, for example, you'd pay us $5,000. Once we render an account, you're required to top that back up to $5,000. So the account never goes into the red. There's always money in trust. And if you don't top it back up, we end our representation of you. So a lot of lawyers, and I've seen this many times, will, take the $500. 2 years later, they get fired for whatever reason, and the account comes over to us, and we realize they've never rendered an account. They have like a $4,500 AR and an upset client. So they worked on the file for 2 years, and now they're not going to get paid. Or if they do pursue a payment, there's likelihood there's going to be a complaint against them. So really difficult situation when your client owes you money and you need to collect and still continue to work. Many clients can't catch up again. So that's why these evergreen retainers are really, in my view, a really good practice tip. But have you used those before, Nat?
Sorry, contingency fees, do you mean?
Oh, the evergreen retainer where they're always
Oh,
required to top up.
absolutely. Absolutely. That's the only retainer that I've ever subscribed to. People need to have money up front, ready to pay for your services. Otherwise, you're potentially leaving yourself in a bind.
Yeah. Nat, in terms of retainers, you have any, or sorry, Carrie, do you have any experience with security, liens, directions, promissory notes? Do you ever return to those?
Yeah, actually, we just did that. We've had some matters where, they've been good payers all along. They've done a good job, but we're coming to end. They're running thin on funds, but we know the home has been sold. We know the closing date. And so we do get them to sign directions to all of us saying the first people getting paid out of this are the legal team. And we actually just did this last week. No problems. The clients were really thankful about it because it was just a pressure point that was taken off of them because they knew we were going to get paid. It wasn't going to be an issue. They were going to get their documents on time so that they could close on their new homes that they had already purchased. So we do that. The other thing that we've had to do in the past is we've actually had to put people into collections. Just simply, you're not paying. And we keep everything that we send out and get in. And so when somebody says, oh yeah, I'm going to pay you. And 6 years or 6 months later, they still haven't done anything. We kind of go, well, our next resource is this. Like, this is the only other thing that we can do is put you into collections. So.
Collection agency or collections?
Collection agent. Well, you go through a collection agency. I always figure, you know what? Even if I'm only gonna get 70 cents on the dollar, it's 70 cents more than I was gonna get if they never paid me. So you take your lumps for not doing an evergreen retainer. But one of the things I have in my retainer agreement is that you will give me a valid credit card to put on file, and if you don't pay, I get to charge your credit card.
Yeah, that's a good point too.
So,
Yeah, directions could be a great tool to get people over the hurdle, especially if you're 95% of the way there, homes closing in 30 days, loss of equity.
Yeah.
It's a convenient, and it's, you want to try to get the clients to a final solution. So that's a great way. We've done liens and mortgages before, inconvenient, lots of delays. Oftentimes I forget about it, and then somebody goes to sell the house and they got to pay out our lien, which is kind of a nice bonus, but it comes in 3 years later, right?
Yeah.
And we've already written it off the books. And promissory notes, I'm not a fan of, really. Even directions can be dangerous. They can reverse the direction or not honor it, or so, even if it's irrevocable. So
Yeah.
certainly some risk associated with that. Did you want to add to any of this, Nat?
I would just say there's a certain level of accountability, I think, that I prefer in imposing an evergreen retainer, because people quickly come to realize that they are very much part of their process. They can either be part of the solution or they can be part of the problem. And once they recognize that they're going to have to keep paying, they quickly change their behavior, I find. So.
That's a great point, Natalie. And I don't think people understand that sometimes we just stop working. Like when we have a threshold that when the account gets to a certain threshold and we have not been paid, or we're having trouble getting paid, we just stop work. We just say, until this is brought up to date and we have a new retainer, we're not working on your file anymore.
Yeah, the collection, at some point, we just write it off. We may send it to a collection agency to collect. We don't care anymore. It's off the books. But, damaging the client's credit rating, they came to us to help. I'm not sure if I want to make things worse by damaging their credit report. I think that might, for me personally, that might be going a little bit too far. We want to try to help them through it, but yeah, everybody's got their own choice. Tim, what kind of security you put in place, or what was common when we go to third-party financing? What should our clients be expecting?
Yeah, I mean, what we typically do is we'll register a PPSA on the client. And then also, if there's a matrimonial home or property, it's not a formal security, but we do register one just to ensure payment upon resolution, and the eventual equalization payment from the sale, proceeds from the sale of that property.
Yeah, so there'll be some documents for them to sign, obviously, right?
Yeah, yes, we have, we issue a few different documents. We have our loan security agreement, which runs through everything. And that also, because we can provide funding in a few different types of ways, it just illustrates how that's done. And then we also have an irrevocable authorization and direction, which also goes to the law firm. And then we just have simply a direct deposit form as well, just to make sure that that the funds are going to the client, but we can also provide a direction that they be sent to the law firm as well, if it's to cover legal fees or disbursements.
Great. So we got a poll coming up here in a few minutes. Next topic is common approaches. So let's not put the poll up yet. Sorry, Shannon, I don't know if you can take it down. What I want, you can put it in the Q&A box, is what's the most common way your clients are financing litigation? And we'll read some of the audience answers off as they're plugging them in there. But let's start with maybe you, Nat. What are you seeing? What's most common in terms of the different approaches that we've talked about today?
I would say typically they use their credit card or the line of credit to fund their process.
Yeah,
that tends to be the go-to. Sometimes they rely upon friends or family to provide a source of funding. Sometimes we come up with creative solutions as well as collaborative professionals, don't we, Carrie?
Absolutely. I think that's the best part about doing collaboratives. We get to be creative.
I used to have a couple clients, they'd always want to pay in cash. And I don't know where the cash was coming from or what kind of industry they were in. And it was great, but then we had our limits, right? My clerk would say they're at their $7,500 or whatever the number is, and I'd have to say you can't pay us any more cash. I'm sorry, kind of a strange position to be in, right? But how about you, Carrie? What are you saying? What's the most common approaches?
Same line of credits. What we've done though with some clients, because we want to give them a little bit of fun strategies that we can use, is that put it on your credit card, then pay that if you can with cash, like pay it out if you can. If you can't, use your line of credit. At least get some points. So maybe at the end of this, you have enough points to go on a vacation. I always say you gotta get something out of this. So, but we line of credit is really, really common. Sometimes putting on credit card, then paying it out. But family and friends, family is huge. Friends are a little less, and that's okay. I don't know how comfortable I would feel about going to my friends for money to fund my divorce, but definitely family. Parents are really big about protecting their kids, no matter how old.
You want to get a direction or authorization from your client to communicate with family members when they're paying, because sometimes they'll want to ask some questions too, and we're not allowed to communicate with them. So you want the client's consent and authorization to do that.
I think we have to be careful if parents are paying us directly, that the parents do have to understand it's simply a payment situation. You're not getting say in the matter. You're not participating. You're not coming to meetings.
You're not getting a report.
Yeah, go sit in the corner. Thank you for your money, but no. Take this up with your kids.
Well, we're remote quite a bit, so it's quite common e-transfers, certainly credit cards. Some, like you said, Carrie, some clients want to crank up their points, right? They could transfer it, but they want the points on their card. Usually escalates the line of credits, but oftentimes when it comes to separation, usually the credit line of credit's been maxed out by one party or their lifestyle, and then at that point, they usually flip over to family and friends.
Honestly, though, if you have a joint line of credit, you're in the collaborative process, especially, or you're in a mediation process, it is a great way to track how much this is costing you between your professionals, any experts that you need, anything like that. And it is a really big dose of reality, especially if it started at 0 on data separation and now it's up to 50,000. You can see where all your money's going and why. And I think it's a great way for people just to kind of keep their pulse on what spending is.
I remember, and my advice is go in with a blank sheet and just be open-minded. When I remember we had a call come through, client didn't pay his child support, was way behind, had a hearing with Fro, and they're suspending his driver's license. Very short timeline to get a refraining order. And one of my associates said, well, why would we take this client on? They've got no money. They can't pay us. I go, I'll meet with them, right? And we literally had to be in court within a day or two, which means we're going to drop everything to work on this one client. We all get clients who come in like this. And I told them, it's going to be at least $10,000 to get this sorted. And you have to go on a payment plan probably to get your driver's license to avoid it from being suspended. He said, sure, no problem. He had the money, he just was choosing not to pay his support. But he certainly had the money to pay for a lawyer. So even though they may look desolate on your intake forms or their financial statements, does not mean that they're not going to be able to finance their litigation. So be open-minded, be optimistic. We're here to help. And you'd be surprised what clients can do, especially when they're jammed up. They're going to lose their license and potentially their job. So CP approaches to financing. Carrie, can you give us a few examples of how you've been getting creative?
Sometimes it's a matter of one party paying up front. They're going to be paying, maybe we have a stay-at-home parent, the other person has a job, they have been having, I don't want to say control, but they have been managing the money for the family. Maybe it's a matter of them paying up front and then we're reconciling it later. That's a really common one that we've done. Sometimes if we know one party is going to be paying the other party an equalization payment, it's really clear that that's going to happen. Let's do a prepayment up front, so that they feel that they have control and anonymity to go ahead and deal with the team on their own without feeling like somebody else is doing that for them. So
How
those
about
are
you,
just a
Nat?
couple.
Yeah, any creative things you've seen in the collaborative process?
So sometimes the team can agree upon doing block fees. If people are well aware of how much it's going to cost in advance for one meeting or one particular event or step, I find it helpful for them to just be able to manage or control how they're going to pay for it in advance. So it's a matter of financial planning. And then quite apart from that, I guess it's pretty typical, but often they'll take a mutual advance from the net proceeds of sale. And that can be helpful as well, if there's a credit
Yeah.
against the final settlement.
That's quite common. Judges will order the release of funds, usually equally, right? $50,000 each or whatever the number is. But you want to be careful you have enough left over to pay the equalization payment too, right? If you generally have a good sense in terms of what the payment's going to be. So you want to
Always
that.
keep money in reserve. Always keep money in reserve.
But we've got a poll here. Have your clients use third-party financing to fund their divorce or separation? Give everybody a minute to answer that. But I really like your answer there, Nat, about block fee services. And Brian Galbraith has been advocating this for years. But the way it works, the lawyers say, okay, we're going to take $7,500 each. The professionals are going to say, we're going to take $2,500 each. And that team agrees to meet once or twice to do the full collaborative process. And it's paid up front. And it's quite effective. And what clients like about it is they can control their costs, right? So you go to get your kitchen renovated, that your carpenter doesn't say, well, I'm going to charge you this amount an hour. They're going to say it's going to be 25 grand or whatever the number is. So they're used to this concept of block fees for big purchases. Or if you're putting a pool in or getting work done to your driveway, it's not by the hour. Your driveway is going to cost you $10,000 or whatever the paper says. So it's quite common in other industries. Lawyers haven't really warmed up to it too much, but and sometimes you run long, right? So you say, well, if you want us to do an additional meeting, this is going to be the additional fee.
Well, and the beauty of it is that we can customize the length of the meeting for the clients and what exactly we're going to discuss. So it just takes planning as a team to actually formulate an agenda that's feasible within the budget of the family.
Yeah, and there's great precedence for block fee collaborative practice agreements. If you need some, let us know, send us a note. But it's certainly a different way to approach financing family law disputes. All right, let's see what our audience is thinking about third-party financing. Yes, 33%. No, 59%. What is third-party financing? 4%. And other. Put it in the box. We've got an interesting article and some case law we're going to share with you in a moment. But I'm going to flip this over to Tim. It's sort of your lead in. Tell us what this is all about. What should we know about third-party financing?
Yeah, thanks, Russ. One thing I would like to do is briefly just address something that Carrie had said earlier with regards to line of credit. We do offer our funding as a line of credit as well. And I just wanted to jump on her point that it does give great visibility on budgeting and also not abusing the time that you're spending with your lawyer. When you're on a deferred payment plan or if the firm's not doing micro billing, clients can lose track of how many times they're interacting with the lawyer, what they're requesting, reaching out constantly. And that's where things can kind of get out of control. And that's when you have issues where there's, conflict at the time of billing. So the line of credit is a fantastic way to sort of manage that and have full visibility for the client. And then, the secondary benefit is with a line of credit, you only pay interest on what you use. So I think that's what we recommend with regards to our funding going forward.
All right, so let's learn about Bridgepoint. What's the application process, loan documents? How's it work?
Yeah, so It's a simple application. We ask for a few details. It's basically an intake form that gives us some good background information. We then reach out to the applicant, your client, and just get more information that is valuable for our underwriting team to get a sense of the situation and what the eventual entitlement or equalization is going to be. Their financial status, their liquidity, the assets that they have, and that gives us a real sense of what we can lend against. So that's the first part of the process. They also provide us with permission to speak with their lawyer. We like to keep this as light a touch as possible while getting as much information as we can for the underwriting process, because we don't want to have the client incur fees and time with the lawyer, but we also want to ensure that we have a full picture of the situation. From there, it goes into a review with our finance committee. And we go through all of the information. We've got a very experienced legal team that reviews everything. And then we provide the funding. So the loan documents, so that's the loan security agreement goes to the client, and the irrevocable authorization and direction goes to the lawyer. And after that, the funds are deposited and repayment is due, and then that's typically via the law firm's trust account at the time of resolution of the separation or divorce.
All right, we've got some questions coming in. What's the interest rate for Bridgepoint is one of our audience questions.
Yeah, we can be fairly flexible on that front, and that's typically we look at complexity as well as duration. But at the our base would be 1.5% a month, and that's compounded biannually. Yeah, there's no other fees associated with that.
All right, a couple more. Somebody's looking for a precedent for a retainer agreement. You can contact our support team. We'll help you with that. Another question came in. What collection agency do you recommend, Carrie, if any?
I can send that over to Shannon so that you guys can send it. I don't have them off the top of my head. We don't use them a lot. That's a good thing, but we do have one that we use.
Another question looking for block fee retainer agreements. Again, contact our support team for that one. And great questions coming in. Thank you so much.
Can I ask Tim a question?
Yeah.
My question for Tim is that if somebody's in collaborative process and they're having to pay for their lawyer, but they need to pay for somebody like me, the financial professional, or they also need to pay for a family professional, can they use your situation to pay for all the members on the team?
Yes, the client can use the funds however they choose.
Okay.
So, as we talked about earlier, those tend to be legal fees, alternate living arrangements, personal expenses, that sort of thing but it's up to their discretion.
So vacations.
Well, that would be
Get away from the spouse.
If it's in the best interest of the child, it's got to be a Disney vacation.
There you go.
You have your hand up, Nat?
Yeah, I just wanted to say, honestly, I found the earlier that we inform people about Bridgepoint financing, the better. And so I make it a point during my initial consultations to raise it, particularly where a client is saying that funding is a concern, because then it enables them to at least investigate their options early on.
You know what? I think it's great for somebody like me, where so often we are the first point of contact now, and they're telling me I can't afford a lawyer. I can't do this. So if I can point them over to a Bridgepoint, that makes my job a little bit easier. I don't want to deal with a client that doesn't have a lawyer. And that I think everybody needs really good legal advice. So I'm not going to take that client on. But if I know that there's a way that we can get them through the process and pointing them over to Bridgepoint, I think it's a great idea.
I don't want to deal with an opposing party that doesn't have a lawyer.
Well, yeah.
Me neither.
So we're all on the same page. Lawyers are necessary for the process.
Now, you can give us some case studies. You've used this before for your clients, right? So what was that experience like, and what were some of the issues you were funding without naming names?
Significant need for funding for arbitration most recently. Honestly, it's a lifesaver for people because they get to a certain point within process where they realize they're going to need a decision maker to get to a final outcome. And often they have no idea what they're going to do to fund that. And so, yeah, Bridgepoint was a lifesaver in that case.
Yeah. And we do have a case in Ontario where part of the cost claimed was litigation financing by a third party. And the judge authorized the interest on that cost, even though it wasn't agreed to or in advance from the other spouse, but they thought it was an appropriate disbursement to finance litigation. And Shannon's going to put that case in the reported case in the chat. And there's also an article about litigation, third-party financing. So I think this is the trend we're going to start seeing. And it's especially important when we look at how many unrepresented or self-represented litigants there are in the family court system. I'm not sure what the numbers are, but if I had to guess, it'd probably be over 50%. Would you think, Matt?
I think that's accurate. It may even be
It's probably
more.
conservative, yeah.
Yeah.
So all these people who could potentially be accessing legal services and don't know that this is an option really need to be educated about this. And if it means that they're going to incur a little bit more interest, that's potentially a claim they can make if they're in a cost submission, if their case is successful, that had the other party settled earlier or accepted an offer to settle, the litigation financing would not have been required. And I think that's a pretty compelling argument. So something to consider. All right, a few more questions for Tim, and then we'll move into final thoughts. This has been a great discussion. This is probably one of the most difficult issues facing our clients is financing. In addition to all the different stresses that go through a separation divorce. If we can get that off the table and say, you're financed, we're ready to help you and follow through on this, I think that's going to go a long way to helping clients sleep at night and helping with their mental health. But a few quick follow-up questions, Tim. Are there restrictions on what family law financing can be used for?
No, as we talked about earlier, it's up to the client's discretion. Obviously, we prefer it's used for, things that are going to advance the process or get them out of a situation, with regards to living arrangements, but ultimately it's at their discretion.
All right, we have a few hundred lawyers watching you today, so no pressure. How does the client qualify for the financing?
Yeah, so we've got, when we work with firms, we do have, we've got our term sheet, a product sheet, and we also have key factors that contribute to a successful application. It's quite a long list and detail, but the high level is, the borrower is represented or will be by a lawyer. The borrower resides in Canada. The matter is governed by Canadian legislation or courts. And that there will be a triggering event for repayment is key. So if that's a jointly owned property with sufficient equity that's going to be sold or brought out by one party to the other, if there's going to be a cash equalization payment made from one party to the other, or a property will be financed and the loan will be repaid from same. Duration and complexity of issues is a large factor for approval as well. And then we also require sort of general information for the application, things like ID, lawyer information. If there's properties involved, we'll need all the documentation there as well as business evaluations, spousal support calculations, the separation agreement, ultimately pension statements. But those documents are based on the unique facts of each case. But that's typically what our finance committee is going to look at. That's what we typically look at, but we can also look at borrower's income or any other assets, like on an informal basis to review with our team.
That's super helpful. I think I got a quick minute left, so I want to get some more questions in here. Does the lawyer have to provide guarantees on the funding? And are there any, or is the lawyer tied in any way to the funding?
No, not at all. The lawyer is not involved and doesn't have to provide guarantees. Like I mentioned earlier, we want to be as light a touch as possible while getting all the information we require. So we do like to work collaboratively with the lawyer just to ensure that we have all the information we need. Internally, we have a policy called our responsible lending promise. So we never ever want to provide funds on claims that aren't meritorious. So that's extremely important for our business. But the lawyer is not liable in any way.
Okay, good to know. Super helpful information. Thank you again for the sponsorship towards the Denise House. We are very close to our numbers, so that was really generous of you. Thank you for that. I also noticed that Ravinder just made a donation. Thank you, Ravinder. Any final thoughts or questions on financing family litigation? Carrie, you want to go first?
Sure. Just a couple of things. First of all, this going through separation divorce is going to be one of the largest financial transactions that you will ever do in your life, from the home to pensions and everything else in between. So you do need to be prepared for that. Having said that, old data, although I don't think it's changed too much, is about divorce is about 67% more expensive than the wedding was. So keeping that in mind, it's going to cost some money to get through this, and you want to make sure you're doing it right because you only want to do it once.
Don't forget the divorce party too, right? That's common.
Oh, well, yeah, that's the added.
Nat, final thoughts?
Just that I love the flexibility of Bridgepoint, and it's fantastic that they can use the money as they deem necessary for whatever purpose, because sometimes there's unexpected expenses that arise, like the need for criminal counsel. So not only paying your family law lawyer, but criminal counsel as well, if there's family violence at play, as well as therapy. I think it shouldn't be overlooked. Therapy helps us resolve our cases, keep people, honest and transparent.
Yeah. I know I'm heartbroken sometimes when clients run out of money and can no longer fund their case and they have meritorious claims. So this is a really fantastic option to be able to present to them. Tim, any final thoughts before we hand it back to Shannon?
Yeah, just a couple of things. I know we didn't have time, but I do have a number of case studies that really illustrate different ways that can be leveraged during
well, let's take 2 minutes quick. Give us a couple of your case studies. I don't want to rush you through it.
Yeah, and just as a footnote to that, I'm happy to provide these to any of the attendees as well.
Yeah, we'll include them with our show notes.
All right, wonderful. So I've got one here just for living expenses. So the facts of the matter are that the parties were still living together in the matrimonial home. However, domestic abuse was present. The female partner or wife was unable to move or retain a lawyer to commence the separation process as she was on disability and did not have extra funds available to her. The parties had significant assets, including 2 properties, which were jointly owned, and a couple different investment accounts. The borrower was able to secure a loan which allowed her to move into her own apartment and retain a lawyer who began the separation and disclosure process. The lawyer was able to assist with the commencement of spousal support, and the borrower was able to escape domestic abuse. We provided a lump sum of $10,000. $5,000 was provided directly to the borrower, and $5,000 was provided directly to the lawyer in trust for his initial retainer fees.
Nice.
Yeah.
That answers one of my questions. So the client gets financing, the money goes to the client or to the lawyer, or it depends what the client directs.
Exactly. Yeah. But the client can direct the funds to the law firm to take care of a retainer or any outstanding legal fees.
Okay, good to know.
And
Any
then
other case studies? Those are really helpful.
Yeah. Well, I've got 8, but we don't have time for those, so let me be discerning here. So another one is the borrower and her partner were married for 20 plus years. Upon separation, the matrimonial home was sold. The separation agreement had already been signed. However, the board did not have funds to secure her own rental apartment. She did not have cash in hand, nor did she have credit to secure funding prior to the closing of the home. So essentially, she was going to be homeless in this scenario. So we provided a lump sum of $55,000 to the borrower, and that allowed her to secure a rental by paying 1 year of rent up front, which was required due to her credit situation. And that also assisted with personal expenses, which was repaid upon the closing of the property 60 days after the loan was provided. So both of those really speak to living expenses. There are legal fees at play there as well, but we do have a number that are just dedicated to legal fees, as well as the ones associated with litigation.
And you're really helping clients in crisis, right? That person could have been homeless.
Yeah, I mean, Bridgepoint started in 2005, and it was based on access to justice. When we did start working with family law firms, we realized that the same situation was happening in family law, where there was a big access to counsel issue, which ultimately ended up being access to justice. So it was an ideal area for us to assist with.
Well, you're providing a super valuable service. Thank you, Tim. Sorry, we went a few minutes over, but this is really important to understand how we can use this financing to help our clients. Shannon, what do we got up next?
Thank you, Tim, Carrie, and Natalie. That was a great presentation. Very, very great information for lawyers and our clients. So thanks so much. We're going to take a short break now, and we'll be coming back at 12 for a very important discussion on embracing the 2S LGBTQ+ community in our family practice. So look forward to hearing from Jane Ho, one of our associate lawyers at the firm, and then Sarah Rutledge Fisher, who is a guest speaker, who will be joining her.
Natalie, Carrie, Tim, thank you so much. Great job,
Thank
Shannon.
you.
We're going to see
Thank
everybody
you.
back here at 12 noon.
Thank you very
Always a
much.
pleasure. Bye all.
Bye-bye.
Hello, hello, welcome back, everyone. Hi, Jane, lovely to see you. How are you today?
I'm well, thanks, Daphne.
Good. Hi, Sarah. Welcome.
Hi, Daphne. Thank you.
Thanks for being here.
I
Um,
am thrilled. Thank you for having me.
Of course. I'll just make a quick note for everyone in the audience that this presentation was accredited by the LSO and has 1 hour of EDI content. So for anyone watching, good to note that. But otherwise, thank you so much, Jane Hutt and Sarah Rutledge Fisher, for being here, and I'll pass it over to you.
Hi, everyone. My name is Jane Hall. I am a collaborative lawyer and a senior lawyer at Russell Alexander Collaborative Family Lawyers. So I'd like to explain a little bit why I'm very interested in this topic and why I want to learn more. I have a child who came out maybe around 6 years ago, and they really asked me to understand them, understand their community. And I have done a lot of research as well as done a lot of mandatory reading, and I say mandatory because I was provided with a mandatory reading list by my child, and I have been diligent in doing so, but there are still many things that I just don't know. I simply just don't know. I'm a little bit confused sometimes, afraid a little bit about asking questions. So I think that if I'm confused half the time, I think many of us are. So I have invited Sarah here to talk to us a little bit about some of the things, and a lot of it is just basic things. So I'll ask Sarah now to introduce herself to us.
Hi, good morning here in Alabama, and I think good afternoon where many of you are. My name is Sarah Rutledge Fisher. My pronouns are she, her, or they, them. I'm happy with either. I am a non-binary lesbian living in the deep, deep south of the United States, and I've spent the last 10 or so years organizing, educating, writing, advocating for and in the LGBT, or the 2S LGBTQI plus community here in the United States. I'm also an attorney licensed in Alabama, here in Alabama, and also in California, where I used to practice. But these days, I primarily work as a mediator and also doing these kind of diversity and inclusion efforts, which are always near and dear to my heart.
Yeah, I think that Sarah and I discussed why we're doing this at all. And I think that, it's really important to keep having these conversations. Well, first of all, it's important to have basic cultural competency. But beyond that, to be able to serve our clients in a way that most of us want to, I think it's not just about reading a chapter in a book. I think it's to engage with the conversations that this community that we're serving is having internally as well. So we're aware of certain maybe sensitivity points or things that we may not otherwise know because we're not within that community.
That's such a beautiful point, Jane. I always think that it's good advice when you are working for or with a community that is underrepresented or non-dominant in the culture to turn first to the experience and information available from that community that is being offered. And I know that, Jane, we did want to share with everyone in this presentation today that while we won't be discussing anything incredibly graphic, these are emotional topics, and we don't know what people's personal stories or experiences are. And so if something we're talking about becomes, too emotionally loaded for you, we invite you to
to step away, turn off the audio for a second, and tend to yourself. This is a self-care and boundary respecting place.
Thank you, Sarah. I think it is important to note that. Okay, so we're going to dive in a little bit, and we want to start off first. Can we have a slide change, please? Slide change. And we want to start off by discussing a little bit of who we're talking about. Who do we mean when we say 2SL LGBTQ community in the first place? I know there are many acronyms that are out there. We just don't know, not all of us know what they stand for. And quite frankly, it's a little bit intimidating, like caps, right? So many letters in caps. And I feel, we all recognize caps mean screaming a little bit. And so we're a little bit intimidated by that. So can you explain a little bit to us and where we can find the resources, Sarah?
Absolutely. First of all, if you find it overwhelming or you're confused, you aren't alone. It is an evolving creature. It is something that has continued to grow and evolve as people's understanding of their identity and their ability to describe that identity and find like members of that group has evolved. And in the, I'm going to get the pointing. I don't know which way it is on your screen, but in the slides, we have provided one resource. The rest of the resources we'll be providing after, but I do want to point everyone towards GLAAD, which is an advocacy organization. They have a wonderful reference term page that they keep pretty updated. Because whatever I go over today is not going to be comprehensive today, and it's certainly not going to be comprehensive in 6 months or a year. But real fast, because I don't want to get too long into the details, I want to just quickly acknowledge that most people probably know the LGB and even the T. Most of us know that L stands for lesbian, and that lesbian is a person who identifies as female, who is romantic or sexually attracted to another person who identifies as female. Gay represents, even though the term is often used as a general term, within this acronym, it represents men who are attracted to or romantically or sexually to other men. Bisexual indicates people who are attracted to people of both male and female gender. And transgender is a term, an umbrella term that encapsulates everyone who does not identify their gender as the gender they were assigned at birth. And we'll get a little more into that in a second. But I want to talk about the 2S and the Q. I think many of you may know that the 2S stands for two-spirit, and that is a term that was chosen by, I believe, a council of Native American leaders to represent the broad spectrum of non-heteronormative identities that have existed in the wide variety of different tribes and cultures of the Native American communities. And so sometimes that term is used loosely as LGBTQ, but Native. It's really more expansive than that, and we'll provide a link in our references for anyone who's interested in going down that rabbit hole. And it has been moved to the front of the acronym to acknowledge the way in which Native people have been displaced and suffered an additional burden, especially Native people of the LGBTQ community. And then, well, I'll take a break and let Jane bring me around to the next point.
So sometimes I get a little bit confused, and I'm not alone, about sort of grouping this gender identity and this sexual orientation together, within this community. Is there a difference? Can you explain to us what the difference is?
Yes, let me explain both the term queer, which I left behind when I got a drink of water, and that difference, because the term queer embraces both gender identity and sexual orientation. And a lot of our attendees today may be uncomfortable with the word queer, and that is
absolutely fine. For many of us growing up, the word queer was used as a slur. It was used as an insult. But to a large degree, the LGBTQ community has kind of reclaimed the word, and many people enjoy using it because of the way it is a blanket term. I don't have to share with you the specifics of my romantic attraction, my gender identity. I can just let you know that I don't fall within the heteronormative gender or sexuality identity. So that's what the Q stands for. A lot of times in the past, it was thought to stand for questioning, but that's kind of been phased out. People don't generally use it to mean that anymore. But that's not what you asked, Jane. Gender identity and sexual orientation can be so confusing because for much of my life, we conflated the two. We said that if your gender identity was more masculine, then you must be attracted to people who appear more feminine. We confused outward presentation with inward understanding. And we thought that outward presentation was a signal of who a person was attracted to. So we had the traditional, Dick and Jane from the 1950s, girl boy reading books of the man and the boy and the girl. And if you wore feminine clothes, then you were trying to be a girl. And if you wore masculine clothes, you were trying to be a boy. And if you were born and the doctor said, it's a boy, and later you're wearing feminine clothes, then you're transgressing culture. But we still understood it as one thing. These days, we understand that it's not black and white, and it's not even a spectrum. It's more of a smorgasbord that we can, flip over and understand all sorts of different points on. So someone can know that inside themselves, everybody on our call right now knows that deep inside themselves, they have a sense of being female, being male, of not feeling any connection or identity with gender at all, of having a connection that is a combination of those three possibilities, or having an identity that can vary day to day, may feel strongly female one day, strongly male the other day, irrelevant other days. Some of these people may identify that outwardly or may just be an inner experience, but that would be gender identity. It's about who you know yourself to be and how that feels relevant to who you are. But that is not at all relevant to who you want to hold hands with when you're walking down the beach, who you had a crush on when you were in the 3rd grade. And those romantic feelings and physical feelings are what we tend to call sexual orientation. And I tend to use the word romantic attraction and physical attraction more because it is for everyone more than just sex. But that is what we are talking about when we talk about gay, lesbian, bisexual, and some of the others that aren't included in the main acronym.
Okay, so because we're lawyers, we want to get the facts straight. We want to figure out what it is that we're talking about.
Define the terms.
You define the terms. The next thing I wanted to talk about a little bit is, again, to foreground this conversation that we want to have today, is a little bit about the history of the legal history of this community, what they have faced. Can I have a slide change, please, Daphne? So in Canada, it's actually only been about 19 years that Civil Marriage Act came into force. So it's really, 19 years ago, I was already an adult and working, and, it's really within our generation. And in Ontario, a couple of years prior, the first gay marriage was performed. And disturbingly enough, I think, in 1969, we saw decriminalization of same-sex sexual activity with the amendments to the criminal code. And in 1995, the Supreme Court held that sexual orientation was analogous to the group of the grounds of discrimination enumerated in the Charter. So again, I just want to sort of describe how recent some of these changes are that have affected the community that we are trying to embrace today. So in 2001, M versus H case established that laws that treated same-sex couples differently from heterosexual couples were unconstitutional, which was a significant change for support issues that we deal with in family law. And in as recently as 2017, the Canadian government started issuing passports with female, male, or X gender categories. And because Canada was one of the first countries to embrace equal marriage, we also became one of the first to consider the particular challenges associated with the need to divorce. So, you know, until 2005, the Divorce Act had defined spouses as a man or a woman. Therefore, people who were able to get married couldn't seek divorce until then, until there were amendments made to the Act to define spouses in a way that we are now seeing today. And again, these changes are very recent in the US as well. So I'm going to ask Sarah to describe some of the changes.
Yes, here in the US, I'm a little jealous of, even though it seems so recent, these changes have been much more recent in the US. For example, I think you said decriminalization of same-sex activity, while one of the first states in the United States decriminalized same-sex activity in the 1960s. It wasn't until 2003 when the Supreme Court struck down Texas's laws in Lawrence v. Texas that same-sex sexual activity was decriminalized for the entire nation. And similarly, it wasn't until 2015, which I'm sure many people remember, when the Obergefell v. Hodges decision established that same-sex marriage was a fundamental right.
Okay, so again, we're talking about a community that has recently undergone changes that have allowed them to feel accepted, allowed them to feel part of the greater community. And there's a sense of harm that comes from that, from having felt marginalized, having felt not within the dominant culture. I know this anecdotally, obviously not as a personal experience. So I'm going to ask Sarah again to share, not necessarily all your personal details, but, you know, from a little bit of a different perspective than I might have. Can I have a slide change, please?
Absolutely. No trauma dumping in this presentation, but you know, being in a group that is outside the cultural norm can impose harm on any community, and the LGBTQ community is no exception. And even though we think 2003, 1969, those changes are so established, we want to be able to just move on and act as if everything is normal now. That isn't necessarily the way our LGBTQ clients are and have experienced their life. So I know that a lot of times when people are talking about the divorce or separation of a couple, we use the example that, you know, this may have been the marriage that one of the spouses has been dreaming about since they were a little girl. Well, when you're working with LGBTQ couples, when they were little people, little girls, boys, children, they were not allowed to dream of their future. Their future was not visible. There were no examples of that dream. And so that comes with a harm that sticks around. There's a hidden harm that can come to not belonging to the dominant group. So, and all of these harms have accumulated over someone's lifetime. So if we have a client who is in their 40s or 50s, and they've been married 10, 20 years, depending on where they live, we may think, okay, no big deal. They've been married, it's been established. They're not suffering the harm of our culture not allowing marriage for LGBTQ folks. But these are also people who were in their formative years during the AIDS crisis, who were alive when women were regularly institutionalized for same-sex sexual activity, at least here in the US. I was telling Jane while we were preparing for this presentation that I remember in the 90s hearing of gay men during the AIDS crisis who would adopt one another, that one of the men in a couple would adopt the other man in the couple because it was the only way for them to ensure that they had medical access should one of them get sick, that they had rights of inheritance, rights of decision making. And those are really hard stories to hear, especially for those of us who pass our day to day in the dominant culture. And, even though I'm a blue-haired lesbian, non-binary person, I lived most of my life passing pretty well in dominant culture and not experiencing that harm, but it is still inside of me, that knowledge that those extreme measures had to be taken. So your clients are coming in with those wounds that they've been walking around with, even if they're not something that you see or that you've experienced.
Or they may not even acknowledge, right? I mean, not in a way that we can respond to. I think the reason why, I think it's important, again, to have these conversations is just to be a little bit aware of the possibilities of, the kind of sense of shame that you're describing that they're walking around with that they themselves may not be aware of, certainly not acknowledging to you.
Right. Shame is a really big issue for all of us, in my opinion, but certainly within the LGBTQ community, because many LGBTQ adults, in fact, some would say most LGBTQ adults did not grow up in families or communities or institutions that were embracing or even tolerant of who they were. And so that experience of being shamed by culture, shamed by family, and shamed by community may be something that they're no longer dealing with because they have found a new culture, they have found a new community, they've formed new families. But that impact is still there. And it can often lead to internalized shame, which doesn't always show up the way we think it does. And it can create real pain and complications in gender roles, even within same-sex relationships, hierarchies within LGBTQ communities that are based on heteronormative, hyper-traditional gender role ideas. And it can really create some harm and some pain.
Yeah, and when we talked before, Sarah, you talked a little bit about how they present as opposed to, what they are masking inside, that some of it being a sense of shame, but there's also a sense of anxiety, right? That
Yes.
Hope that they can actually let their guard down. There's a sense of anxiety that always plagues one when one has these kind of deep-rooted emotional feelings.
Yes, I think we did talk a lot about masking, and I think that idea of needing to put on a mask is something that everyone has experienced, but isn't something we talk about a lot. And it's something that affects non-dominant cultures and the LGBTQ community quite a bit to varying degrees from person to person. So if someone feels at home within a community of others like them and they fear that they might be not welcomed or treated with some harm in community, in the dominant culture, then it's pretty typical for people to adopt a mask of behaviors that make them feel more safe, less threatened by potential harm in the dominant culture. And I think the example I used with Jane the other day was that, you know, as female presenting people, as women, we are used to the idea that if we're walking home late at night in an urban environment by ourselves, there's a heightened sense of awareness of threat. And there's also a need to portray a certain amount of confidence, a certain amount of ability, and a certain amount of support. So we might walk quickly with our shoulders back and talking on the phone so that any potential attacker knows that we are not going to be an easy target, and that somebody is paying attention to who we are. And I think that the non-female members of the audience can probably also identify with a moment when they had to put on an identity, to project an identity to make sure they felt safe. Well, someone in the LGBTQ community who feels like they might be at a disadvantage when they are in a very traditional environment or an environment with an unknown group of people, or an environment where they feel ill at ease, like a courtroom or a professional office or a doctor's office, anywhere where there is status involved, where there is that fear of the unknown specialized area. For me, it can be even going to the grocery store if it's crowded and there's more of a certain demographic present than others. And it doesn't mean that that person is going to, you know, put on an entirely different personality, but they might make sure that none of their facial expressions are very vivid. They want to fade into the background. They want to appear just like everyone else and not draw anyone's attention. And the reason we need to be aware of that and be mindful of it is because it costs a lot of energy. It's very hard. As anyone who has walked home late at night with all of those guards and presentations up knows that at the end of that experience, you get home and you're, oh, thank goodness I'm home. That was so stressful. I'm so relieved. I feel exhausted. Well, when a person in the LGBTQ community is in an environment where they feel like they need to mask, it is more exhausting than it is for a person who doesn't feel the need to mask in that environment.
Thank you, Sarah. Gives me again things to think about while I am, having a dialogue with my clients. I want to sort of draw the line, though, of understanding a community and then also describing that community in sort of that othering kind of way. I'm always very conscious of this othering kind of thing that we do sometimes, and sometimes I hear it, well, those people, this and that I have experienced somewhat racially, so I can relate to it somewhat. So I just want to talk a little bit about being very careful or very mindful that that's not what we are intending to do.
Yes, the best of intentions, right? And othering or noticing your own tendency to other, and policing that and kind of finding a new way to connect and relate is one of the best ways that you can non-verbally communicate to your LGBTQ clients that they are safe to let down those masks. So when we talk about othering, we literally mean just treating someone as the other. Our little group, our understanding of the world is the norm, and this person is part of the other. So, if we say, oh, this person's coming in and they are a trans individual, so everything is going to come from this lens of exactly how I treat trans people because they are not like normal people, they are other. That can be really harmful, even from the best intentions. And the best example is oh, sorry, I was thinking of something else, but that it can be really harmful. It can really communicate a lack of connection, of understanding, and of empathy. So when we are thinking about and understanding the LGBTQ community from a standpoint of wanting to serve our clients, we aren't wanting to serve them because they are something other than our clients. They are just like everyone else. They are just facing different issues and having similar pains, similar hopes, similar fears in different ways. And so I think the opposite of othering, I was reading in one of the resources I think we provide, is belonging. And so the more you can connect to the idea of helping focus on the way someone belongs, not the way they're normal, not the way they're just like everyone else, but the way they belong here as much as anyone else, the more you avoid that accidental othering of someone that doesn't look or sound or present or live the way you do.
Right. Like most things in life, it's a question of balance that you're going to strike with the information that you have. I think there is a particular kind of way that the community has developed, though, especially when we talk about marriage and divorce. You talked a little bit about sort of dreaming outside the dominant culture, having dreams that didn't quite fit into that culture, and that does carry forward, right? So I think that you and I talked about then what does that mean for them when they are faced with, failure of marriage, which I wouldn't call it a failure, but many people do look upon it as a failure, and how acute that sense of failure is something that I actually didn't realize before I spoke with you. Can you talk to us a little bit about that, some of the things that you've talked to me about?
Absolutely. So, when we absorb these stories from childhood, when we're told from childhood that the people we want to love, that the experience of loving someone of the same gender, the experience of identifying differently as the gender the doctor assigned at birth, that makes you an abomination, or that any relationship that follows that model is doomed to fail, or not a valid relationship. Even though we might fight against those ideas, we might push back, we might reclaim our own understanding of self and our own understanding of identity and culture, it's hard to completely erase those voices, those echoes within us. And so that can lead to some of those internalized homophobias, internalized gender phobias that we talked about earlier. And the result of that can come out a lot of different ways in LGBTQ marriage and divorce. I think on the slide we're on currently, there's the final note about the higher incidence of intimate partner violence in the LGBTQ community, which is really unfortunate. The data on any intimate partner violence is always less full than we would like it to be. But in general, within the LGBTQ relationships, there is a higher instance of intimate partner violence. One of the reasons for that is that if you are an LGBTQ teenager and you're sitting in your school sex education class where they're teaching you about heterosexual reproduction, they're teaching you about STDs from a heteronormative standpoint. They're teaching you about everything that's coming up presumes heterosexual attraction and orientation. And what happens is a lot of teenagers will just tune all of it out. So when they get to the point of talking through red flags in relationships, emotional relationship ideals, the lessons that we try to teach our youth so that they will be informed and aware and hopefully notice red flags for intimate partner violence before it occurs. A lot of times these teens aren't getting that information because everything we've fed them is so irrelevant to their experience already and their future already, that why would they be listening to that part? So that can be one really harmful outcome of that difference between cultural norms and the way that these ideas can linger from childhood and youth.
So can we even suggest that when we do our IPV screening, as we all do in our practices, we pay particular attention? It's not a foregone conclusion that it's going to be present in a relationship in this community necessarily, but is that something that you might recommend, Sarah?
Absolutely. And also there are some cultural assumptions that can work against our usual awareness and screening for intimate partner violence. Until maybe the last 10 years, there was this cultural idea that in a relationship between two women, there could not be intimate partner violence because women weren't violent, or because one woman couldn't be controlling of another. There can also be a cultural norm that in a relationship between two men, some physical roughness is just par for the course. And, far be it from me to speak to everyone's relationship and what is consensual within a relationship. But there are certainly many people whose experiences were denied because they were told that's what you signed up for, or that can't really be true. The same way that in the past, men were often seen it not to be a possible victim. So that can show up as well. So when screening, I think just notice your own biases and try to pay attention with a real clear head.
Okay. Again, as Sarah mentioned, we don't have clear data on this. This is what we have been noticing in the resources that we've looked at. But there are differences also in a very positive light within queer culture and marriage, right?
Yes. Okay, so are we skipping? Sorry, I got lost in our presentation. Yes.
No, because we were so engaged in our own.
I know. I get really excited about this stuff. So thanks for giving me a second to catch up, everyone. Yes, this is the great news. This is the silver lining. So the thing is, we've been talking about all of the hard, the way that the LGBTQ community a lot of our LGBTQ clients have come to us having experienced a lot of hard things, and that can result in some trauma and some pain that we may not otherwise be presuming. But the upside of this is that the LGBTQ community has been so creative and compassionate that they have really developed some wonderful cultural norms that can really benefit our clients and really benefit us as we begin to learn from them. So the LGBTQ community has a very, very strong and long history of chosen families. And many of you may have heard a lot about the idea of chosen families. And of course, like many of the best things, it has sad origins. Many LGBTQ people have very strong chosen family networks because their families of origin were not accepting or had kicked them out. But what that means is that as opposed to happens normally with our heteronormative clients, when our LGBTQ clients come in, they may have a stronger network of support around them. And they may have someone who is a best friend or an ex or a neighbor or a former roommate that has the same kind of support and closeness and love and compassion that we might think of from a sibling or a parent. And so it's really wonderful. I hope you get to experience some of those relationships and how supportive and powerful they can be. The other silver lining is that a lot of our LGBTQ clients have gone through some of the hardest conversations they might ever have in their lives. I'll paraphrase it to make it a little more palatable for a business environment, but there's an LGBTQ columnist, Dan Savage, who started the It Gets Better project. And he liked to say, when you've sat down with your mother and had a conversation where you tell her that you are romantically attracted to someone of the same sex, there is no conversation you can't have. And now as our culture changes, there are LGBTQ teenagers who have not been through those hard conversations because their families are so supportive and embracing, like Jane. But for some of the older LGBTQ adults, even those with accepting families, most of them have already gone through these really hard conversations. And so they're a little more capable of navigating some of the hard conversations that inevitably come with transitions and marriage, with custody conversations. And so that can be really inspiring to see the flexibility.
Yeah, so which makes it obvious that they're very predisposed to collaboration and mediation practices that you and I have. And I do find that they're ready, they're prepared to have these discussions. I don't have to convince them that it's worthwhile. I don't have to convince them that there is light at the end of that tunnel.
That's right.
The other thing I see in my clients is that there is this insistence on co-parenting, and sometimes that co-parenting involves multiple parents, right? Children from exes, and they don't want to leave them out. So then we have these multiple parenting schedules that we have to combine. But for this community, it's an important sense of belonging that they have to share with their community, their chosen family, as you described.
Yes. And certainly what we are talking about doesn't apply to every single person, but it is more present in the LGBTQ community to be able to freely navigate non-traditional family structures. There's less of an expectation of failure if the family doesn't look like, the mom, the dad, the 2.4 kids, and the dog, and the 2 cars in the garage. You might already have a more non-traditional family structure. I just had dinner last week with one of my dearest friends and his partner, and they had spent the day out on a boat with the lesbian couple for whom one of them had been the donor for their children. And so he has had a kind of an uncle kind of role in their lives because they wanted him to stay involved. And the children know that he is their biological dad. They have a really close relationship. He's the default caregiver. They spend a lot of time together as an extended family. His parents have a extended family, almost grandparent-like relationship with the children. And it is just the most beautiful example of the fact that there is no limit to the capacity of love. And so I think because within the LGBTQ community, there are so many more examples around us in our community of non-traditional family structures, I think it's just less of a hurdle to overcome in the co-parenting, divorce, custody conversation.
Okay, so I think it's almost time to wrap up. I want to talk about, I know it always flies by when I'm talking to you, Sarah. So I want to talk a little bit about creating on a practical basis a safe space for our clients.
Absolutely.
Yeah, so I want to talk about maybe infrastructure that physical infrastructure, and then maybe other things that we could implement in our practices.
Yes, and I'm going to go through these pretty quickly because we did provide some excellent resources in our resource sheet that I think everyone will get after. The first thing everyone thinks about when providing a safe space for LGBTQ folks is unisex bathrooms. Okay, of course, right? Which is not something everyone has the ability to do. But if you are designing your own space or you have access to unisex bathrooms, even if you are offering them to people whose gender identity you think you know, offering that unisex bathroom is a way of communicating, I have respect for your gender identity. My office environment respects your gender identity as you understand it, and we're not interested in imposing our impressions on you. And so that's always really helpful. We also talked a little bit about updating office forms, and this is the worst because we have so many forms and we forget about forms, we forget about documents that may have slipped through the cracks. So I was telling Jane, I thought this was a great task for that summer clerk, that summer associate, to just send them through each form, each standard document, looking not only for pronouns, but for titles, Ms., Mr. There's a gender inclusive title that some non-binary people use, which is MX. And then just adding an other option for anything that's gendered is a great way to be inclusive without having to know what the latest favored jargon is or be worried that the latest favored salutation might change. Not assuming husband and wife, changing your documents to say spouse one, spouse two. And then, asking for people's pronouns, adding a space in that form for pronouns for preferred name, and always leaving that other option there so that they can self-determine if needed.
And then beyond the forms or offices, I know that we mentioned here in the slide thinking to give clients a heads up, just because sometimes we can't control the documents that, that come from our court or some kind of third party, right? To communicate that we are aware, and to communicate to our clients that that we are sensitive to their sense of wanting to feel embraced.
That's right. Right. If you have a document that comes from the court or from another firm or from a vendor you're using, and you know that that document, or you suspect that document may not be up to date, then just letting your client know, I don't have control over this form, and I'm pretty sure that it may assume heteronormative gender, or it may say husband and wife instead of spouse and spouse. It doesn't change the form, but when they go to fill that form out, instead of just feeling that negative, icky feeling of this world, has erased me, they also have that supported, embracing feeling of this world has erased me, but my attorney sees me and my attorney has my back.
Exactly. Also training our staff. I mean, it's great for us to be involved in this, but I know at my firm, there's the intake team, there's the accounting team, there are many other people. So we have continued internal dialogues about how we serve all our clients, but, LGBTQ community.
Absolutely. In fact, if your office has a receptionist or a paralegal or an assistant that is at the front of the office where people enter, that person is going to probably have the biggest burden of making the first impression for your LGBTQ clients. They're the person who is going to be asked, where are the bathrooms? And if I come in and that person says, okay, she's presenting as female, I'm going to tell her where the women's restroom is and not give her the rest of the information, it's probably not going to offend me, because I usually use the women's restroom unless there's something really wrong. But if that person says, it's so nice to see you, Sarah, there's a women's restroom here, there's a men's restroom here, and we have a unisex restroom down this hall, what they've done is communicate to me that they are a gender inclusive space. And so even if it might not apply to me, I know that it just communicates that they're safe, that they're not othering me.
Yeah, and I just want to talk or touch on this pronoun habit. So I think new habits can be learned. Lord knows I make a lot of mistakes, even though I'm always trying. And I feel very, very badly when I make those mistakes, but I do keep trying. And I think it's important to communicate that we're trying, right?
Absolutely. You don't want to make it all about you, but you do want to communicate that you're trying. And everyone makes mistakes. Everyone adjusting to something new makes mistakes. And what's more important than getting the pronouns right is trying to get the pronouns right. And if you get it wrong, that's not that important. If you say, oh my gosh, I'm so sorry, I said she and I meant they, and then just move on. Don't have the person then have to spend their time and energy consoling you and making sure you feel okay. Just own up that it was a mistake, and you're so happy to support them by getting their pronouns right. When you can, people appreciate effort. And if you do happen to run across someone that, just has a big reaction to being misgendered or having a wrong pronoun used, remember that it's not about you. It's not about your one really unintentional mistake. It's about the 27 other people that week who maybe did something intentionally. And so you just giving them a little grace can go a long way.
Okay, thanks so much, Sarah, for all of that. We are running out of time, and as we mentioned in the beginning, we will be providing you with resources for anyone who is interested in doing a little more reading, talking about it. You can always reach out to Sarah or me, and in the resources that we provide to you, you'll have our contact information again. So I encourage you to.
If we have just a minute, someone dropped a question in our Q&A that I think we can just answer really fast. which is about the term queer. So this question's been sitting here for the whole presentation. I apologize. And it's just someone asking if, as a cisgendered hetero person, it would be appropriate for them to use the term queer. And I think that it's really it's really a matter of reading the room. If I were representing someone in a legal situation and I didn't know them and I hadn't heard them use the term, I probably wouldn't use it with them. If you're working with someone who does use the term queer, I use the term queer, I identify myself as queer quite a bit, then I think it's a matter of knowing your own comfort. There's no need to try to adopt that term if it doesn't feel natural coming out of your mouth. And if it does, then you can always just check with the person. You know, that's never a bad thing, is to have curiosity and compassion, and just stay in communication about these things.
I think we don't have time to address the other questions, but again, I invite you to please reach out to us. We're happy to provide you with, I don't know, fodder for thought, if nothing else. But thank you again for being with us. Thank you, Sarah, for having this conversation with me.
It has been my pleasure. Thank you so much, Jane, for inviting me to be part of this.
What a great presentation, Sarah and Jane. Thank you so much. So informative.
Okay, I think we're going on a little break, right, Daphne?
Yeah, that's right. Thank you so much again.
We've got some housekeeping matters, but thank you guys. We're just going to do a quick housekeeping update, and then it's going to be lunchtime, right?
Yes, that's right.
All right. And welcome back, Shannon.
Thank you. And thank you so much, Sarah and Jane, for that very important discussion. It was very, very insightful and moving. So we really appreciate that. And also thank you to all of our audience members for tuning in and your commitment to learning on this topic. Really appreciate it. As Russ mentioned, we are going to go to a lunch break so everyone can get some food and refuel. So we'll be back at 1 p.m. with a presentation on CBV reports with Melanie Russell and Jason Klukowski. So we'll see everyone back at 2 p.m. I think I said 1 p.m., but I meant 2 p.m.
We do have an update, right? I want to thank the speakers. A couple more anonymous donors. Thank you so much. Jonathan Paynter, thank you for the donation. Carrie Heinzel, Revander, thank Bridgeport for the additional support this morning for the Denise House. And I think Shannon will put a link in there. We were close, 95-15 last time I looked, right, Shannon?
Yes, you got it.
So we're almost at the $10,000 mark. Sir, we're going to get over the hump this afternoon. Great presentations this morning, so informative. Really looking forward to this afternoon. And what's the plan? Back at 1 p.m., Shannon?
Back at 2 p.m.
2 p.m. But we're going to leave this link open and you can stay on or come back on, right?
Yep, it'll be the same link.
Great stuff. So we'll see everybody this afternoon. Have a great lunch.
Okay. See you, everyone.
Sleep till I come home. Thank you for joining our third
Hello, Michelle. Welcome back.
Hey, Shannon, nice to see you.
You too.
What a great day. Sorry, go ahead.
I was just going to say I tuned into your session this morning on risk factors for family violence with Jonathan and Amrit, and it was, it's a very difficult topic, but you guys did a fantastic job of providing really great resources. So thank you for that.
Thank you so much. Next year, can I suggest an hour and a half for our topic?
Yes,
We
yes.
could be gone for another couple of hours.
An hour is never enough, is it?
It is never enough, but it's good. Hopefully I'm a little worried about the 100 pages of materials we're going to be giving everyone, but hopefully.
I'm sure everyone will be very grateful for those resources.
Excellent. Well, I'm excited about today. I know we've got a couple of great people coming on board.
Yes, we have Jason Kwiatkowski and Melanie Russell, who have been on our program several times before, but they have a couple of new presentations for us. So I'm excited to hear from them and get some insights on CBV reports and then also attribution of pre-tax corporate income. We have back-to-back presentations with them.
Oh, those poor things. We're making them work too hard.
I know, I'm so grateful to all of our speakers. We have quite a few actually who have done multiple presentations. So very appreciative of everyone sharing their time and knowledge with our audience today. Hi, Melanie.
Hello, good afternoon, everyone. Some great
Welcome.
sessions this morning.
Yeah, you've been on since 9 a.m., Melanie. I saw you.
I know. I'm not even tired yet. They were so excellent.
That's amazing. How much chocolate and or coffee have you had today?
Only one, but I didn't technically need any because the sessions were so good.
Wonderful. I'm excited. Well, I've had more than one coffee today already myself, so you're doing better than me.
I am also guilty of that. So we'll take just moment here just to let everyone log back on from lunch, and then we'll get started in just a moment.
Wait, you let people have lunch today? Look at you.
I know, right? We're letting them have 15-minute breaks, lunches. We like to take care of our audience and our speakers.
Well, that's excellent. And it is amazing how many people we have in attendance. Thank you all for joining us. It's so great. We really appreciate everyone taking the time and coming out today. And yeah, it'll be great. It'll be a good topic. I'm actually looking forward, Melanie and Jason, to learning about the topic as well as we do the discussion. So you'll see me taking my notes. I'm always taking notes.
Excellent. Well, we'll look forward to your feedback as well.
I'm sure it'll be amazing.
Hey, Jason.
Welcome, Jason.
Hello.
Hey,
How's
Jason.
it going?
Good. How are you?
Good. Sorry, I had some problems figuring out the background and getting connected, but I'm here.
You're
No big
here.
deal at all.
Welcome.
We've been chit-chatting.
So on that note, I'd love to take a moment here to introduce Jason and Melanie, if you haven't met them before. So Jason Kwiatkowski is a founding partner and the president at Valuation Support Partners Limited, a professional services firm specializing in providing the business and legal communities with business valuation, litigation support, and exit planning advisory services. Jason is an independent financial neutral and has completed numerous business valuation and expert reports, including income assessments for various purposes. Jason has testified before the Ontario Superior Court of Justice as an expert witness in business valuation and damages quantification. Jason has authored many articles and spoken before various professionals and business groups. Next, we have Melanie. Melanie is the founder of KLX Partners Incorporated and began professional practice in 1985 at a large international accounting firm. After moving from the audit group into the financial advisory service group at the large international accounting firms, she developed expertise in various areas, including valuation, dispute analysis and resolution, forensic accounting, succession planning, and transaction support. Her clients include a variety of private and public companies of various sizes and across many industries. Melanie placed second in Canada on the CBV Institute, CICBB, membership qualification examination, and she founded KLX in 1996. So welcome to you both, and we have Michelle returning back here to moderate the discussion. And I'll just quickly go over the agenda, what you can expect to learn over the next hour. So Melanie and Jason will be discussing CBV's role as financial expert in matrimonial matters, discussion of the CICBB and the professional standards, types of report mandates for the CBV, types of CBV reports, the process, usefulness, appropriateness, and potential cost. And lastly, we have joint retainers with CBVs, the pros and cons. And as always, we'll try and reserve as much time as we can for audience Q&A as it comes in. So on that note, I will let you take it away, Michelle, if you have any opening comments, and then pass things over to Melanie and Jason.
Thank you so much. No, Jason, you missed it. I was just saying thank you so much for being here today. I'm excited. I'm looking forward to learning from you. You'll see me taking my notes. So why don't we get started with a poll, because we love our polls here at RIA. So our first poll is, what experience do you have with CBVs? A, no experience. B, some experience. C, great experience. D, what is a CBV? And E, other. So why don't we actually start with that? What is a CBV? Who wants to take that one?
Sure, I'll take that one. So CBV just stands for Chartered Business Valuator, and it's typically the people that get their CBVs have gone through another program. A lot of them are CPAs, CAs, but doesn't have to be, but they often have another designation, and they've generally specialized and had a certain amount of years or hours of experience. And they also take a bunch of courses and then have to write a final exam, which coincidentally was just yesterday for the 2024 CBV hopefuls.
Wonderful. Well, good luck to everyone who wrote the exam today. All right, let's see the results of our poll. Well, it's just taking a minute. Oh, there we go. So we have 46% have some experience. I'm also in that category. I've had some experience, but not a ton. 11% great experience, 32% is no experience, and 11% is what is a CBV. So I'm so glad we did that question first. So why don't we jump right into the next topic, which is the discussion of a CBV's role as a financial expert in matrimonial matters. And I think, Melanie, can I pick on you to do that one?
Sure, pick on me anytime.
So you're going to regret that.
Yeah, exactly. Well, and in the spirit of collaborativeness,
yes.
if that's the right word, Jason, I'm going to invite Jason to jump in and add things, correct me, and talk about his experience in this too. But there's a lot of different ways that CBVs can get involved. And we like to stick, of course, with the financial side. So there's the typical, on the equalization, the property side, the valuation of things. That may be a business interest, whether it's somebody owns 100% of a company, they own a small part of a company, they have a joint venture interest, a partnership interest, a sole proprietorship interest, so some business interest. But it can also extend to things like more complicated issues, things like stock options or tax liabilities, contingent or otherwise. So that's sort of the property side. We'll also get involved in the income side if there's either child or spousal issue, and how much is that person making pursuant to the guidelines, and other considerations. We may also get involved in things that kind of buttress either the property or the income piece, which could be tracing analysis. So, they say that there are these business interests, but maybe there's other stuff, that other bank accounts or other things that is not being or there's a concern they're not being disclosed, or inheritances. Also can be for things like supporting the income analysis. So on the tax return is this, we see this per the financial statements, but there's some concerns that maybe there are other assets or other sources of income that aren't being disclosed. So we might get into lifestyle or other net worth type of analyses. Jason, did I miss anything?
No, I think that's a good summary. I mean, the only thing I would add for the sort of kickoff intro topic is that just to keep in mind the CBV is a specialty role in matrimonial matters, as opposed to, there are certified divorce financial analysts who tend to get involved in all different types of financial aspects of a separation. You really only bring a CBV in to the situation when there's a business and the business needs to be valued, or like Melanie said, stock options and that type of thing. Or on the income side, when there's a business and you need an income assessment for support purposes.
Excellent. Thank you so much. So can you talk a little bit about joint capacity versus non-joint capacity, how that works, pros and cons?
Joint reports?
Oh, yes, joint reports.
Okay. Jason, do you want to kick off?
Yeah, I mean, this was just meant to sort of be an introduction. We're going to talk about joint retainers, sort of our last topic today, but just to sort of keep in mind that, using a CBV in a matrimonial separation, you, a lawyer representing one party, the husband or wife or one spouse, you can retain a CBV for that side, or you can get together with your counterpart on the other side and you can collectively or jointly retain one CBV instead of each retaining a different CBV to prepare reports and prepare critiques and stuff like that. But just to be aware of that as an option or an alternative, and we're going to talk a bit more about that later.
Awesome. Sorry, I don't want to step on your toes. Excited by it. I actually have a couple matters right now where we have joint reports being done. So I'm excited to hear your analysis of it. But why don't we go into our second poll? In your experience, how long does it take typically for a CBV to produce a report? Same day, 1 to 3 months, 3 months to a year, between 1 or 2 years, and other. So we'll just wait 1 minute for that to go, and then we'll see the results as we let people in. Wouldn't it be nice if we can get them done in the same day?
Well, funny enough, I'll just jump in here. I was on the phone with someone, this is a tax-related matter, yesterday, and they were trying to decide whether they needed a valuation or not. So we ran through, and in a couple of hours, I told them what the issues were and what I thought the range of value could be, so they could decide whether it made sense to go ahead. So in theory, some analysis can be done, but let's see the answer to those polls.
All right, let's see what our audience thinks. Okay, vast majority, 1 to 3 months. 37% of us think 3 months to a year, 3% between 1 and 2 years, and 10% other. All right, so what is the answer? And of course, there are typical cases and of course, non-typical cases. So just in your typical case, what's our timeline looking like here?
To get a report done, it really depends. But I think most people there were saying the 1 to 3 months. I think that would be most people's experience on average. And that would certainly be my experience on average as well.
And I'll just jump in there and say that ideally should work, but the challenges you get and I think a lot of them were talked about this morning, but things like complexity when there's a lot of different businesses or a web of complex organization structure, but also the ability to disclose and the desire to disclose and be transparent. So sometimes evaluators, you may think it's the evaluator taking a long time, but it may be often it's because we're sitting waiting and trying to play that disclosure waiting game. And when do we go ahead and make assumptions, or how long do we wait to get disclosure?
Absolutely, I'd agree with that. I mean, if anything's going to hold up the process, it's getting us the information we need. And sometimes that can be a lot more challenging or difficult than you would think.
Yeah.
Yes, well, don't worry. As a family lawyer, I get to hear all about it because if someone isn't doing a report, I'm calling Melanie to say, okay, who's the problem here and how many motions do I need to bring? So
Yeah.
yeah, we understand as lawyers, we get that you obviously cannot produce a report without the source documentation. And sometimes clients are unwilling or unable to produce that for whatever reason.
Yeah, and then I guess another point with that is that sometimes the clients don't understand what's involved, and a great way to kind of let them know right ahead of time that this is like a mini diligence. It's not going to be as if someone was looking to buy the company, there'd be way more diligence, but we still need a fair amount, and so you can't just look at a set of financial statements and say, here's the numbers, but clients often don't understand. They think we have ESP and we can figure it out without anything on paper.
And how many times do you get that client who says, oh, it's all super easy, just call my accountant, and you call the accountant and you say, yeah, this is a mess. They've filed and refiled and done so many structuring.
Or you call the accountant and the accountant says, we're going to have to talk to the client about that.
Yeah, I haven't gotten instructions.
Well, and that's an excellent point that Jason's bringing up because, and Michelle's bringing up, because people, I will say the movement often is to reduce the amount of fees you want to pay to accountants, right? They want to do, whether they want a compilation or maybe just the tax return. And that means that the accountant's doing a lot less work and doesn't have the same, or shouldn't have the same knowledge that someone who does a review or an audit. But then as soon as something goes wrong and they need documentation, it's, oh, the accountant must have ESP, even though we never retain them to do much, but they must know everything about my financial position, which isn't the case.
Yep.
Absolutely. All right. So why don't we talk a little bit about the CICBV and the professional standards? First of all, what is a CICBV?
Yeah, I'll take this one. So the CICBV is really just our governing professional body. It's the Canadian Institute of Chartered Business Valuators, or they like to be known as the CBV Institute now. And I think this is not something we want to go into great detail, but the main takeaway here is just to be aware that when you're retaining a CBV, CBVs must follow the practice standards and the code of ethics of their professional governing body, the CICBV. I mean, these standards and code of ethics are publicly available for anyone to sort of look up and review on the CBV website. And they're really, just like any profession, they're meant to protect the integrity of the profession and serve the public interest with a high standard of like honesty, competence, objectivity, impartiality. So the code of ethics is, as you would think, right? It's maintaining the good reputation, integrity of the profession. It's ensuring independence, avoiding conflicts of interest, ensuring privacy and confidentiality of client information. And then you turn to the practice standards, and these are the standards that CBVs must sort of adhere to when they're doing their work, when they're in the process of preparing a report. So there are practice standards that are sort of set for CBVs to follow regarding report disclosure, the scope of the work, the amount of work that has to be involved in a certain type of report, and how they document their files. And that's for valuation reports, expert reports, and limited critique reports, which we're going to discuss in sort of some detail today.
Excellent. That's really great. We have a question from the audience, and it's a really good one. How often and how likely is a court going to make an adverse assumption when a party does not disclose the required or accurate information? And why don't you guys take this from your perspectives, and I'll also tell you from the legal perspective what I think.
Sure, I'll just jump in here, and I think from the legal perspectives, you guys see this more often than we do, and from a valuator's point of view, we have to sign the expert's acknowledgement. We're supposed to be independent, so we can't just make an adverse inference on our own. Somebody has to tell us, this isn't being disclosed. Can you please make this assumption? Now, that's fine, but we also have to be careful of if there's equally valid assumptions that maybe we need to do scenario analysis. But in that case, I think we're often directed by the lawyer to say, what does this mean? Because This wouldn't be normally what we do in evaluation.
Yeah, and I think, from my perspective, we see this a lot where we're requesting supporting documentation to sort of back up the fact that these expenses are required for business purposes or business nature, and they're not providing it to us, and we're following up, and maybe they're giving us some information, but they're not answering the question or giving us the information we need, and we're following up again, and we're continuing to follow up. And then eventually, council advises us, if they're not answering the question, make an assumption and state the assumption in the report. And then the court may draw an adverse inference from that.
Yeah, I fully agree. I actually have a trial coming up, and this is one of the issues where the other party has documentation, is the only person who can provide it and is consistently not providing it. Now, that's a joint retainer, which means that I'm seeing all those correspondence between counsel, and I can use that in my trial. Or if I needed to, if we got to an impasse where we couldn't move forward without the information, I could then go to court, bring a motion, seek my costs, seek an order for whatever I need to, or seek an order that the valuation not go ahead, or that an adverse inference be taken, and that the valuator be directed to take that adverse inference as a result of this motion. So yeah, we see it all the time. And obviously, if you're in court because you're not providing disclosure, it's never a good sign for you, for the party not doing the providing. All right. Why don't we move on to our next topic, which is types of report mandates for the CBV. And Melanie, I'll ask you to get on this one, please.
Sure. So as Jason mentioned, we have practice standards. We actually have 6 sets of them for CBV. So some of them are more commonly used in family law than others. So standard one that most of you, those who have seen valuation reports, have probably seen the 100 series, the 110, which is a valuation report. There's also a 310, which Jason referred to, which is called expert reports. And that would be things like tracing reports, income analysis, anything that's not a valuation per se. The 410 series, 400 series is limited critiques, which we have, I can provide some, I'll hold back on my comments on those, but the usefulness I think is very questionable, but they do exist. So those are the written reports, and those are, as Jason mentioned, that the CBV Institute has this box around what we're supposed to include. Now, it's obviously still judgmental what goes into a report, and we're not, it doesn't mean you can only put these things in. You can put more in, and whatever you think is useful. That's the guiding principle, is what's useful for the reader. But there are certain minimum things that have to absolutely be in there. But then there's also referred to, I think this morning's session talked about it, I think Russell mentioned it, verbal or oral reports, which aren't subject, there's no standard in the CBV handbook that says this is what an oral report is. It just says if you are doing something in writing, even by email, regardless, then it has to follow these standards. So out of default, an oral report means that you are not following the standards, but it can't be anywhere in writing. So Jason, you want to fill in a few more on?
Yeah, no, that's
reports?
really a good summary. I mean, we're going to go into some detail about the different types of reports, but this section on, what sort of mandates could you use a CBV for? Well, it's business valuations, it's income assessments, and any type of a expert report in a matrimonial setting can include like a lifestyle spending analysis or a tracing analysis, that type of thing.
Right. And one thing just to add on the business, although we talk about business, that can be expanded to sometimes even liabilities, right? Like the contingent tax liabilities would be considered to be a valuation analysis as well.
Yeah.
And depending on the, on the equalization, there may be big contingent liabilities, and it may be very helpful to have that, because you don't want to go to a trial and for the first time be arguing over what those contingent liabilities should and shouldn't be. The court's going to look at you and say, why are you wasting my time? Why haven't we had this report done well before now? All right.
Yeah, and even though the CBV is sort of a specialist or a specialty area within matrimonial, like you may need, it can become quite complex. You may need a CBV to do a valuation of a business or a number of businesses at both the separation date and the marriage date. And you may also need them to sort of identify and highlight amounts due to or from, like shareholder loans and advances, as well as the contingent disposition costs and taxes, which is the liability. But like there can be quite a number of things that you rely on a CBV for.
Absolutely. We always, as soon as we see a business, we always call you guys, but also there are times when there are multiple businesses, right? There are sister corporations and money's moving back and forth. And just for the lawyers to fully understand and for the court to fully understand what is going on here and how we've come to the conclusions we have.
Right. And just to add one more thing on that, like, and Jason mentioned the marriage date, separation date, there may also be a current date issue if it's a joint family enterprise. There may also be the fun part for the evaluators is if there's a disputed separation date too. So we even get to do more evaluations. So we love that. But the clients, when you start talking about costs and time, that's where things start increasing significantly.
Yep.
Absolutely. Are there anything special with stock option valuations that we should know about as lawyers?
Do you want me to take that, Jason?
Yeah, you can comment. I can provide some comments as well. Yeah.
Sure. I guess it's nothing special about it. Would still have to follow CBV standards, but it's maybe a bit of a different reference point from the value. So when we do, the family law talks about value. So that's open to whatever the interpretation is.
Yeah.
If you engage a valuator, we don't necessarily know what the right value is. So we typically default to fair market value, which is the initial value term that came up from tax rules back in 1971. But from a stock option, the challenge is that they're often not transferable.
Yeah.
So if you look at fair market value, that means someone else would buy it. So you might use a different term, or value to owner.
Yeah.
What's it worth to the person who holds it? No one else will pay for it because they can't own it.
Yeah, I agree with that. And then, there's sort of different approaches or methodologies for valuing options as opposed to a business. Like typically you're looking at an option pricing model like the Black-Scholes or something to use in valuing a stock option. And so then there's a number of different inputs and assumptions you have to gather in order to do that valuation. And one of the inputs happens to be the value of the company, the stock price. So if you're looking at stock options in a private company, then you've got to have a value for the company, right? So it's a lot easier if it's a publicly traded company, but those are some of the nuances.
Yeah. Valuator's dream. More complexities. We love more complexities.
I'm not asking it all from a selfish point of view. I don't. Don't worry, we can chat after this. So in terms of income assessments, especially because as family lawyers, we're looking at this often for support purposes, is there anything there that is important for us as family lawyers to know about?
Can I go ahead, Jason?
Yeah, I can. So income assessments, it's an expert report, right? So it's not a valuation report. And I think you really need to have a good understanding of the federal child support guidelines. We're going to talk briefly about this today with an income assessment under expert reports, but you have to have an understanding of the federal child support guidelines. And you really have to have a good understanding of them when there's a business involved, because, it's not just as simple as taking the individual's tax return that they file with CRA, and that's the income for support purposes. There's a number of other potential perks and benefits that the business owner derives from the business that have to be looked at or taken into consideration in coming up with one's income that's available for support purposes. So,
and I guess just to add on to that is another issue for the lawyers to consider and the evaluators is this general concept of double dipping or double counting, right? So options are a great example of that. So we may value them, and then an easy one school of thought might be, well, hold on, you valued it, so why does it come into your income later on? And there's a lot of ways to deal with it, and often, in that you might do valuers might do different scenarios and say, if you want to take this position here if you want to take this position, because it's not clear cut how you would deal with that between the equalization and the income.
Yeah, I can tell you from a lawyer, it's so helpful when you have an expert who has that understanding of the federal child support guidelines, because they are their own beast, right?
Right.
And a lot of times, if I have clients who are business owners, they'll say, hey, why can't I deduct $3,000 in meals and entertainment? And, I'm allowed to do it. The thing we always hear, if the CRA allows me to do it, why isn't the judge allowing me to do it? And I said, well, it's not quite the judge. It's a little bit more of the law. So it's really helpful when you have an expert who can sit that person down and give, a high level piece of advice. It's even more helpful when your client is not the business owner and is struggling to understand these big concepts of, what are add backs, what's double dipping, how, I've just always known that he makes A. Now you're saying he or she makes B. How do we deal with this? So
yeah, good point. Sometimes it's an education is more of what the client needs, one client or the other, than anything else.
Yeah. And I always find that once you have a validator who has that expertise, it's so helpful, because once you get past the education piece, sometimes it really reduces the issues, right? If you can say, look, this is likely what a judge is going to say anyway, we can fight it, but we have your evaluator who's giving you this number, you're going to be hard pressed to find a judge who's going to go outside of that. It really pushes things towards a settlement. So I know, and of course we know now, that all reports have to be provided within 6 days of a settlement conference. So there is this push by the judiciary to get these reports done early, so that we can have more settlement focused discussions and we can move things away from trials and into settlement positions. So yeah, I personally find that really helpful. Okay, so what is a lifestyle spending analysis?
Jason, do you want me to take that?
Sure.
So lifestyle spending analysis. So, and I've come in some of my reports now, I'll do an income analysis based on, we'll talk more about what goes into it, but then I may say I haven't been retained to do a lifestyle analysis. And the lifestyle analysis, I see it just as a bolstering of the income analysis. So if someone on their tax return is showing $40,000, I know that's, or 20,000 or 50. I know no one's ever had clients like that before, but then they happen to have their kids go to private school, and they happen to be driving a Ferrari, and they have a house up in like 10,000 or 8,000 square foot home that has very little mortgage. You kind of go, well, hold on, what's going on here? Now, it's very possible that all of this is funded by debt, not likely, but funded elsewhere. But that is the open question. So that lifestyle analysis just says if they're spending, if the person is living like they're making 200 or whatever thousand a year, but their tax returns say this, what are we missing in between? Is it debt? Is it mommy and daddy? Is there trust? Is there other source of income? Is there cash, unreported cash in the business? What's going on? So it helps the intention is to plug the holes and get that bridge to the income report.
Absolutely. And again, I think that's a really great education piece, because, maybe those properties or whatever it is are owned by the business, and you can explain, okay, this is not going to be an income piece. This is going to be more of the equalization, what's already included in the value of the business. So, and it's really helpful for lawyers, so that, we already have someone who's sitting there, who's done all the research, who can give us the Coles notes of, hey, here's what, here's kind of how it works, so that I can now also explain that to my client and show them the different options and settlement positions that we can take.
Yeah, and just to add to that with the lifestyle spending analysis, like we don't do them very frequently because they tend to be very forensically driven. Like it's a matter of a lot of detailed work, looking through bank account statements and credit card statements, trying to isolate spending for personal versus business and come up with that picture of the overall spending for the household, right? It often comes up in situations where one spouse thinks the other spouse who runs the business is taking a lot of cash and not reporting the income. So of course, that's when it's going to be relevant, but it can be very time consuming and costly to do that. So sometimes, we will suggest that maybe start with just 1 year and let's see what we come up with. And if we need to do more, then we'll expand it from there. But sometimes clients shy away when they find out the amount of work that's involved.
Yeah, that's a great point, and I think that's a great suggestion. Like the 1 year, I'll do the same. I'm finding these are coming up more and more, but I do have to say, when we've done them in the past, we've often found very interesting things. So, you don't know until you do it, but as Jason said, they're time consuming, expensive. You probably don't need a senior evaluator doing them, supervising. They should be supervising them, but still they're very, they definitely are time, especially when there's more than one credit card statement, more than one bank account.
Yeah, and often I have to speak to my clients, on whichever end, to explain that they can have a big impact on support and, going forward, especially in long-term relationships or long-term marriages, where you're looking at 20 or 30 years and there's a large spousal support component to this. Having that lifestyle spending analysis to determine what the true income should be for support purposes is really helpful. And let me tell you, judges love them because they don't want to be sitting there saying, hey, look at his credit card statements. He says he makes 40,000 a year, but he spent 200,000 on his credit card. How could that possibly be? All right. So would you mind if we move forward with a tracing analysis and how that works and even what that is, maybe to start?
Yeah, I could just sort of mention briefly, we don't do these very often. They are sort of reserved for certain situations, but we've done them a couple of times where, a party says that I have an inheritance or a gift back from a number of years ago, and we need to sort of go back and trace where the funds went and where they originated, right? So it can be very complex if the money's been moved around in following the money, and it's just a matter of looking at sort of the bank statements and doing that sort of tracing and then putting it into a concise, easy to read report.
I'll say a tracing report can also come up if, like, let's say you're going through bank statements and you find money is going somewhere else or money is coming from somewhere else. So, and whether then you need to get a forensic person, which we have, and get further information because it may involve third parties and trying to find out where the accounts are. That may come up from time to time, but not as often as something like lifestyle or the other tracing.
Yeah. But it is important, especially in my view, when they're very large inheritances and they there has been movement and there will be, especially in longer term relationships where, 20 or 30 years, it'll be, I think it's important for my client to be able to show and demonstrate to the court and to a judge, yes, this is an excluded amount, because the worst thing you want is to go to a trial, assume that, the judge is going to agree with you that this $1 million inheritance should be excluded. And then all of a sudden they're saying, wait a second, we have some issues with the tracing of this. So definitely in situations where there is a lot of money at stake, it is worth every penny to get it done. Now, this is an interesting one because I'm doing a bunch of these right now. What about, tell me a little bit about reviewing and critiquing the opposing party's expert report.
Do you want me to go, Jason, or?
Sure,
Okay,
sure.
So as Jason mentioned, we've got like the 400 series is a limited critique report, but that's a pretty limited scope. In theory, it's just you look at someone else's report and you comment on it, but you don't provide a conclusion. So I don't know if anyone's had experience with those, but I think, in my personal opinion, is they're pretty useless. Because they do not provide opinions. And regardless, when you're doing a matter that's involving family law, someone is paying you and wants your opinion. But if you're instead going to say, well, I'm not sure, I don't think I agree with this multiple or this, but I can't tell you what my opinion is because I wasn't retained to do it. It's not that helpful. So on a standalone basis, they're not that useful. So I think in cases when you really have issues that are judgmental issues and valuation or income issues between experts, then both experts probably are going to be doing reports. And then they may, limited critique, who cares about a limited critique? You're just commenting on, well, Jason's multiple, I think, was too low because of this. I agreed with these other things he did, but I just have a problem with this and this. And then, of course, we haven't even talked about hot tubbing, but over to Jason.
Yeah, no, I'd agree with all that. Like, this is a limited critique report. It's limited in use, and that's part of the name, right? Like, that is the problem. You provide comments on another report, but you don't give a solution. You don't give a recommendation. You don't give a conclusion. So I mean, perhaps it could help with narrowing the issues. Perhaps it could help with early settlement negotiations. Perhaps it could be useful for cross-examination of opposing expert. But I find anytime I'm asked to do a limited critique report, the next step is, after I provide that report, is, well, what do you think it should be? And then I have to do my own report anyways.
And I've gone to, I don't know if you have, Jason, but I've gone to court, this doesn't happen very often, where the other party has done a limited critique on my report. And it's really, lawyers out there, do not go to court when your expert has only done a limited critique. The judge is just going to say, I don't know what to do with this because it's not an opinion. So we have an opinion. Someone is saying they may not agree, but we really don't know if they agree or don't agree overall. So it's a really bad thing to do. So as Jason said, maybe from a settlement point of view, maybe not. I think I tell people they're pretty well useless. They used to be, when they first came out, people, I will say, in my experience, they weren't well understood. So they were more effective because people were worried about, oh, well, this must be wrong. But I think now most people understand what they are, especially the courts, and they don't generally get you that far.
Thanks so much. I know it's not on our list, but what is hot tubbing? You said it, and now I'm interested.
I don't have a hot tub at home, but I don't know. Jason, do you have one?
I do have one, but I don't like that term, right? They're going to change that.
No,
they got to change that term. Yeah, it's really, I mean, the courts and judges are really trying to encourage, and in some cases sort of mandate, that before things come to court, they want the experts to sort of get together and discuss their differences, discuss where they agree, discuss where they disagree, discuss why they disagree, and come to court only with a list of where they disagree and the reasons why. So, I mean, the hot tubbing is meant for experts to sort of discuss each of their reports, discuss the issues, and see if there's any chance of movement or compromise to try to, in an effort to settle before going to court.
Yeah. And they can be very useful, I think. And sometimes you get personal dynamics in there, but from a 10,000 foot view, they're good because it helps out the court to say that these are the real issues, right? That helps the court filter. These are like insignificant. Like, we're arguing about $10,000. Let's just cut in the middle. Now, this is a big issue. And I've done some of them before where what we ended up doing is saying, well, these are legal issues and let's agree. So we would agree that if the court finds this, this is the value, this is the income, whatever it is. If they find something else, we both agree. So now let's, let the lawyers do their arguing. And then once there's a termination, they can pick one or the other because we've already agreed. So I think they can be very useful. What I've seen lately, I don't know if Jason has seen this, the mandating and judges noting the experts did not do this, or they didn't come to an agreement, and it's like, oh, we're in trouble now. So they're really pushing the experts on this, in my experience.
Yeah, I agree with that. And years ago, a few years ago or more, we were asked to do it, and I found that the success rate was very low. And I don't know if it was just because I was opposite another expert who was sort of dug into their position. Like, you really need to keep an open mind. No, of course not.
Just to be clear, we would be able to resolve it.
Of course. but what I'm finding is the trend is shifting. Like I'm finding more experts are being more open to not being emotional and being more open to, okay, this is just an exercise we have to go through. And all we're doing is summarizing the differences and presenting our arguments or reasons. And if this is new information to you, maybe you'll consider changing your opinion. If not, then we're just going to highlight that issue and what the two different reasons are. And it seems to be going a lot better.
Yeah, I'd agree with that.
That's great. And you know, the thing is, trial time is so difficult to get. Like our judicial system is so bogged down. The cost of trials are so expensive. So if you could have the experts come with a united list of issues that they don't agree upon, and maybe there are legal decisions that have to be made before they can choose a path, that would really reduce the trial time. And it's a great way to sell it to your client. If, you know, if I can reduce a whole day in court, that's going to save you much more money than a couple of hours of the expert sitting down and kind of hashing it out. So I hadn't heard the term hot tubbing before, but I understand the concept of it, and we do use it a lot.
I think sometimes in the order they're trying not to say hot tub. They're trying to use a different term because everyone knows it. They go like this when they hear tubbing.
All right, why don't we go to our next poll? So what do you expect a business valuation report to cost? And this is so funny because I get this question. It's the very first question every single family lawyer gets is, how much is this going to cost me? So 5 grand, 10 grand, 25 grand, 100 grand. It depends. Every lawyer's favorite answer and other. So we'll give everyone. But have you guys, isn't that the first question that people ask you? How much is this going to cost me?
They always want to know.
Yeah.
Timing and cost.
Mm-hmm. It's always, and I'm sorry, half of those questions are probably from lawyers. I apologize.
Yeah, it's probably you guys sick clients on us to ask.
Yes, but it's our clients, it's not us. We know it takes what it takes.
Fair.
You know, you may go in thinking the scope is this big, and then as things happen, it gets bigger and bigger. So let's see what our audience thinks about this. All right. It depends. You know, you've got a room full of lawyers when that is the overwhelming answer. 59%, 27% of us think it's about 10,000, 7% of us think it's about 5, the 5% at 25, and 1% thinks it's 100,000. Oh, and we've got another. So why don't you guys educate us?
Yeah, I would say I think you got, not only because you're lawyers, but I think you got the right answer, right? That was it depends. And it depends. We talked a little bit about some of the reasons why things can change, disclosure, challenges, regardless of the source, but disclosure challenges, but complexity, but also, you know, income analysis. How many years are you covering? If you're doing a retro claim and looking for go forward, then I've got one now where they want me to go back to 2015. It's like, guys, I'm happy to do that, but forgetting about whether we can get the documents, think about how much money this is going to cost. It's got to make sense relative.
Thanks.
Yeah, I agree with that. It totally depends, but I think the next most popular response was 10,000. And I mean, if you're just talking about a single business, a single operating company, maybe 1, maybe 2 valuation dates, it's not overly complex, you know, that might be in the ballpark there.
Yeah.
Thanks, team. I just want to do a really quick question. So if you've had one CBV do a business valuation, can you have a different one do an income assessment, or is it better to go back to the original CBV? I know my answer, but I'd love to hear what you guys think.
I would say if you've got the advantage, unless you've had an issue with the valuator, that valuator's done one piece of it, has the knowledge of the client, has the knowledge of the business. So they should be able to do a better job, a faster job. I don't see on the surface why there'd be any advantage to going to another one unless you had an issue with the evaluator. You know, Jason, any?
Yeah,
thoughts?
no, I agree with that. Like I hardly ever see 2 separate valuators doing separate. One does the business valuation, one does the income assessment. It just makes more sense. Oftentimes we're engaged to do both at the same time, like because we're gathering similar types of documents and information. So
Yeah, the only time I've ever not used them both at the same time is where something happens and that valuator is not, let's say we do the business first and then decide we need to do an income later. Something happens and that valuator is just not available or doesn't have the right timeline, or unfortunately is off on a medical leave. But that has happened once, I think, ever in my 14 years of doing this. So my advice to my clients is always do them both, do them early, because the more information we have, the earlier we have it, the easier it is to resolve this matter instead of going to trial. Okay, so why don't we talk a little bit about types of CBV reports and, the process, the usefulness, appropriateness, and potentially the cost. Jason, I know you started talking a little bit about 10K being a business valuation, but we're lawyers. We want to get as much information as we can out of you guys today.
Yeah, we've talked about a lot of this already, so I mean, I won't spend too long, but when we're talking about written reports, I guess one of the things we didn't talk about, because we've talked about valuation reports and expert reports, the different types of expert reports and limited critique reports, but we haven't drilled down a bit on the valuation reports. When a CBV does a business valuation report, there are three different types or levels of valuation reports that they can provide in accordance with the standards or professional standards. And that's a calculation, an estimate, or a comprehensive. And they vary in terms of the scope of review or the amount of work that's done, the disclosure in the report, the cost, and the level of assurance that's provided over the conclusion. So just like, for example, a comprehensive is based on a very comprehensive review and analysis of the business, the industry, all of the factors, right? It's a very detailed report. And in my experience, it's not very common. And typically for larger companies, significant dollars at stake, it could be litigation, it could be maybe the public is going to be a user or reader of the report. I mean, we have one going on right now, but this is only one that we've had in the year. And it involves a going private transaction for a large public company, like $300 to $400 million value. Like that's a comprehensive. They're not very common though. The estimate is based on a more limited review, analysis, and corroboration of sort of the information in the report. And that's useful for litigation, certain contentious issues that require deeper review, investigation. The lowest level is the calculation, and that's based on a minimal review and analysis and almost no corroboration of sort of information. It's a very brief report. They can be useful, and they are quite common for, planning purposes, tax planning, estate planning, or early stage negotiations, or you want to get an idea of what the value is, because in a calculation, the CBV still needs to assess all of the different factors that affect value. It's just they're not digging deep to independently corroborate or verify every single assumption. So you're still going to get a good ballpark value, and it's less work and it's cheaper. So I don't know, Melanie, any other comments on the different types of
that's
reports?
great summary. The only thing I want to just be really clear about this is, regardless if the financial statements are audited, financial statements are reviewed, the financial statements are compiled, the financial statements are just prepared internally, theoretically, evaluators could do any level. So just because the financial statements aren't audited doesn't mean we can't do a comprehensive. So I think there's a bit of a misunderstanding that people think if you do a comprehensive, that means we're also going to be auditing those underlying financial statements that are only compiled. That's not the case. That would be it's not unusual that we'll be engaged to do certain forensic or detailed procedures on the underlying statements if they're not audited or reviewed, but that's separate from the valuation in theory, right? Doesn't mean during the valuation we're not going to say we're concerned this account doesn't make sense, that account doesn't make sense. But if we didn't think that, then we could still, in theory, do any level of assurance.
Yeah, the only thing I would add to that is it's up to the evaluator's judgment in terms of, is there enough good quality information available to allow me to do a comprehensive review and provide my opinion? because they may want you to do that, but you may say, well, your records are horrible and I can't rely on anything you're telling me you're giving me. So I'm I don't feel equipped to be able to do a comprehensive.
Yeah, I agree. I think though you'd still have that issue of if you have no comfort in those statements for a comprehensive, I'd have no comfort in an estimate or a calculation in theory, right? Because
Yeah.
it's garbage in, garbage out,
Yeah,
regardless of
totally.
what level you're doing. So that's and the movement over the last number of decades has been downgrading external public accountants' involvement with financial statements and the assurance provided, because people have just sort of cheaped out along the way unless someone demands that they do it. So that's the bane of, I don't know about Jason, but I suspect I know one of the bane of my existence is the unreliability and questionable reliability of the underlying financial information that we get.
Yeah, and sometimes what you're hearing from the client or the accountant doesn't necessarily jive with what you're seeing in the records, and that gives you less confidence over what you're being told too.
Right.
All right,
Yeah.
guys.
So yeah, I just wanted to. Oh, you're going to do another poll. Okay.
Sorry.
No, no,
That's
no.
okay. We're going. Sorry, we're
Yeah.
close to the end. Sorry.
I apologize. Okay. CBV reports. Have you jointly retained an expert with opposing counsel? Yes, no. What's a joint retainer and other? So hopefully by now we know what a joint retainer is. But while the audience is answering that, I just have some quick questions for you. Someone asked, it sounds like a limited critique would be helpful to decide if getting a full report would be useful. What are your thoughts on that?
Go ahead.
Yeah, I mean that's a good start, but I would even say if you've been served with an opposing expert report, you don't necessarily have to start by retaining evaluator to do a limited critique report. Like just retain the evaluator to review the report and verbally give you their thoughts and issues and concerns, because maybe they think it's okay, or maybe they have identified a number of issues that would warrant preparing a report.
Yeah, totally agree. That's the best, most efficient way. You retain the expert for a few hours or whatever it is, and then you go to step 2 if needed, but maybe you don't need to.
Thanks, that's great. And so cost savings. Okay, let's see the results of our poll. All right, yes, no,
Okay.
a couple of what's a joint retainer. So that's great. I mean, it's good that we are using these. If you haven't used them before, don't be scared. You can call Jason and Melanie. They're wonderful, and they'll answer some super professional questions about the process if you need to. If you're looking at getting something like this, and if it's worth it, and you guys are both so practical, which I love about you. I know that you would give someone really good advice as to what that step is, and to also look at your options. Right? This is what I think would be best in this situation.
Right.
Okay. So why don't we move on to our last topic, joint retainers with CBVs, and the discussion of pros and cons.
Yeah. Do you want me to start, Melanie?
Sure, go ahead.
I mean, a joint retainer is simply where the parties agree to both retain one expert jointly instead of each retaining their own expert. This could be a court-appointed joint retainer, or it could be just a voluntary joint retainer. And I mean, on the surface, you would think that there's a major benefit in terms of cost savings, because now the parties are splitting the fee for one expert as opposed to each paying for a separate expert. However, in my experience, I don't know about Melanie, but in my experience, that's not always the case. So I just wanted to sort of give you a couple of pointers as to, when they may be appropriate and they may work, and when they sort of don't work. Like, I think when they work and when they're effective, in my experience, is if you've got sort of a collaborative setting where the parties sort of are open and honest and forthcoming, and their goals and interest driven. They're not positional, and they're willing to consider options and willing to compromise. It's not like a win-lose mentality. Those situations, a joint retainer can be very effective. But when they don't work, and unfortunately I've been involved in a number of these, is when the parties are highly litigious, highly adversarial, highly emotional, and irrational. And so why don't they work in those situations? Because the parties are ultimately going to disagree with each other on a number of issues, key issues. It could be anything, personal expenses, unreported income, but they're going to disagree with each other, and they're going to tend to dig in on their position, and they're going to request the evaluator to continue to investigate until they get their way. It's going to turn into a detailed forensic exercise. It's going to be very expensive. It's going to be very time consuming. Ultimately, the parties probably will never be satisfied. They're not going to sign the rep letter the CBV wants them to sign, and they won't be able to get a final report. I don't know, Melanie, have you had any of those
Oh yeah,
situations? I'd like to be able to identify those and then avoid them.
yeah. When everyone started doing joint reports, naive Melanie thought, oh my God, this is great. This is brilliant. The world is going to start working better. But I've learned a lot. And one of those things is making sure you put parameters. If you do think is going to work, then put parameters in there. So just as Jason said, so you don't want someone to be able to hold up a report just because they don't like the result. So I always put in my engagement letter certain parameters. Well, we'll do a draft, and then within a certain period of time, the parties respond. Then we may, we will decide whether we do another draft, whether we reflect those comments or don't. And then if we do another draft, they have a certain amount of time. And then after that, we're done. We do a final report and nobody can stop it. So you got to be very careful with that, because someone can drag their heels. And it is certainly a huge issue for CBV profession, because I'm on a subcommittee or a committee at the CICBV that is dealing with joint retainers, and we're trying to come up with best practices and things like what go in engagement letters. How do you make sure you deal with the clients and such like? So it is certainly, Jason's experiences are certainly very common.
Yeah, and just a couple of final points on this to keep in mind when there's a joint retainer of a CBV. Once that CBV is jointly retained, it's not like one side can then later in the process just unilaterally say, well, now I want to hire you to do this. No, there's going to be a conflict there. You're going to need the approval of both parties for that to happen. And also to keep in mind, when it's a joint retainer, there needs to be transparency throughout the process. Like, all parties need to be copied on all document disclosure and all communications with the CBV. So you can get yourself into trouble if you don't adhere to that.
Yeah. And I guess that's another good point about, because I've seen a lot of joint retainers where someone says, well, okay, I'll agree with the valuation, but I really think that they're hiding stuff. And no, we weren't retained to do that beginning. So then they want you to do, okay, you've done your income analysis, but you haven't done so what are we doing now? So to try to set out what the mandate is and anticipate that up front, so you don't have those issues that linger and you never get to resolution.
All right, guys, you've been so generous with your time. I know we've been peppering you with questions. I know we're over the time, but I'm going to ask you one or two more if you don't mind. So here's one question. When completing a limited critique report, do you get the source documentation, or do you just see the report itself?
I think that totally depends. And this, I'm assuming, the question can also be if you're retained to review someone else's report, not necessarily do that. Sometimes yes, sometimes no. Sometimes you just need to look at the report. Sometimes you go, well, I'm not sure how the other expert came up with this or that. Can you send me off this? So I think it depends on the situation. Jason, I don't know.
Yeah, I know. I'd agree with that. Like, I mean, what is it that you want me to do? Do you want me to just review the report and give you my thoughts as to whether I think there's any issues or concerns here? Or do you want me to actually check the accuracy of the report to the source documents and to go to that level? And they may not want you to do that initially, but maybe after you've gone through and identified some issues and they want you to prepare a report, well, at that point, I'm probably going to ask for the scope documents, because as part of my exercise of preparing the report, I'm going to want to see the documents that they relied on in preparing their report.
Yeah, that makes complete sense. Okay, one last one, because it's a good one. What are some of the biggest issues you see in other expert reports?
Well, okay, so I'm going to just plug my book here that I co-wrote with Dr. Howard Johnson, called Understanding Business Valuation Reports from Reuters. So Thomson Reuters, if anyone's interested, but it was aimed at the at legal reports. And I'm sure Jason has a lot of these too. I think that one of the most common one is a lack of clarity, or a lack of disclosure is how someone came up with something, or what assumption, or what methodology, or like when I tried, and it doesn't mean I always do this, but when I prepare my reports, I try to visualize someone else reading them and saying, are they going to understand how I came up with this number? Assuming that they're reasonably intelligent, they understand valuation, so they've got some knowledge. Are they going to say, how did she come up with this multiple, or how did she come up with this number? I want them to be able to. They may not agree with me, but at least they can say, I agree or I don't agree. I know, Jason,
Yeah, I agree with that. That is sometimes an issue. You just don't quite understand. They haven't given enough support or rationale in the report. But another common sort of issue I see is that they really didn't do enough work, and they just accepted what their client told them. Like, I see that very commonly, relied on discussions with management. Well, I want to dig into that and support the reasonableness of that. That may not be reasonable. That may not be the situation. So that's another sort of a common issue I see.
Yeah, that goes back to things like, if you're doing a calculation report, then in theory, that's what you're doing. But is that really appropriate to begin with? Should that other expert have really agreed to that in the situation, knowing it's going to be a contentious matter?
You know, another common one is just taking unreasonable assumptions, unreasonable positions on, you know, the allowance for personal expense adjustments and stuff like that, or unreasonable positions on an economic salary. Whatever assumption, it really should be reasonable and supportable. And a lot of times I see that's not the case.
Well, thank you both. This has been so wonderful. I've taken lots of notes. I have questions for you both that I may call you about later. We really, really appreciate you taking the time and answering all those questions throughout. We're sorry, there were so many that came in. We tried to get to as many as we could. So it just shows you that there's such a need for us as professionals to have you guys come and speak to us. And so we really, really thank you for taking the time today.
Absolutely, you're welcome. And anyone can reach out to us at any time if they have any questions that weren't answered today.
Thank you so much, Melanie and Jason. We are just going to take a short break so you two can get some water or whatever you need to do before your next presentation. So we'll be back here at 3:15 for Jason and Melanie's presentation on attribution of pre-tax corporate income. So we'll see everyone soon. Thanks,
Great.
Michelle.
See ya.
Welcome back, everyone. Just an action-packed afternoon of content. Thank you for that, Jason. That was fantastic.
Absolutely. Went by fast.
Oh my God.
I bet the
Great,
days blowing by fast.
great content, Melanie. Thank you so much. So Shannon, we've turned a corner. We're on the home stretch. I see the PowerPoints in between programs. So anybody who wants to sign up for collaborative practice training, that's starting in October. And we'll put an extra link into the box. Still 10% discount code if you sign up this week. Still hovering just under $10,000 for Denise House. So, I feel very honored to be part of the legal profession, and it's a privilege. I think we all have a duty to give back to the communities that we serve in. Feel free to cut and paste the GoFundMe link and share it on your social networks. But help us get over the top. We're going to hit 10,000, I predict, by mid-afternoon. We're pretty close, right, Shannon?
Yes, we are very close. So thank you again to all of our attendees who have donated, all of our speakers who are donating their time and their knowledge, and we're so grateful for that. We wouldn't be able to do it without all of our speakers. So I also want to give them a big shout out and a big thank you. And yeah, we still have a few hours to go. It's hard to believe we're just down to our last couple presentations, but it's nice to have you both back, Jason and Melanie. We appreciate you and all your time today. Melanie and Jason are going to be speaking about attribution of pre-tax corporate income. I won't spend time on introductions as we've already met, and I want to give Melanie and Jason as much time as they can to cover this content, but I will just give you a snapshot of what you can expect for the next presentation. So Melanie and Jason will be discussing income assessment for business owners, Section 18 of the guidelines, nature of the company, historical practice, ability of the spouse to control the distribution of funds, amount of income available having considerations for the financial status of the corporation, and lastly, other income issues. And similar to the last presentation, please feel free to send in any Q&A you have through the Q&A, and we'll do our best to get to as many questions as we can. And on that note, Russ, anything else you'd like to add before we pass things over to Melanie and Jason? Oh, you're muted.
Run that poll number one. We've got lots of questions that have come in advance, so we've got a lot to cover. So let's make a start. First poll question is, what experience do you have with income assessments? We'll give everybody a few minutes to answer that, but let's go. Jason, I'm going to start with you. What if the business has net pre-tax losses in the year? Does that get deducted from the spouse's income for support? Just come out swinging, right?
Yeah,
no,
yeah, exactly.
No
Exactly. No, that's a good question. And, the guidelines talk about pre-tax income. They don't talk about pre-tax losses. So if you take it at face value, then I would say no, but I don't really know because I have seen expert reports that do include losses. I tend not to. I typically don't, and I think most evaluators don't. They interpret the guidelines that way, but I don't know. Melanie, what do you think?
Yeah, it's an interesting one because it's certainly not clear. And I remember sitting in a judge's chamber after a case, and the judge basically said, well, if you read it literally, that's what this says, but agreed it wasn't fair. So I think you get into challenges. I think some experts, and sometimes we do this too, will do two scenarios. If you think this is appropriate to deduct losses, here you go. And it also crosses into the issue of capital preservation. So I think my answer generally is, let's do two scenarios.
I'm not going to pretend to know what I'm talking about. You guys are way above my pay scale. That's why we bring you in to help us out with these things. So let's see what our audience is saying here. Attribution, what experience do you have with income assessments? No experience, 32%. Majority of our audience is lawyers today. Some experience, 49%, great experience, 18%. Well, hopefully the great ones will get something out of this as well. What is an income? Well, everybody knows what it is according to this poll, and other, you can put that in the Q&A. All right, so let's get at it. Income assessments for business owners. Jason, what does our audience need to know? Oh, I don't know. Is that Jason or me, Melanie?
I think he's frozen.
All right, so let's go to another question while we're waiting for Jason to come back. So Melanie,
Yes.
can a CBV
Equivalent concept.
Sorry, Jason, you just cut off. You want to start off from the beginning?
Oh, can you hear me now?
Yeah, you're great. So let's go back to where we were. Income assessment for business owners. What do we need to know?
Oh, I
can hear you
think
now.
Okay, good. So this is a good place to start. Sorry we cut off, but this.
No worries. I was just going to pepper Melanie with the tough ones, so you saved her.
Good.
Thank you.
So this topic provides the context for today's sort of topic, right? What is an income assessment? Income is needed for support purposes, right? And income for support purposes is calculated in accordance with the federal child support guidelines. And under those guidelines, income for support purposes is a gross employment income equivalent concept, right? So for business owners, what does that mean? Well, for business owners, what that means is the benefits from business ownership must be included in one's income for support purposes. Now, in sort of the general process for an income assessment for determining one's income is to start with the individual's tax return and what income was reported to CRA. But then a number of adjustments have to be made in accordance with the guidelines. And one of the adjustments that have to be made when there's a business owner is potentially the attribution of pre-tax corporate income. So that's what we're talking about today. Today, specifically, we're drilling down on that one adjustment to income assessments for business owners. Any other thoughts, Melanie, on?
No, that's exactly it. I mean, there's a lot of different components that go into the calculation of income for support purposes. Some of them more judgmental than others, but definitely this one we're talking about today, the attribution of pre-tax corporate income, is certainly one of the more subjective ones.
All right, great introduction. Let's go to our next poll, see what our audience is thinking. And we had a great question come in, which I'm going to get to. So in your experience, how long does it typically take for an income assessment to be completed? And let's go to this audience question that just came in. Please send us your questions. They're fantastic. We really appreciate it. When a corporation does not have enough money to distribute its earnings in a given year, but then has enough cash to catch up in a subsequent year, how is that dealt with? Sounds like a law school exam question, really, but that's a great question.
Yeah, or it could be, so one of the things that happens with this issue of attribution pre-tax corporate income is we start by looking at, as accountants, we look at financial statements. And financial statements are prepared on a certain basis that may not be cash, right? So a company may be growing and building up the sales may be high, the profits may be reasonable. It may all be going into inventory or receivables, but there's just not cash there to pay out to somebody. So even if the payer said, I'd love to take out more money, put on my tax return and pay you more support, but this company can't afford it. Otherwise, I have to go to the bank and they may not lend to me, or it may not be, I don't want to pay interest or whatever it is. But so it doesn't have to be loss situations. It can be just normal operations that require some working capital to be maintained in the business.
Jason,
Yeah, that's a difficult question to answer in isolation, because you're isolating the cash balance this year and then there's more cash next year. I mean, when you're looking at this issue, as we'll talk about later, there's a number of different factors you have to consider, right? It's not just cash. It's, well, maybe they generated income, they had the cash, but they loaned it to a related company. So it's sitting there as a receivable. Like, I mean, there's a number of different factors. So, and also, sometimes we do an income assessment for 1 year and we're just looking at 1 year in isolation, but other times we're asked to look at 3 years or 4 years or 5 years. And in those situations, it might make more sense to look at sort of the accumulation over the years and what's sort of going up and down in the business. So those are some initial thoughts I had.
Yeah, I was thinking you might take a 3-year average, right, and roll it out, and you're going to see probably some rollover from year to year. That would be catching up. So let's see what our audience is thinking. Same day, yeah, that would be something, eh?
It would be.
Put a drive-through window in your office, and they could just drop in and give you the banker box of
That's right.
paperwork with the coffee stains on it, and come back in an hour.
Right.
Well, you got 24 hours to do the report, right? 1 day.
1 to 3 months, 60%. I think that might be quick. 3 months to 1 year, 26%. 1 to 2 years, 1%. Other 7%. I guess it would depend a lot on how timely the disclosure is, right? Like if you're waiting on a third-party accountant who has other clients, you're not going to get that information in 3-4 weeks.
Absolutely. Just like a business valuation and income assessment, we can do that as quickly as we are able to get the information we need.
Yeah.
And I guess one other thing to consider too, people usually want more current as possible, right? So they may say, oh, I want you to do 2024, but you have to be realistic that, 2024, it ends, yes, a few more months to go, but then by the time the accountants get all the documents together and get the tax return done and the financial statements, you may be many months out. So you have to kind of be realistic and think about the relevant period that needs to be looked at.
All right, let's go to our next poll. We're going to keep Shannon hopping in the background. So the next poll question is, what do you expect an income assessment to cost? So that's going to come up on the screen in a moment. Here we go. Thank you, Shannon. And while we're giving the audience a few moments for this one, I'm going to go to you, Melanie. Question about attribution. Can a CBV help develop a formula for attribution of PTCI in future years for a settlement agreement? Well, my first question is, what is PTCI?
Pre-tax corporate income.
Okay.
Here you go with, it's funny with acronyms. I was speaking to someone who talking about report writing, and they said one of the things with the report writing,
if I'm thinking of it, there's probably 200 other people probably thinking, what the hell does that mean? But maybe it's just me. So
no, that's
let's read it over again. Can a CBV help develop a formula for attribution of pre-tax corporate income in future years for a settlement agreement?
Yeah, I would say the general answer is yes, but I think it's a really challenging thing to do. Lots of people would prefer, in a simple situation, maybe you can, but if you've got a situation that it's a business that is not really stable, a business that, there's different shareholders, there's issues of personal expenses, there's a whole bunch of possible issues. It's very hard to say what's appropriate. So while it theoretically sounds like a great idea, let's put a formula into the separation agreement and be done with it. It will be a challenging thing to do.
Jason, what do you think?
Yeah, agreed. Like I mean, if we go through the exercise of doing an income assessment, then we do have a framework there, right? We do have a framework we can provide, but is that useful going forward? Like Melanie said, it depends. Is everything going to stay the same going forward, or are there going to be changes to the ownership, the transactions? Do they do a capital gain strip? Like any number of things could happen that it falls out of the formula. So it may be useful as a starting point, but you may still want to get someone to sort of check on the situation in subsequent years.
Would changes in the market condition affect the formula too? We went through COVID and a lot of businesses got turned upside down, or would the formula still apply?
Yeah, for sure. That could be another thing. And back to your point about averaging out the number of years, we often go to 3 years just because it's talked about. But if you were in the COVID years or just coming out, averaging may not have made any sense at that point.
You're averaging 3 out of 4 COVID years. It's not going to help you, right?
Right.
All right. You know what? We're not going to put depends in any more of these poll answers because this audience this audience knows our trick now.
They know, they're smart. Yeah.
$5,000, 13%, $10,000, 19%, $25,000, 8%, $100,000, 1%. It depends, 60%. It sounds like an auction we've got going on here. Yeah, it really does depend on the company, on the amount of paperwork. Sometimes there could be holding companies and multiple corporations, multiple shareholders, public or privately held companies. A lot of factors come into play, I would imagine.
Yeah, absolutely.
So you guys are agreeing it depends?
Yes, they know. Your audience is smart. They know.
Yeah.
All right. Shannon, I don't know if you can do it. Take it all the depend answers. Go for the next couple poll questions. I'm just joking. Don't do it if it's going to freak you out. Section 18, next subject. Section 18 of the guidelines. Yes, our favorite section. The court may determine the spouse's income to include all or part of pre-tax income of the corporation, referred to as attribution of pre-tax corporation, and factors typically considered by the court. So that's sort of exactly what we're drilling down in on this afternoon. I'm glad we didn't have this as part of a other program, because we really need an hour to talk about this. Melanie, you want to start us off?
Sure. So I guess the big picture reason, I think, why this is in there is it's very easy if you have a business, regardless of how large or small it is, to say, you know, I'll show $10,000 income on my tax return because I get to choose how much. I tell my accountant how much to do my T4, and I'm just going to leave everything else in the company. And it just builds. So it's that, you know, it's in a situation where someone controls what goes on in a company, it wouldn't be fair to say, ignore the company or ignore that corporate entity, because that person has the ability to have more support, more income. If they don't want to take it out as cash, fine. But
all of a sudden I'm going through a divorce. Let's load up the company with retained earnings, right?
Yeah, exactly. So I think that's the overriding consideration. So, you know, as valuers, and Jason can say if this was his experience, but I know when I first started doing income analyses, everyone at that time was attributing 100% of the pre-tax corporate income without question. And it's become a much more nuanced analysis now to say, hold on, that's really not fair to the support payer necessarily either, because if they did pull everything out to pay support, then that's going to harm the golden goose. So be careful. You know, you got to look at it from a business perspective, and that you want the business to continue to be able to support the family.
Yeah, it's not cut and dry. It's not cookie cutter. I mean, it's the court may determine, right? And it may determine to include all or part of the pre-tax income. So it's definitely not cut and dry and automatically 100%. And there are a number of factors that the courts typically consider when dealing with this issue. And, you know, nature of the company. What has been the historical practice? What is the ability of the spouse to control the distribution of funds? And the amount of income available for distribution. So here there may be income, but is it available for distribution? Those are different factors. And the fact that there's different factors just sort of tells you that it's a complex issue to deal with.
Yeah, and that's a great point. So I think the easiest analysis, and Jason can say if he agrees or not, but the starting point is, did the company realize an income, right? Often you just stop there. If they didn't, then okay, we're done. Okay, subject to this issue of attributing losses, but you're done. Then you've got all these other things to consider after that.
Yeah.
And I guess they may have covenants with their financial institutions, right? Like they may not be able to pay.
Mm-hmm.
That's right. Even on that fourth point, which is the income available for distribution? You know, I can think of 7 or 8 different factors to look at to assess that itself. So it's, a lot of different factors.
So what would some of those factors be?
We're going to drill down on it later on. Yeah.
All right. Got it. Okay. So let's talk about the nature of the company. You kind of touched upon that a little bit, Jason.
Yeah. So now what we thought we'd do is we drill down on each of these four factors to really get to the meat of each of these factors or issues. And the first one is, well, what is the nature of the company? If you're looking at a company and maybe it has income, the first factor you look at is, well, what is the nature of the company? Does the company require working capital for ongoing operations? Like, it has to keep some funds in the business for its working capital. So what I look at is, what is the working capital at the end of the period? And when I talk about working capital, I'm really just talking about, the company's current assets minus their current liabilities. Do they have the ability to pay off the liabilities that are coming due in the coming year? And to look at that, you can look at the history. Does the company historically keep working capital on hand? You can look at industry average working capital balances or current ratios. But working capital is one thing that depends on the nature of the company, right? Like, if you have a holding company versus an operating company, a holding company is usually just an investment or real estate holding company, and typically doesn't require working capital. But an operating company could be manufacturing, it could be distribution. It's an operating company that manages receivables and payables and inventory. I mean, it has working capital that working capital needs, and it may have excess working capital, or it may have a deficiency of its working capital. But that's the first thing in the nature of the company. The second thing with the nature of the company is, how capital intensive is it? Is this a company that requires a lot of capital reinvestment for ongoing operations? Or is it one that maybe is just a service company and doesn't have a lot of capital assets aside from maybe some computers, hardware and software? So you can look to capital intensiveness. You can look to actual historical purchases. You can look at the capital asset cost base. You need to assess how much this company, given the type of company it is, needs to hold on hand for capital reinvestment. So I talked about the holding company versus operating company and the service company versus a manufacturing business. What if you've got a startup company versus a mature, stable business? A startup company may require higher working capital or capital reinvestment or capital expenditures during the growth or startup period. So you can really drill down on this one factor, the nature of the company. Any other thoughts, Melanie?
Yeah, a couple of things I add to that to watch for is this issue of conservative management. So when you get a private business, they're not necessarily responsible to board of directors that are saying, well, hold on, you've accumulated all this money, why don't you pay it out as dividends? So I often, I'll ask, one of the things I do when I'm trying to find out how much working capital is needed is ask management, so ask the owner, what do you typically need? And they'll say, well, we need at least 100,000 or 150. I go, why? Because you're collecting your receivables in 30 days, you're paying your trades in your suppliers in 30 days, you pay your employees 15. So yeah, you need a little bit of a buffer there, but you really don't. Why do you really need that much money? Oh, just because. So then you get into that issue with, yeah, that's what they've historically done, but do they really need to do it? Right. So that's one issue to look for, and especially in private companies where they don't have that, like a public company, you would assume, of course, that they're operating efficiently. The second thing to look at, as Jason was talking about, on the capital intensive nature. So yes, you would say, well, if I have I've got to replace all my computers next year, or I've got to buy a new printing press. That might automatically say, okay, we better keep all the cash here. But you can lease these things, you can borrow, so it's not the only option. I once had a case which I still laugh at, and there was a well-known expert on the other side, and what the reason was, and it wasn't Jason, the reason that they used for needing all this cash, like all of the cash for years, like we did a long term, was because the owner wanted to buy a building. So the owner had like $5-10 million accumulated over all these years, but wants to buy a building. So therefore it's not available for support, which to me was crazy. But they were trying to make the case on that capital requirements. So
How'd it go?
I think it's still ongoing, but I keep shaking my head because there was various versions of that report, like various updates, and that still said the same thing. And after probably about 7 years of not buying a building, it was still, oh no, they still need the money because eventually they'll buy a building. But
Yeah, I think there's a lot of value to looking at historical practice prior to the data separation. You know, these divorce cases can take 3-4 years. So what was the practice before the business owner thought they're going to be on the hook for a significant support claim? And that's usually quite telling too, unless there's market conditions that are affecting that. Jason, what do you think about historic practice?
Melanie, I think was going to take this one, but I can comment.
Or no, sorry, you want to lead in? Sorry, go ahead,
oh,
Melanie.
that's okay. Go ahead, Jason. I'll just add in.
Melanie, go. I'll get Jason next time.
Okay. So I think the history, Russell, as you said, it is very important to look at the history. And if they're always paying dividends and all of a sudden just around separation date, those dividends stop, then of course you're going to question why did they stop? There may be very valid reasons. The company may not have earned as much, the company may need the money to buy a building or not, but there just may be valid reasons. So and it's also good to look at the agreements. If you have a business that's more professionally run, they might have an agreement about how much they have to keep on hand at any point in time, or how they approve disbursements. So you want to go to those shareholders agreements and other things that say, or dividend policies. There may be a dividend policy in place. So yes, historical practice really important to consider.
Jason,
Yeah, it's not a huge factor, but it is a factor that the courts look at. I mean, and what they're trying to get at is that if historically this business owner has been distributing out the income every year by way of dividends or bonus or whatever, I guess it's dividends, right? If the business owner has always been doing that, and then all of a sudden going through a separation, they change and keep it in the business, well then, what's the argument for it not being available for distribution and being part of your income, right? So I think they're trying to avoid that situation when they look at this factor.
And I guess the reverse is true too, to be fair to the business owner, right? Because they also want, I think sometimes the presumption is, as it should be, that they're running the business optimally, or were before the separation. So why would we go in and now say you've never taken dividends, but you should in theory be like, why aren't you? So you got to look at that side of it as well.
Yeah, I think that's a good point.
Ties in neatly with the question that came in. I'm going to throw this one to you, Jason. Well, if the company's built up retained earnings, is it appropriate to attribute all or part of the retained earnings?
Yeah, I get that question a lot, but that's not even the right question to ask, because a lot of times people hear retained earnings is the accumulation of income over the years, which is true, but that's not the exercise we're dealing with. Like, we're looking at, in a particular year, what was the pre-tax income of the corporation for that year, not the accumulation of all the historical income, just the income for that year. So that's what we're talking about. Is all of that available for distribution or not? And one of the factors that we look at to see potentially if it can be available for distribution is if there's retained earnings on hand, or retained earnings have been accumulated. That may be a factor to say that it is available for distribution. But retained earnings is not what we're looking at attributing. It's the income. So don't look at the balance sheet, look at the income statement.
Yeah, think of this on the separation. If you have a clean cut, those accumulated retained earnings in theory were already equalized, right? So you just want to look at what's coming after that, not what is already been accumulated, which is what Jason was saying. Just look at year by year what is accumulating or not.
Ties neatly into our next subject, the ability of the spouse to control the distribution of funds. Jason?
Yeah, this is the third factor, and this one is pretty straightforward. I mean, it just speaks to the ability to control, to make that decision, right? Because maybe the spouse only owns 25% of the shares or less than 50%, a non-controlling share interest. They don't make that decision unilaterally. That has to be made in conjunction with other shareholders. So it can't be automatic that, oh, your 25% share of the income should be attributed to you. So having control and being able to make the decision is a big factor to consider.
Melanie, thoughts?
Yeah, I totally agree. And I think the other thing to look at is who are the other shareholders, right? So it often comes up where people will say, well, hold on, this is for 25% shareholders of a family. Well, of course you should attribute 25%. Well, maybe not. If you separate the ownership from the running of the business, and if they need the money to run the business and not distribute it, then maybe it's not appropriate. But if all of a sudden, again, maybe back to they're all of a sudden changing their policy that they're now not distributing things, and they're using their control together to change policies to protect the spouse that's separated, then obviously you'd have a different conclusion.
Sounds like you guys almost have to be detectives to get the nuances of the relationships and who's controlling what and what's really going on, right? Behind what it says on paper.
Yeah.
All right, amount of income available having consideration for the financial status of the corporation. Another factor, Melanie, we want to take a look at it?
Yeah, sort of that's what we kind of talked about at the beginning that early on, is that often the first question is there income in that year? And if so, then go on to all these other considerations that Jason and I have talked about, and more sometimes. But it may be a little more nuanced than that, right? Because you may have to look at things like, well, again, starting with the income. If you read it literally, income is an accounting concept, right? It doesn't say cash generated, it says income. So, okay, let's go to the income statement or statement of P&L statement and start there. Okay, but is that number suppressed or too high because of accounting policies that may or may not reconcile with what you might think of more on a cash basis? So are we talking accounting income or cash? And of course, unusual, non-recurring stuff, should that be excluded or not? I mean, you might get into the issue of, is it go forward or retro analysis? Because if it's retro, you're looking, it is what it is in that year. But go forward, if it's a non-recurring, that's not, presumably that's not going to be there. So that might affect your go forward type of analysis. And I guess another really, really good thing, we talked about the dividends, is being careful not to double count. So if you get to the point of saying, there's 100,000 of gross dividends on this person's tax return, but the company generated 200,000. Well, you shouldn't be adding back 200,000 to the line 15,000, because then you're double counting that dividend. So you have to be careful of recognizing that there's things that may be on the tax return that you don't want to double count from the financial statements.
Yeah, I agree with all of that. Absolutely. I mean, the starting point is look at the pre-tax net income or pre-tax income on the income statement, but you may need to make adjustments to that before you even get to the point of assessing whether or not this amount is available for distribution, because you have to adjust for amortization and CapEx needs. You have to amortize or adjust for unrealized items, non-cash items, non-recurring items potentially. And then, like Melanie said, you've got an income, but if dividends were paid, you've got to back out that dividends because you don't want to double count. And so once you arrive at the amount that we're talking about as the adjusted pre-tax income to consider whether or not it's available, then there's a whole bunch of factors you have to look at to assess the availability. And I mean, I kind of go through this exercise of, first I'll look at the cash balance. Is there enough cash on hand? Then I'll look at the retained earnings balance. Is there enough retained earnings on hand? Then I'll look at the working capital. So now I'm drilling down a bit more on the balance sheet. Now I'm looking at current assets, current liabilities. And is there excess working capital there? Is there enough working capital for the business to operate? If there is, fine. You know, there could be the income is available for distribution, but I sometimes look at industry averages. And if the industry average current ratio is 1.5 to 1, and my company only has a 1-to-1 ratio, maybe there's not excess working capital there. So once I look at that, then I look at, well, has there been any activity in the shareholder loan account? Has the shareholder taken money out of the business by way of a shareholder loan instead of income? Because if he or she has taken money out by way of a loan, then to me, that kind of indicates it looks like funds were available for distribution. You just chose to have it advanced to you by way of loan instead of paying yourself a salary or a dividend. So I look at that. And similarly, I look at loans to related parties, maybe not the shareholder, but related parties. And then I also look at the liabilities. Are there bank loans? Are there third-party debts? And are there covenants? Are there covenants that require a certain, tangible net worth to be on hand or current ratio to be on hand? And then after looking at all that, the final thing I look at, well, and what I often hear from the business owner is that, no, we need to keep funds on hand just to manage our risk, because our business is very cyclical and we can go up and we can go down, and we have a good year. That doesn't guarantee a good year in the next year. We could have a bad year. So we need to keep things on hand. Or maybe we're going through an expansion and we need to keep funds on hand for this CapEx expansion that we've committed to. Like, all of these factors have to be considered in assessing whether or not the income is available for distribution. I'm sure Melanie can add to that too. Like, it's not easy. It's not just cookie cutter.
No, great points. Great points. And the shareholder loan issue you brought up is a big one. And I'll give you an example. One of my challenges always is, if someone has let's say they have an interim order against them for support that's maybe too high over what they're earning. I've had clients who have had to pull out of their shareholder loan just to satisfy that order. But then we look at it, we go, oh, well, you're taking money out, therefore must be a lot to attribute. That may not actually be true. It may be just that they're trying to prevent going to jail and whatever else. They just want to make sure they meet their payments. So that, of course, for the lawyers, be very careful on the interim orders, but a big one for us to take a look at. One other comment I'll just make, and good points about looking through the income statement, and that we talked about reliability of financial statements sometimes being an issue. Just an example, I had a client who had prepared their own financial statements, and I looked at one particular year and there was a loss. So I originally said, well, maybe you stop there. But when I looked into the expenses, the business owner accrued like $2 million of warranty. I go, what, $2 million? Did you pay that out? No, I didn't pay it out, but just in case. And I'm going, no, let's look at what the actual obligation is, or how you calculated that. So being careful, you really need the valuator to help you out with that understanding of the income statements and balance sheets.
I can't make notes fast enough. I'm going to need to get a transcript of this. Do you guys have like a pre-flight checklist to remember to check all this stuff out? It's incredible. Great information. Yeah. Let's go back to our audience and engage with them and see what they're thinking here. Mm-hmm. What do you think the most contested assumptions are in an income assessment? We're going to leave that up for a few minutes. We've got some great questions coming in. Please keep them coming in. Question from one of my favorite colleagues out in Kingston. If a company is depreciating its machinery, how do you feel that this impacts on the argument that money is needed to be accumulated to replace equipment? Great question. What do you guys think?
Yeah, I think like in any capital intensive business with machinery and equipment, I mean, you purchase the machinery and equipment, you do depreciate it each year. So you see that depreciation on the income statement as reducing income. And when I start with my pre-tax income, I will add back that depreciation because that's a non-cash item. But at the same time, I will look at, well, what is the annual capital expenditures or reinvestment that this business requires? Because there could be a few periods where it's not that high, but machinery and equipment doesn't have an indefinite life, right? Like it may be around for 10, 15 years, but then you need to replace it. So what we want to try to do is try to smooth it out and look at an average annual capital reinvestment for this capital intensive. Sometimes it may be the same as depreciation. Sometimes it may be higher or lower.
And that's
Do you
a great.
do you ever look at how old the equipment is, right? Is that reasonable that you'd be accumulating that capital for a piece of equipment you bought 6 months ago?
Another example in the capital assets is leaseholds. So let's say you have a 10-year, 15-year lease, and the company just spent 200, 300,000, whatever it is, some enormous amount of leaseholds. So you've got a challenge there because they're probably not going to have to incur it for another 10, 15 years. So should all that amortization be added back? Or do you say, well, 10, 15 years, you got to save up a little bit?
We also have a process question that came in a while ago. The client has more than one account, but the partner is only disclosing one of them. Are there rules to get them to get information on those other accounts? The spouse knew he has other accounts, but does not know which bank. So here you got a disclosure complaint by one of the spouses. How do you guys treat that?
In what? When you're when you're on a joint basis, when you're separate?
Either. Well, I guess you get a court order for it or direction.
Yeah, we go back to counsel and say, you're going to have to track this down for us, get it somehow.
This is a process question for counsel, not really for the experts. I agree. All right, let's take a look at our audience poll results here. Thank you so much, Shannon, for posting that. Most contested assumptions, gross up 21%, personal expenses 60%. See that quite often. Attribution of pre-tax corporate income, 35%. We're talking about that today. Cash, 32%. Reliability of financial information, 36%. And other, 4. You'll put that in the Q&A and we'll find out what that was. How do these results reflect on you guys? What do you think? Is this pretty much what you're seeing all the time? Or which one would you, which one of your assumptions, I guess, get contested the most?
I would say if you put it all of the above, you would probably have the vast majority of people answering that. It's very hard to choose because the personal expenses, the gross up comes together with the personal expenses. It may come together with capital gains versus regular income, but that's a follow on. But the other ones, it depends on the situation, right? But as I said, my bane of existence is the reliability of financial information. That is an issue in so many cases.
Garbage in, garbage out. Jason, your thoughts?
Yeah, agreed. I think, look, all of these are very common, but personal expenses seems to be almost in almost every file. That is very common. And attribution of pre-tax corporate income is definitely an issue that's common whenever there's a business, which is why we're involved. And that's an area where I find there can be a lot of disputes between or among valuators. So, because it's very judgmental and you have to make sure you look at all the factors. And then unreported cash, it does come up, but it's very dependent on the type of business or type of industry, right? In some industries, it's much more common than others. But yeah, these are all very, very common issues.
So for an income assessment and the attribution of the pre-tax corporate income, how much are we moving the dial by here? Are we going to double the person's income potentially? Is it just 25% or is it all over the map?
Could we use the it depends category?
Shannon
hasn't removed that yet, I hope. So
how successful, how profitable is the business? Because in some cases it can be very significant. And in others, not so much.
All right. So, Melanie, what are some of the biggest issues you see in other experts' reports?
Yeah, and this would be similar. I think this is very similar to the valuation piece, is that, and actually Jason hit on this on the valuation of the report side, is that often we'll get a report that say I relied on management for the personal expenses. And then I go, I'm not sure what to do with this. Do I have to go through all the general ledgers, get all the supporting documents? What do we do? Because there's not much to base it on. If the client just told the valuator, nope, there's no personal expenses, they did nothing, then it almost, you have to throw it back to the lawyer and say, I can't tell you whether this makes sense or doesn't make sense. I can look at the expenses and see how significant they are as to what maybe the potential risk is, but I really don't know until we do a lot of work.
Jason, thoughts?
Yeah, I would agree with all of that. I mean, personal expenses is a major issue in almost every file. And sometimes you have situations where sort of the non-business owner spouse basically has lived, the business has paid for all these expenses over the years. I know there's a lot of personal expenses. I know the business is paying a lot of personal expenses, and they're expecting that to be a huge adjustment in the income assessment. But it could be a situation where once we get into looking into the records, the books and the records, you know, this is a business owner, an accountant that is very clean with their record keeping, and they track all of those expenses in the shareholder loan account. And then they clear out that shareholder loan account at the end of the year to income. So it's all on the up and up. There's nothing to add back there. So sometimes you have to deal with sort of educating your client on, you know, what you're seeing in the documents and records.
Yeah, that's
Yeah,
a good
very good.
point. So understanding how the accounting records are, who prepares them, how they prepare them, what they do in the shareholder loan is really important. That's a great point, Jason.
So it looks like mischief on the top, but they're actually recording it properly and already attributing it to income.
Right.
Yeah, and they may attribute, it may be partly, it may be
Right.
all accounted for. Sometimes the accountant doesn't know everything. Even if they're correcting for a lot of it, it may not all be corrected for, but still.
Okay, another question for you, Jason, regarding the nature of the company and the capital reinvestment. What if the company has committed to or actually invested in certain one-time growth-related capital expenses? Can that be considered required for business purposes?
Yeah, this is a tough one. And I mean, on the surface, you know, that's capital investment, right? So that's for business purposes. And I would tend to lean towards saying that, okay, you know, it's been earmarked for business purposes, so it's not available for distribution. And it may be entirely truthful that those funds may not be available for distribution because they're being reinvested in growth or expansion. But sometimes what I hear from the other side is that, well, your client chose to reinvest in this business, not just for capital maintenance purposes, but for growth and expansion purposes, which he or she is going to benefit from down the road. Why should this business owner be allowed to do that and say it's not available for distribution for support purposes? When if they chose not to sort of embark on that growth strategy and just stay status quo, it would have been available for distribution. So it's a tough one.
Yeah. Melanie, thoughts?
Yeah, I totally agree. It's a very challenging one. And I think you can think of stock option exercise as a bit less of more of that kind of, do you control it or what, right? Because you can choose when you exercise an option, but so is that something that should it be included in someone's income now or later on? Similar to the growth, but if the growth, if this is needed and this is a rational business decision, then I would look a little bit behind the scenes and say, well, okay, can you lease or borrow, pay interest, and you can still pay support on it, right? Do you really need to finance something 100% with internally generated funds? You may want to, but is that really fair to the support recipient?
Yeah,
go ahead.
Well, I was just going to make a comment that what I hear so many times from business owners that I do income assessments for, once I start going through all these adjustments, personal expenses and the gross up, maybe related party wages and the gross up, attribution of pre-tax corporate income that hasn't been distributed, but it's theoretically available, but hasn't been distributed, we get this enormous income figure, which leads to high support payments, which the business owner says, I can't make those payments based on what I take out of the business. So it's very stressful and disconcerting for the business owner. I find that very common.
Yeah, it's just not workable. And then the business might fail too, right?
Right.
Yeah. All right, we've got one final topic, other income, but I want to go to one more question from Melanie. Aaron Franks and Adam Pruer talked about disclosure in their 2024 case law update. Some cases there if you want to, if our audience members want to take a deeper dive. But the question is, I've seen CBVs provide long lists of disclosure requests, and sometimes disclosure requests go on for months. Why do CBVs come up with such long lists? And what if the documents on the list are either not available or relevant to the party who won't provide them? So Aaron Franks was talking about lawyers sending off letters and just stapling the CBV's disclosure requests and say, here's, produce this. So what's your response to that, Melanie?
Yeah, and you know, it's stressful. I'll say it's stressful for the valuator because we're balancing our need to want to issue a report that is as accurate and reliable as possible with the cost. We know it costs a lot of money to do these disclosure requests, to go back and forth, maybe have to go to court to get the request. So, but we also don't want, we also think about going to court or being cross-examined or another expert looking at a report and saying, you didn't do enough work here. This is a wrong assumption. Why didn't you look at this document? So it's a very challenging. So part of the reasons it goes on for a long time is because parties aren't necessarily cooperating. So we come up with requests because we think about what we need to be able to issue an opinion on something, whether it's income, whether it's valuation, whatever, a value or whatever. But it gets to the point, as we sort of talked about in the last session, that sometimes people call the game. The fat lady sings and says, okay, we're done. We can't, there's just no way we're going to get any more. We've made all the efforts. My client has paid a small fortune to you, to me, to try to get disclosure, not doing it. So I want you to just move forward and assume this or assume that. And as I said last time, it's a little bit of a dangerous game because sometimes that's disadvantageous for the client, right? Because what kind of assumption are you actually going to make? So I'll go to the lawyer and say, what specific assumptions? And it may end up saying, if it's not clear cut what the assumption should be, maybe there's more than one assumption, and working with a scenario type of analysis.
It's a tough balancing act, right? Timing and delay and costs versus, you know, getting your report bulletproof, essentially. Jason, thoughts on disclosure?
Yeah, I agree with that. It's challenging. And sometimes when you get these very long disclosure request lists that can go on for pages and pages and pages, I find those situations are the situations where there's absolutely no trust. The trust is broken down and one spouse knows about stuff that's going on and wants to find out everything and dig into everything and make this a living nightmare for the other person. And when I see these long disclosure requests, like now it's a matter of going through the disclosure request and saying, is this reasonable? Is this really required? Is this even available? Because maybe it's not available and it's going to cost a lot and take a lot of time to actually put together to produce. So it's not an easy topic. I mean, obviously disclosure is required, but it needs to be relevant.
Yeah,
Right.
that's a good point. I'll just add one more thing to that is that sometimes the lawyers will ask, well, Melanie, can you review the other experts' request list? And of course, Jason's are always reasonable, so it's not Jason,
Yeah.
But, and comment on it. And that's very challenging because usually experts are going to be deferred to when they make a request. Doesn't mean they shouldn't support it, but it's very hard for me to say, no, you shouldn't ask for that. And sometimes I look at them, I say, yeah, that's not an unreasonable request.
Right.
So, but I agree with Jason about it's often when the trust is broken down, but sometimes people use the disclosure issue, try to use the disclosure issue as a bit of a stick and try to, which is not reasonable. Sometimes it works very well, but it's can be
a litigation tactic as well.
Yeah, for sure.
So I think that's where counsel needs to step in and say, no, this is not reasonable, or we're going to review this with the case management judge. and get the court's opinion before we produce another 12 banker boxes of historical data. That's what I would do if I thought it was pushing the envelope a little bit too far. Okay,
And
let's go.
if I'm ever putting a disclosure request together, I really need to have a reason why. Because I know if I get asked, why are you asking for this? You don't need that. I need to be able to respond. It needs to be reasonable and it needs to be required. Yeah.
Yeah. All right. That's fantastic insight. Thank you. Let's go to our final topic of this afternoon. And thank you for the back-to-back doubleheader sessions. This has been super informative. Other income issues. Sort of a catch-all here. What do you guys want to cover off? What do you think, Melanie? You want to start us?
Other income issue. I guess we've covered a lot, but one thing we didn't discuss in any detail was the issue of various sources of income. So as Jason said, from an income analysis point of view, you're looking at the employment income equivalent. So when you get these other sources of income, whether it's capital gains, whether it's dividends, whether it's money that regular payments from a trust, regular payments from parents, how do you equate that to employment issues? So watching for other sources of income.
Yeah. Jason, thoughts?
Yeah, on the other sources of income. I mean, there could be other sources of income that are not taxed, like capital dividends. They need to be included and grossed up. There could be other sources of income like dividends, which are taxed at more favorable rates, or capital gains taxed at more favorable rates than employment income. So they need to be adjusted and grossed up. Yeah, that is important. So looking at the different sources of income, I think also when you're talking about income assessments and looking at a particular year or a number of years, I think you also have to be mindful when you're doing those of, are you calculating the income for support for that year, like a retroactive payment? Or what you're trying to figure out is, what is the prospective income, the potential ongoing average annual income that we should use for prospective support purposes. And that distinction, really, retroactive, I mean, the income that you earned in the year is the income you earned in the year. So there could be a one-time sort of a sale and disposition and capital gain. Well, you earn that income in that year. So that should be included in your income for retroactive support purposes. But when you're talking about prospective going forward, you're not going to sell that building every year. You're not going to earn that capital gain every year. So it should be adjusted out for prospective support purposes.
Yeah.
What about sorry, go ahead, Melanie. I was just going to ask
say,
what about non-recurring income.
Yeah, non-recurring.
Yes.
And that's a good, well, it could be non-recurring loss, I suppose, too. But that's an excellent point, because I find a lot of clients don't understand that. So they'll think, yeah, I may had this good year, but that's never going to happen again. But if it's within the support period, too bad, so sad. Maybe going forward, we normalize that out, but you're kind of stuck with it regardless of whether it's non-recurring or not.
Yeah.
2 more quick points and we're going to let you go. Thank you again. This next point could be an hour, but we've got to get it down to 30 seconds or 1 minute. Family trusts. Wow. Who wants to take a crack at that wasp nest? Jason?
Yeah, look, that's difficult. And from an income perspective or evaluation perspective, I mean, you want to be aware if and when there's family trust, and you want to get sort of the background information about that trust. You want to get the trust agreement. You want to have an understanding of who the executor or executors are, or who the beneficiaries are, what type of trust it is. Is it discretionary? What's the historical pattern of payments or dividends to the trust, and then from the trust out to the parties or the corporations? You want to understand that, but it's not an automatic inclusion.
Right.
And it could oftentimes come down to a legal issue where you might provide different scenarios.
Yeah, really. A really important issue on the trust is who effectively controls it, just like with, and also intentions, right? Because sometimes you set up a trust for the kids, but the intention is to sell the business, income split, but basically steal back the money from the kids, so they never get it. So intentions and control are really important.
Pretty good. That was almost a minute. Last one, double counting. What do we want to be thinking about for double counting?
double dipping, you kind of mentioned that, double counting, whatever you call it. It's not, obviously it's not a black and white issue. But it's something you need to consider. And it gets, I find, probably Jason has had this before, where very messy issues where we're doing income analysis before separation. Then there's some issues after separation. And then how do we get rid of non-recurring and stuff that's already in the valuation? So it's really, really hard to clarify, but this often is results in different scenarios. I find if the court finds that this double counting isn't appropriate, here you go. If it finds it is, here you go.
Jason, thoughts?
Yeah, I agree with that on the scenarios, because here we're entering into territory where we're sort of blending or crossing over the valuation issues, which is the division equalization of property, and the income issue, which is an ongoing thing. And I guess the crux is, well, I've included that asset value in my assets, and I've already paid the other party for half of that. Why should I also include income that was generated from that asset in my income? And now I'm getting screwed both ways. That's where it comes up.
You're getting counted twice.
Yeah.
Great analysis, Jason, Melanie, fantastic. And I see Shannon is back, which means I think we're close to our time. Welcome back, Shannon.
Thank you. And thanks again, Melanie and Jason, for sharing your wealth of knowledge. Your presentations are always so informative. So thank you so much. And thank you to all of our audience members for tuning in. We have one last presentation for you as part of the summit. So we'll be back at 4:30 with how new advances in AI will be shaping the legal profession. So Russ will be speaking with our marketing director. Daphne will be joining the conversation, also my co-host for the event, but he'll be joined by Pamela Wickersham from Supio and Monica Goyle from Caravel Law. So looking forward to hearing from them.
All right, so go grab a coffee or take a health break. We'll see everybody back here at 4:30. Jason and Melanie, fantastic as always. Thank you so much for your time today.
Thank you, Melanie, Russ, and Shannon. Bye-bye.
Thanks so much. Take care.
Welcome back, everybody. It's 4:30 and we're going to be starting our final session. How new advances in AI are shaping the legal profession. Welcome back, Daphne.
Thank you. Happy to
Hi,
be
Pam.
here.
How are you doing today?
I'm good. Thank you so much for having me.
Our pleasure. Thank you for joining us. Monica, good to see you again. Welcome back.
Thank you.
So we really got the dream team. This is day 2 of our 2-day summit. You guys drew the headliner spot, final presentation at the end of the day. So what do you think, Daphne? You want to do some intros and make a start?
Yeah, I think you saved the best for last. So I'm
100%.
looking forward to our presentation on how new advances in AI are shaping the legal profession. And just a quick note for all the lawyers out there watching, it has been accredited by the LSO for 1 hour of professionalism content. So I'll go ahead and get started and introduce these new faces on the screen. So Pamela Wickersham is head of product at Supio, bringing over 15 years of experience in document management systems and legal technology. Her experience includes a pivotal role as a VP of product and engineering at Litify, where she spearheaded the development of DocRio, a cutting-edge document management and generation software. Throughout her career, Pam has been dedicated to optimizing document workflows and creating solutions that address customer needs. Outside of work, Pam enjoys spending time with her 3 dogs and visiting friends in various cities she's lived in, including New York City, Chicago, Miami, Los Angeles, and now Seattle. Welcome, Pam.
How do you survive New York City with 3 dogs?
I just had 2 then, but it wasn't a lot easier. Yeah, and you also get hit up for directions. It's a dead giveaway that you're from there, and everyone needs to know where the train is at. So I would actually say that's the hardest part about walking dogs in New York
Are
City.
these dogs that you carry around in a purse, or are they like full dogs?
I wouldn't actually call them full dogs, but I do make them walk on their own, except for the 15-year-old. She gets picked up every once in a while. So yeah, they're little dogs though.
We're big fans of dogs at our firm, so that's good to hear.
Yeah.
We can trust you.
We actually sometimes I have them in at the office, so it's a lot of fun for everybody.
We can trust you now if you got 3 dogs.
I appreciate it. I feel the same way. Thank you.
Yeah, I could talk about that for hours, but we'll get on to our next guest speaker who's here with us today as well. We have Monica Goyle. Thank you for joining us. She is the Director of Legal Innovation for Caravel Law. In her role as Director of Legal Innovation, she evaluates new technologies and implementation within the firm. She's overseen the implementation of their integral contract and document automation system, design and implementation of their client onboarding process, and the implementation of corporate services solutions. She is a part-time lecturer at the TMU Lincoln Alexander Law School, where she teaches critical approaches to data, algorithm, and science in the law. Monica was formerly an adjunct professor at Osgoode Hall Law School. In 2023, Caravel Law was an Excellence Awardee for Nexus Canada Award for Best Use of Technology in a Law Firm in the last 2 years. Monica was nominated for Canadian Lawyer Most Influential Lawyer in the Changemaker History. So quite the background there. We're thrilled to have you, Monica. Thanks for joining us. Now, Russell, I believe you will have all
Everybody's been listening to me all day.
Pam.
Nobody wants to hear you talk about me anymore.
And I'm happy to join this presentation as well. I'm the marketing director at Russell's firm, and I'm excited to share my perspective on using artificial intelligence for marketing. So without further ado, I'll pass it over to Monica to get started with intro to AI.
Yeah, we're going to do a quick recap. We've done a number of programs on AI, but Monica, can you give us an overview, and then maybe we'll get Pam to give us her thoughts?
Yeah, so I was just thinking about like, so when we're talking about quick recap, I was just thinking about like what's happening in the last year, and there's actually a ton of stuff.
Like last year, last month, this week, right? How far
I
back are
know.
we gonna go?
I know. Well, I figured this is an annual summit, right? So
Right.
but just kind of, maybe some people weren't, at the last year's summit, but just kind of, when I think about kind of what's happening in AI, and what I'm seeing is a lot of new technologies emerging that are incorporating generative AI into their solutions. So there's existing legal tech incorporating AI into their solutions, and then there is the very new stuff that's emerging, that's coming out. And there's a lot, but I think that there's some, you know, kind of categorizing that we can do around what the generative AI solutions are doing. And so they're really good at summarizing information, extracting information, generating text, searching for information. And so, I give that as kind of a basis, because when you're looking and you're thinking about what am I doing, these are kind of tasks or things that we do as lawyers where generative AI could be really useful. And so from that, I also see, 'cause some, I think, large categories of kind of new technologies that are emerging and or have emerged over the last year, and they've gotten really sophisticated. One is contract review. So I never knew that I would need a Word plugin that could review a contract, but there's now, I've looked at 20 of these solutions over the last year. So it's just uh, inundated. The market is inundated with these different solutions. And there's, I think, some notable ones that I could like call out. One is a Canadian one called Spellbook. We've been using it. We've been watching them in their kind of journey. It's a great solution. Um, the other kind of ones that I think are nice in this category is Ivo .ai. It's similar but a little bit different kind of functionality. If you're in-house counsel, or you're looking at a lot of contracts, Leah is a nice one to look at. Then the other category that I see kind of emerging is AI timekeepers. So, I mean, there's been this promise of like, AI being used to help lawyers with timekeeping. And now I'm seeing some solutions on the market that seems to actually be that these solutions might actually work. And so how they work is that they work in the background. Um, and they help you kind of create those dockets. So they like actually will tell you, okay, you spent like 6 minutes working on email, 10 minutes in this document, and help you to draft those time entries, and that you would then review and kind of then post. The other area is legal research. So LexisNexis, Thomson Reuters are kind of getting into that. We're going to talk later about legal research, so I'll kind of hold my thoughts about that till later. The other category of like tech that I'm seeing is litigation support. So like going back to that, summarizing information, extracting information, generating text. So there's all kinds of new tools that are coming up where you can upload like for example, your documents from a trial. So your evidence, your discovery transcript, your pleadings, and then use it to create motion materials, create help with writing briefs. So there's a software called ClearBrief that does a good job around that. There's also that kind of like legal research memos and so forth that you can and I'm thinking about Alexei. Alexei is a company that's an AI legal research memo kind of platform, but also the new kind of functionalities from LexisNexis and Co-Counsel from Thomson Reuters also give that kind of support as well. And then the other, kind of category is contract analysis, where you can upload a large number of documents, and that could be for due diligence, or it could be for e-discovery. And just seeing a lot of solutions kind of offering that as a offering as well. So, that is kind of like my kind of quick, I would say recap of what I'm seeing in AI over the last year. Um,
Pam, I think we all have a pretty good sense as to what AI is, but maybe you can break it down for some of our audience. When we talk about AI, what are we talking about, and where do you see that we're at right now?
Yeah, I was actually just thinking about that too. Like the past year, it's almost too wide, right? Like so much has changed. I would say a year ago, I was just starting to use ChatGPT, like more, more from a single user personal way. And now I see it's really becoming an everyday part of what we're doing at work. And I think the big learning for me at Supio is, what is AI good at and what is AI not good at? And how do we sort of lean into that? I heard someone describe this the other day as taking those mechanical tasks and making them mechanical. So using AI to do those things that it's good at, like some logic, some reasoning. With the new model that came out last week, calling it chain of thought, it's really able to do some of these complex tasks that you would ask a paralegal to do, or you would ask an assistant to do, and really getting used to just trying it for those things. I think the main thing that I see with our users and being in product is, I'm just encouraging people to ask questions to see if using chat against your document set can get the information that you're looking for, finding inconsistencies in data, being able to see what is this missing, or do we have missing receipts, do we have missing records. It's actually really good at finding those things. It's really good at comparing data, and it's really good at sort of helping you hone in on the thing that you need out of the 20 pages, hundreds of pages. So it's really making that a lot simpler, and watching that happen and watching that click for people. We're also watching people learn how to use these tools better, learning how to phrase questions, refine questions. I see this when I'm looking through logs of what people are doing, and it's really, really great just to really see like how people are teaching themselves AI and how they're using tools like Supio to do that.
Yeah, and let's go to our first poll question. In which areas of the legal profession do you think AI has the most potential to make an impact? And Pam, I want to thank you and Supio. You're one of our supporters and sponsors here today, and helping and donating the money to the Denise House, the women's shelter. So I deeply appreciate your company's contribution and support of this cause, which is a really important local shelter for women who are suffering from their victims of domestic violence. So thank you again for your support today.
Thank you.
Okay, so there you go. There's a recap of, we could spend an hour just doing a recap, but we've got a lot to cover off. Let's see what our audience is thinking in terms of impact. Legal research, almost 70%. Document review, we're seeing a lot of that in just about every area of law now. 57%. Contract analysis, Monica talked a bit about that already. 43%. Predictive analysis, 31%. I use this part constantly. I'll have an argument that I'm going to go to motions court with, and I'll ask AI, what are my blind spots? What am I not seeing? What's opposing counsel going to argue contrary to this? And it almost always comes up with 3 or 4 points that are relevant. They may not be the strongest points, but they're things that I may have overlooked. So it's really super powerful tool for that. Client communication, we're seeing that more often. Screening emails, screening reviews, responding to reviews, and other. You can put that in the Q&A box, and we'll take a look at the other. All right, well, document prep. This is a huge part of what lawyers do day in and day out. Lots of discussion about how we're going to bill for this. We're taking our financial statement in the family law proceeding, which may have taken a law clerk or a lawyer 2.5 hours, and we're getting it down to 6-7 minutes, which is incredible efficiency. Pam, let's walk through document prep and what you're seeing and the kind of services your company is offering.
Yeah, with what we're offering, I think what we really focus on doing is taking structured or unstructured data and turning that into structured data. So how do we sort of hone in on the parts of a document that you need to extract to create that disclosure summary, to create all the documents that you need down the line, and do that really quickly. So pouring over lots of different formats of receipts or expenses, all of your intake data, instead of just putting that, maybe merging that into another document, we're also creating like basically a data repository for you to keep using that data so that you can chat against that data, so that you can help that in drafting new documents. I think that if you get that information out of sort of those, I would call them dead data sources, and into active data sources, all of that then is there for you to use for the entire case, for you to ask those certain questions, Russell, that you were just talking about, but also to draft the documents down the line. And that's what we really are focused on at Supio right now. How can we help you not only just extract that information, but then action on it, to be creating those next documents, to be creating those briefs, to help you summarize the case. Every single thing that you need to do after you do the data collection to make sure that you have a case and verify that case. How can we also help you with all of those downstream processes and make that really, really, really simple? The advancements that are coming out are constantly improving, and we just see the ability to basically draft every single document type that you need, even helping with client communication, helping with keeping your executive team at the firm in the loop. Everything that you need, you can do with our drafting software, because we have such rich data in the beginning that we're helping you collect and sort through and really get to the bottom of.
Yeah, I really like the intake forms. It saves me about 20 minutes in terms of traditional information I would get from the clients already ready for me. I can start thinking about their problems. They tell me they have an outstanding court order or separation agreement. I'll ask for that even before the first meeting, where ordinarily I would find out about that halfway through the meeting, and we may have to reschedule it because they don't have it handy. So that's effective. And I really like the financial briefs that Supio is producing, with the hyperlinks to the briefs, all assembled in a digital format. My law clerks find that a super effective way to process the information.
Yeah,
So,
absolutely.
great work. Daphne, marketing, what are you seeing at your end? You got some surprises for us tonight or what?
I do. Yeah, so similar to how it's helping the lawyers and clerks, it's also increasing efficiency in the marketing department as well. So one of the ways that it does this is with image generation. So we use a tool called Midjourney to create images that don't exist otherwise through Discord, which is very cool. The prompts can be very specific down to the image dimensions, what kind of camera model the photo would have been taken with, and different artistic styles. So one example of this is we have a blog, familyllb.com, where we cover different family law cases. And we did a story on Trudeau. And rather than paying to use an image of Trudeau,
for the non-Canadians, Trudeau's our prime minister, sort of like your president, just to let you know.
Yes. So we were able to generate an image that kind of looks like it was taken from paparazzi of Trudeau and his now, I believe, ex-wife. And another one that we were able to do is very popular Taylor Swift. This actually is not her. This image was also generated by AI. So just a couple of really cool uses of the tool, and it can get very accurate. So
and without AI, we would have to get copyrighted images, which creates a whole new problem, right?
Absolutely, yeah. We would have to get the rights to them and pay for them as well. Another way that AI helps with editing is if you have an image of something and it's not large enough to post on social media, or the dimensions aren't right, whatever the case, you can use Photoshop, or I believe even Canva now, to create the rest of the image that wasn't there otherwise. So super cool tools. Another one is, this is the surprise that Russ has been hinting at, is the video avatars are very cool. So we, maybe I'll just show the video. We'll just show the video and I'll talk about it after.
Thank you for joining our third annual Family Law Now Live virtual summit. I'm Russell's avatar. AI enables me to communicate with clients throughout the world in any language. Merci d'avoir participé à notre troisième sommet virtuel annuel sur le droit de la famille, désormais en direkt. Je suis l'Avatar de Russell. AI ermöglicht es mir, mit Kunden auf der ganzen Welt in jeder Sprache zu kommunizieren. Gangsienin kanjia woman de disanjianian dujiating pafengui, وشيلا ساي إير توكسيانग. أقدر أتكلم العربية. ये मुझे दुनिया भर के ग्राहकों के साथ किसी भी भाषा में संवाद कराने की अनुमति देता है. We hope you've enjoyed the summit so far.
That avatar looks a little angry. I don't know.
Yeah, the video technology, I'm not sure it's quite believable yet. We're getting there. But what I find really cool is the voice cloning. I think the audio was pretty on point. It does sound like you. So very cool, and also probably brings up some ethical issues and security concerns as well, which I won't dive
Yeah,
into
for sure.
today. Yeah, exactly.
Yeah, so if I get a call from you now and I don't trust the content, I'll know exactly what happened.
Only, yeah,
Go
don't-
ahead. I'm really more of a listener.
Here, Siri's going off on my end. The AI is taking over here.
Okay, I'll also just talk briefly about chatbots. So on your website, it's you're able to use AI now to talk to clients, and you are able to also put in parameters. So do this, don't do this, so that you are able to still kind of control the conversation and what your chatbot is saying. You can put in the purpose, the intention, or the end goal of the conversation. So it's really customizable, which is really cool for helping clients when any time of day, really. And then lastly, I'll just touch on social media briefly. So various different platforms are embracing AI and putting in their own features, their own tools, their own optimize this description, make it better using AI. And you can also use AI to create captions and find hashtags that are effective. So there's a ton of uses, and I could go on, but I think I'll leave it there for now.
It's really endless what you can do with AI and marketing calendars, you name it, coming up with ideas. Really super competitive marketing with it, and it's all tailored towards search and the algorithms. So very powerful tool. Thank you for sharing those, Daphne. Let's go to our next poll question. Have you used AI powered tools for research? If so, how would you rate their effectiveness? And just before we wait, we'll give everybody a moment to answer this. Pam or Monica, any comments about AI and marketing?
Yeah, we've been using it a lot for blog posts, like kind of a first draft of a blog post. So, a marketing person might talk to a lawyer, has gotten some points from the lawyer, puts that into ChatGPT or into one of the other kind of solutions, and then generates that first draft, sends it over to the lawyer. They can review it. It's really changed how we are kind of generating some of the materials. Before we would have somebody dedicated to kind of writing for us. So yeah, it changes things a lot.
I'm not finding it's replacing the marketing department, but it's making them a lot more efficient, and we can produce a lot more content. Traditionally, we would have a research lawyer and a lawyer do the first drafts, and now you're saving all that time. Pam, what are you seeing at your end?
I like to use it for the prompt engineering and to really give it that context. I think I work with a lot of very technical people, with engineers and product managers, and we have a hard time sometimes explaining features to our audience. And we can say, take what I'm giving you and explain this to a legal professional, explain this to a paralegal, and we can really frame that in a way that takes out the engineering speak and really puts that in a context that they understand. And that is so incredibly powerful. Same thing, it's not replacing the need for people, it's just helping us achieve what we're trying to achieve faster and giving us a lot of new ideas to consider.
Yeah, all right, so let's see what our audience thinks. Thank you, Pam. Not very effective at the top end of these poll results. Haven't used it at all. See, about 70%. That's surprising, actually, because a lot of the research providers in Canada are already using, you may be using it, you don't even know it. A lot of their software has it built into the back end. Monica, what we need to know about legal research and AI?
Well, it's gonna change very soon. I mean, it's already changing. So what's just recently this past summer, Westlaw, I mean, Thomson Reuters has integrated into CoCounsel Westlaw. So if you can do, for example, legal research memos, you can generate them through CoCounsel, and it's going to be pulling in cases from Westlaw. So, one of the concerns I think that lawyers have is about hallucinations. So there's those famous case like in New York where the lawyer used ChatGPT for legal research and it made up case citations. And then there was a lawyer in BC again who used ChatGPT and again, there was these cases that were found in their materials that were made up. So with using a platform like CoCounsel or even Lexis is now, I don't know if they've launched it or I know that they're going to very soon, something called Lexis plus AI, and that's their version of CoCounsel, and it also has generative AI, and it also is linking to their repository of cases. And so this is going to change the paradigm of how we do legal research because, I remember and probably you do too, Russell, where, you would do these, like, this is what I would do as an articling student is these legal research memos, right? And it's like, what's the issues? What's the conclusion? What's the facts? What's the
You
law?
remember there used to be libraries and we'd pull a book off the shelf,
Yes, I do remember
photocopy
that.
all the cases.
Yes. And that was a faster way of like doing legal research than, trying to search for something on these platforms. So not only is AI kind of being incorporated into Westlaw and Canley and all those platforms, but now they're layering on top of that the generative AI, and that's going to allow you to do kind of this, I would say, like level 2 kind of activity. So the legal research memo, kind of litigation arguments. So there's another tool that we've been looking at called Alexi. It's a Canadian company as well. They've raised a lot of money recently, and that is like basically it generates instant memos. So it generates an instant legal research memo. You can then also, it has an arguments feature. You can like ask it a question and say, what are the arguments that the other side could come up with, and that kind of ideation is really powerful. Being able to ask a tool and say, hey, can you come up with some ideas of arguments that the other side is going to come up with, or ideas or things that I haven't thought about. And so the tools are kind of, can be used in that way as well. So this is, it's just coming out. One thing to note about pricing. So with CoCounsel and with Lexis plus AI, there is going to be, you have to have a subscription for Westlaw or Lexis Plus, and then you buy on top of it this CoCounsel or this Lexis plus AI that comes layered on top of it. So it's actually it's an additional cost, and so it can get a little bit pricey. So I mean that's one thing that I'm noticing with these tools is that the costs are quite high. And I have heard anecdotally, I haven't seen any announcement, but supposedly Canley is also working on something, but it's not clear when that would come out.
Yeah. The Avianca Air case in the US was big. We've got some articles in the actual case Daphne's going to put into the chat. The biggest fear initially is this hallucinating AI, right? They're just making up cases as they go along. And I'm concerned, you hear about these tools that we're describing, lawyers of our generation, Monica, we can second guess what we're getting.
Yeah.
New lawyers, they're not,
Yeah.
they haven't developed that muscle skill or that resilience, right? They're just,
Yeah.
they don't have that.
Well,
Maybe they do, they don't have that ability to say, I'm going to question this and double check and know how to do the proper research.
Yeah. So one thing that's with all of these solutions that I mentioned, Alexei, Lexis Plus AI, CoCounsel, they are going to give you the link to the case.
Yeah.
So you can go and you can click on the link and you can verify that this is actually a real link. So Alexei has links to Canly, Lexis Plus AI has links to their repository of cases. And Lexis has said that they are guaranteeing that the links are actual cases. So to kind of address the concern that you're talking about, Russell.
Yeah. But that's still your reputation, right? You can't.
Yeah, no, you have to double check
Going
for
to motions
sure.
court and saying, "Oh yeah, my law clerk prepared that." The judge has no patience for that.
Yeah.
And you're seeing judges in the U.S. Requiring lawyers to certify, what's been prepared by AI and what hasn't, and the court's really taking this seriously. Pam, what are you seeing on the research side?
Yeah, I think a bunch of things kind of come up through that. We have a strong focus on citations and references with everything that we do within our platform for that exact same reason. I always say trust but verify, and that's such an important step that can't be skipped. The citation will point you to exactly the document that either you uploaded or is a part of your case. You need to be checking those links. I mean, yes, if you know that that's absolutely factual because you've already read that, that's great. But everything else has those citations, and we're making that front and center in our platform so that you can always make sure that this was referenced. This is a true part of the case. There's no hallucination going on. And I also call those guardrails, like really understanding where AI is good and where AI is not so good, and providing that feedback. There's a lot of tools that you're using. Maybe there's a thumbs up, there's a thumbs down, there's feedback. I would say, as someone who builds product, use that. If you're getting something that doesn't make sense, that you're not understanding, make sure that feedback is getting back to those products and is really making its way back to these tools, because we're relying upon that, and we're also relying upon our users to still take those measures to validate everything that they're getting.
So risk management, Pam, what safeguards are you putting in place? What are you seeing? What are best practices?
Yeah, I was going to say this one really flows into the next one quite nicely. Along with those guardrails that we're talking about, I think the other thing to really keep in mind is with the tools that you're using, are these closed models? What sorts of data are you sharing with AI? Everything that we do at Supio is in a closed model. It's contained within your account, your platform, even case between case that's contained or that's closed, because we don't want certain facts from this case making its way over here. And so I would just say that you need to really ask a lot of those questions when you're evaluating these tools, how it's built, if there's data sharing, even how the own products are using that data or anonymizing it to train and make these models better over time. So again, just a lot of questions that you need to be asking, and a lot of measures that we're taking to really keep data separate and distinct, and really private. And I think that that's a really important piece of this.
Yeah, 100%. Monica, risk management?
Yeah, so one of the things, I was saying before, there's a lot of new solutions, and they're being built on GPT, like OpenAI's GPT, so generative AI. So those models, or Anthropic, Claude, and what I'm seeing is kind of companies, a lot of legal tech companies moving away from building their own AI models. So they're relying on these third-party AI models. So what you kind of need to look at when you're looking at these solutions is you need to ask them, how is the data? Where is the data going in the solution? So, not only do you need to look at how does the legal tech vendor treat your data, because they're saving the data in their servers, but they're also then using these third-party models. So you need to understand what is the terms of service between those third-party providers, and how is the data kind of going in? Is it being encrypted as it goes into these models? Is it do they have access to that data? Do they retain that data? Are they using it for training of their models? So these are the things that you kind of have to think about with, I think, with the, new generative AI. I think the other thing is that we're seeing is that this AI, it's accelerating kind of technology use and adoption, and it's like we're becoming more users of tech in a way. And so security, privacy of data, these are big things that all law firms need to be thinking about. And we need to be thinking about the tech is it's a lot more complex, so it's sometimes harder to understand what's going on. And then the people, there's a lot of bad actors, and they've become a lot more sophisticated. So I think this like data security, cybersecurity, that's something that we're paying a lot of attention to in our firm. But I think it's just, it's something that I will see. I think we're going to see a lot more firms kind of paying more attention to it, becoming more sophisticated on how they're going to handle that.
Yeah, I agree. So this poll question is, what is your biggest concern about the integration of AI in the legal profession? We'll give everybody just a second to complete their answers. I just noticed, the Apple iPhone came out last week, 2 weeks ago, and it's got AI built into it, and Apple's saying they've got their own closed data system. Pretty incredible, right? Like I'm an Apple fan, but you've got to wonder how powerful is this tool going to be once it comes out, if it's at your fingertips. All right, let's see what our audience is thinking. Thank you, Daphne, for putting that poll up. All right, what is your biggest concern? So job displacement, 10%, ethical implications, 18%, data privacy, yes, it's always a big one, especially with lawyers, our duty to maintain our clients, solicitor client privilege is 31%. Accuracy and reliability, 21%. I think if we ran that poll 6 months ago, it probably would be over 50. So we're seeing some improvements. Cost implementation, 13% other. Just put that in the Q&A box. So thank you for submitting your poll answers in. Now we're going to talk about the rules of professional conduct. Daphne's going to throw up a few rules on the screen here. And I'm mindful of our time. We're probably going to go to about 5:15, which would be 45 minutes, so we're still good. So for Ontario lawyers, these are the rules you want to be mindful of. There's a number of other ones. These are the ones that jump out to me. I'm just going to review a few of them. Most of these rules are consistent throughout Canada, most of the US, same principles and ethical requirements. Competence and duty to provide efficient legal services. So I think we have a duty to start adapting this technology, especially if it's going to be a cost savings to our client and it's going to make us more efficient. 6.1 is a big one, supervision. So business owners and law firm partners and managers need to be supervising their staff, their law students and articling students, and their associate lawyers, making sure no corners are being cut and all these staff members are using it properly. 3.3 is always a big one, confidentiality and privilege, protecting clients' data. We heard Pam talking about a closed system. You want to question what security measures are putting in place when you're using this program. Are you revealing confidential information publicly through AI if you're punching your client's data in? Huge concern. 2.1, responsibility to the profession. So we want to maintain the integrity of the profession, and all lawyers have that duty. So just look at Avianca, the storm that caused for that particular law firm and the legal profession. Just one mistake on a factum could really reflect poorly on our profession. 3.6, fees. This is always a difficult one. They need to be fair and reasonable. So that financial statement that used to take your law clerk 3 hours to prepare, you might have spent 20 minutes reviewing it, might now be down to 6 or 10 minutes. It's that efficient. So you're not going to be able to bill that 3 hours anymore. It's contrary to your rules of professional conduct. So my prediction is we're probably going to see a lot of services move towards block fees. Now that financial statement is going to be $750. How we prepare it and how we do it efficiently, that's our responsibility, but you're agreeing to pay me this fixed amount for this particular service. It's not much different than real estate lawyers and other legal service providers who do block fees. So I think the family bar may start moving towards that. I know Brian Galbraith is a big fan of block fees, and he's been advocating it for years, and maybe AI will move us in that direction. Any thoughts about these rules or comments, Monica?
I think that your comment about the block fees is interesting. I've seen a lot of discussion in other kind of conferences or discussion panels that I've been on about moving towards fixed fees, like AI kind of changing the paradigm there. And I think it's still an unknown, but what I do think is happening is I think there's maybe some more certainty. I think one of the things with legal is that it's sometimes difficult to estimate what the fixed fees would be. With AI, it seems that there's more certainty around how long something is going to take. So it would be interesting to see. I think there's that white paper that you put into the chat. I encourage everybody to look at it. It's kind of the Law Society setting out what how they think we should be approaching it. It's got this checklist, and they do say, we should be using the AI, but we should be using it responsibly.
Yeah, for sure. And the back end of all that is, how do you pay your staff, right? If somebody spends, the law clerk spends 20 minutes and the lawyer spends 10 minutes, how are they being compensated for their time? You're going to have enough work to keep them busy if we're docketing a 0.1 when ordinarily that'd be half their morning preparing that financial statement. So I think it's going to make lawyers a lot more efficient, for sure. It's not going to replace us, but you need to get on top of this for sure. Thank you. New advances in AI, Pam. What do you got, and what do you got for us?
I don't know if they're new, but maybe new to the legal profession. I just think that with, again, constantly changing models and constantly changing, honestly, even confidence in the system, with more and more people being willing to try these tools, we're just making sure that we're providing as much value as we possibly can, starting from extracting data, making it easier to use your data, but now also making it easier to draft documents, making it easier to create summaries, to understand where you are in a case, to understand if you're missing information in a case. It's like every single thing that you'd be sort of tasking to a paralegal, you can do that automatically. And then the next thing that we're looking at is really how to provide some of those insights. So we're encouraging you to talk to your data and talk to your documents like you would anyone at your law firm. But how could we do some of that for you automatically? How could we pull out what could be the next step? How could we make some of those suggestions about what to do next? I, again, heard one of our customers talk about how we're just leveling the playing field. They had varying levels of paralegals, very, very advanced, very senior, and almost completely new, just starting their career. But it's helping them level up, helping them train. There's so many uses in it that I wouldn't have even foreseen with our software that I keep hearing our customers tell me about, which, as someone who's building product, that's something I absolutely love when we find a new use case. But it's helping them get their paralegals up to speed faster, helping them understand where to dig in on the case, and not having to have 10 years of expertise to do that. So I'm really excited about the way that I see that shaping my software's future, but also every other piece of technology out there. And it's building my confidence in using AI in my daily life too. So I think it's a really high bar for what we're producing, and I hope we keep building products that delight our customers.
Is CPO still producing financial statements?
Yes. Yep. We're still producing financial statements.
We had an audience question about that. Monica, what do you think? New advances, what are you seeing?
It's like, what am I not seeing? It's like there's advances in like every area, and we talked about marketing. We're
like
actually
a fire hose, right?
Yeah, exactly. It's like, oh my God, there's so much new tech. Keeping up with it is actually a challenge. What I think what I think for a lawyer, kind of looking at the market and trying to understand what they should do, how they should tackle it. I think they should look at their own, like how comfortable they with using or adopting the legal tech. If they're not, I would start with like marketing and sales. Like we're piloting some solutions around BD and sales and stuff like that. So there's a lot of like tech that can be used for that. MS Copilot. We've been doing a pilot with MS Copilot. MS Copilot is amazing. It's got a lot of really interesting functionality. For example, I can input like a um, template of what I want a presentation to be, and it will generate that first draft of a presentation. And it's got other kind of functionality, like helping you generate emails for when you're doing your emails, it's kind of baked into Outlook. You want to do a form, you can use MS Copilot to like help you generate that kind of MS form, Microsoft form. So that I think is really useful. I just recently was playing around with a new tool by Google called Notebook LM. And this is like a free kind of solution, but some of the examples that I've seen is like people uploading a book. Like maybe they wrote a book and they want to create a podcast from the book. So they upload the book and then they have this Notebook LM generate the podcast for them. So I think there's a lot of like ways we can use the software that if we're not comfortable using it in our legal practice, you can start there. But I would just start. Like there's just so much out there, and I would just start.
I was gonna say something really similar of just try it, right? If you have ideas, just try it, because I'm even surprised with what some of the things it can do. But within that, because people are hungry to try this, make sure there are tools that you're sanctioning at your firm. That's how you want people to be using AI, that there's not data leakage, that they're not trying this on their own with different tools. And so I would say that people are craving that. And I think that that's an exciting part of it too, of how staff are kind of pushing their firms to be prepared for this.
Yeah, exactly. And there's a lot of practical, where we're going to find all the time to consume all this content people are producing, right? I guess we'll get the AI to listen to the podcast for us, but lots of practical tools, right? Slack AI can, summarize your team's messages going back 3-4 years. Zoom AI, there's lots of AI modules that go to Zoom. So if we're having a collaborative meeting, it'll take notes, it'll break it down into chapters, it'll have to-dos for specific members. Will have sentiment analysis, who participated, what was the pace of the meeting. Super insightful. You can use all that for your intake too, to monitor how they're dealing with new clients. So really, really helpful. So let's go to our next poll question. How do you see AI transforming the legal profession in the next 5 years? And I guess, Daphne, you're seeing constant new ways to use marketing tools with AI.
I am, yeah, similar. I love the fire hose analogy. I think that's so accurate. There's just so many tools, and all the companies and everyone is scrambling to try to stay ahead of the curve. But yeah, it's so exciting, and I'm not sure if I launched the right poll here. I just want to make sure.
No, this is the wrong one. We want to go to poll 5.
Okay, sorry guys.
Yeah. How do you see AI transforming the legal profession in the next 5 years? Sorry, Daphne, I thought I messaged that to you.
Oh, my bad. I might have missed it.
No worries. All right. So dramatic transformation, moderate changes, minimal effect, no impact at all. We'll give everybody a chance, but let's go into a look ahead and final thoughts, and we're going to end with the poll results. Hopefully it's not too dreary. Final thoughts. Let's see who we're going to pick on. Daphne, you want to go first?
Yeah, sure. So I guess my takeaway or tip for anyone who is just new at this and isn't comfortable, doesn't know where to start. I personally love Gemini by Google. If you just open the Google app on your phone and click the little star, you can communicate with it. And I find it extremely helpful. And I use it more often than I Google things now because it provides an answer. So I would say check that out. It's free and I love it personally. And looking ahead, I would just say, I think the power of human connection is so important and isn't going anywhere. I think human connection cannot be replaced by AI by any means. And so in terms of marketing and social media, I think that influencers will always be prevalent. And yeah, those are my takeaways.
Monica, thoughts?
I feel like the last question kind of was my, kind of final thought, but, kind of trying the tools. I'm working on this course with Osgood PD. It's about prompting. And I think that's going to be very helpful for lawyers, but, trying to understand how to make the most out of these tools. And so there are other kind of prompting courses out there, but, kind of just joining one of those and developing some of the skills around it, I think you will really benefit. Like, get started now, start develop those skills. You will really benefit for it going down the road.
Yeah. And I see that Supio just increased their donation, and now we're at 12,115 for the Denise House. Thank you so much, Pam. That was very generous of your company to be so supportive of this cause.
Thank you. I'll make sure I let everyone know, but thank you, Jerry, for doing that. I'm sure that was happening behind the scenes.
So your final thoughts, Pam?
Yeah, I was gonna, it's Daphne and Monica said it very well. It's just try it. This is going to be a part of our daily lives, and the sooner that we sort of lean in and realize where it can be useful and maybe where it can't, I think that that's a really strong thing to figure out. So anytime you think, oh, this is repeatable, this is mechanical, that's a good use case. Refine, talk to it like you would a person. Like, that's one of my learnings too. I mean, you can strip out all the nice words. You don't have to say please and thank you to the AI, but you get something back. Can you make this shorter? Or I was looking for this in 2 bullet points. It's really good at doing those types of tasks. So try, refine. The prompt engineering suggestion is great, and just keep learning.
And give it examples. It learns, right? No,
it does.
This is what I'm looking for. Yeah. Super insightful. I would say give it a try, right? Everybody's scared a little bit of this technology. Our results, 58% dramatic transformation, 37% moderate change. Change is coming, right? This train's coming down the track. You might as well get on it. When Daphne and I first went to a conference about a year and a half ago, the theme was, this is when we had all the headlines, right? AI is going to wipe out the legal profession. AI is going to kill everybody. They're really, we have screenshots of the news articles. It's really outrageous, some of the articles that were coming out. So we're not going to get replaced by AI, the legal profession, but somebody using AI may replace you because they're more efficient at delivering legal services. It's going to make our services more accessible to the public, and it's going to be hopefully reduce the costs for the public. That's some of the biggest complaints we received at the family law bar, at least prior to the pandemic. It was too expensive and it took too long. And I think AI has a chance to make us more efficient. So super, super great insight. Thank you, Daphne, Pam, Monica, great discussion tonight. And we are going to wrap this up. I think Shannon's going to come back with a few updates, and look at that. Amazing. Welcome back, Shannon.
Magic. Thank you. And thank you so much to Pam and Monica for joining Daphne and Russ for this discussion. So interesting too. At the pace that everything's moving, we did this presentation or a similar presentation a few months ago with Jerry from Supio and another lawyer. And just to hear fresh perspectives, new perspectives, but also just how quickly things have been advancing, and there's a lot of new things to learn. So thank you so much for sharing your insights. And I can't believe it's already over. We have been looking forward to this event for quite a long time at our firm, and it was so nice to have all of our speakers come and have such a great turnout from the audience. So I just want to thank everyone for their contributions and participation. And we're so happy to be able to use this and share this as an opportunity for the Denise House to help build their new shelter. So thank you so much, everyone. Anything else that you want to touch base about?
I want to thank our audience for playing full out, participating in the poll, sending in the questions and answers, donating to the Denise House, everybody watching on YouTube Live. Really appreciate everybody participating and providing us with your support. If you want to join us for next year's summer, there'll be a speaker application you can fill out that will follow up with, and we're going to get show notes and surveys after this, right, Shannon?
Yes, that's right. So the survey, once you log off the webinar, you can share your feedback there. If you have a moment, we love to hear from you. As Russ mentioned, we always like to look through it, and it helps us guide, whether there's new topics or things that we can do to improve for our future events. So we'd love to hear from you, and you can do that there. And then we'll also be sending a follow-up email tomorrow with show notes from each of the presentations, so you can do a deeper dive into the different topics that were covered throughout the event.
And a special thanks to our sponsors, CPO and Bridgeport North, Tim. And there's a lot of people behind the scenes you're not seeing on the screen. Sarah A, Nicole R, Daphne, Shannon, you did a fantastic job organizing this. So thank you everybody for making it such a great success, and have a great evening.
Thanks, everyone. Take care.